of Tobago. And so almost every day that student year, when I opened my book, I saw the courthouse of Tobago. Now, why was the picture there? Well, it's now more than 200 years since the case of Buchanan against Rucker was decided. Do any of you remember that case? It's a case in which a judgment made in Tobago against a foreign non-Tobagoan defendant was sought to be enforced in the English courts. Enforcement was resisted on the basis that notice had been given simply by nailing a piece of paper on the door of that courthouse, that same courthouse that I looked at every time I opened my textbook. And as Professor Reese asked us, I remember arms outstretched, and quoting the English judge who denied recognition of the notice, "Can Tobago pass a law to bind the rights of the whole world?" That was the question we were asked. Buchanan was a landmark case. And for me, therefore, this is a spiritual journey. But for all of us, the Buchanan case should be a reminder of the long-standing juridical ties, the legacy that binds lawyers in Trinidad and Tobago with lawyers in London. If nothing else, globalization and technology make those ties even more relevant today. Today, we will hear about recent jurisprudence, I'm sure cases, many of them much more recent than Buchanan, and we'll hear about the relevant experience of our speakers. Relevant as we position ourselves as a profession to be helpful to our clients as best we can be, so that they can meet the challenges that confront them. Globalization and technology are our opportunities, and they will, however, add to the scale of the test that's before us. The facts are always important, and the facts are changing. But let's not put our heads in the sand about those changing facts and circumstances. Let's put our heads together. Let's put our heads together and use this opportunity that we have today to strengthen the collaborations that will help us serve those clients and maybe even give competitive advantage. In any event, I just wanted to welcome you to the conference. We welcome the opportunity of it. And now let me pass the microphone back to Mr. Besesser, who will chair the morning session. If you stay the course, if you're here this afternoon, you're going to hear from me again, and I hope to see you when I come back after lunch. Thanks very much.
Tobago Legal Network, the TTLN. Initials I want you to become familiar with. You will be hearing more from the TTLN, but it is in fact a foundation which was incorporated on the 28th of April this year. Its principal mandate, ladies and gentlemen, is to promote and provide continuing legal education to members of the legal profession and persons who are interested in the law, as well as being a forum for scholarly debate on important legal issues and, of course, contemporary public events in Trinidad and Tobago. The TTLN is a non-partisan organization. It is not aligned to any political party or philosophy, save that it encourages and holds very dear to its heart strict adherence to the rule of law and a citizen's right to due process. The TTLN's president is Mr. Ramesh Maharaj, Senior Counsel, and I serve as its Secretary Director. Mrs. Vijaya Maharaj and Mrs. Nyala Badal also serve as directors. The TTLN was formally launched last night at a gala ceremony at the Courtyard Marriott Hotel. And in fact, today, consistent with its mandate, is presenting its inaugural law conference, which, as I've indicated, is titled The Recent Contribution of the Caribbean to the Common and Constitutional Law. And of course, we are convening in the Aubrey Fraser Theatre, which at Huberding Law School. And let me pause to acknowledge with our gratitude the law school for hosting us. It's a very important event, and I'm very happy that we have many students and members of faculty in our audience. The law conference is hosted, or in fact co-hosted by various chambers, including RLM and Company, Dalton's, 3 Hare Court from the United Kingdom, and my own chambers. Many of you would have received your packages and you would have had an opportunity, albeit briefly, to look at the program. But if you have, you will have seen that we are, in fact, presenting papers, several of them, for instance, Sir Fenton Ramsahoye on the justice trajectory post-independence, an intriguing title, and I'm sure, like myself, you're keen to hear from him in relation to that. Mr. Ramesh Maharaj is presenting on the Supreme Court as the guardian of the Constitution. Mr. Peter Knox, QC, who is head of 3 Hare Court, is presenting on an overview of recent cases from the Caribbean. Mr. James Guthrie, QC, is presenting on judicial bias. Later this afternoon, Mr. John Jeremie, Senior Counsel, is presenting on parliamentary privilege. And also this afternoon, Mr. Thomas Rowe, QC, is also presenting on dissenting judgments. There are other contributions, and in fact, this afternoon, I am really looking forward to our panel discussion, which concludes our conference. It's on at about 2:30 this afternoon. And it's a panel discussion on contributions of the common law in recent events. But having said that, its chair, Mr. Simon Davenport, QC, has invited me to remind you that he will be considering on the panel, which comprises persons from both the United Kingdom Bar as well as, of course, our Commonwealth Bar as panelists, to listen to and perhaps offer views on contemporary events in Trinidad and Tobago, not matters just purely related to the papers that you are presenting or are being presented. So it's not going to be a fairly dry exposition. It's going to be very live, dynamic, and I hope fairly provocative as well. So that's our morsels for this afternoon. Good. Our first paper is being presented by Professor Satvinder Juss, and it is entitled Legitimate Expectations. Satvinder is, in fact, a member of 3 Hare Court, but I was chatting with him a little earlier, and he gave me an intriguing background. He was born in colonial East Africa. It's now called Tanzania. And he had an idyllic childhood in the foothills of Mount Kilimanjaro. He was making the point that his family emigrated in 1968 to the United Kingdom because of a lot of political strife. And in fact, those events have shaped his contribution, which is really relating to constitutional and public law, and fired his zeal and his zest for the rule of law. His particular expertise is in comparative constitutional law and public administrative law, and his practice includes, of course, judicial reviews, as well as hearings in the High Court and the Court of Appeal. He also has considerable experience in immigration and refugee law and various fields of human rights practice, from employment law to education law. And he appears regularly in the High Court and the Court of Appeal, as well as in the Privy Council. He sits as a deputy judge of the Upper Tribunal hearing immigration and asylum cases, and is a former human rights fellow from Harvard University and a Harkness Fellow. He is a professor and the director of the MA course in International Peace and Security at the Law School at King's College in London, and specializes in international refugee law and in human rights, public law, and comparative law cases. In October 2012, Satvinder was appointed to the panel of the Welsh Government's Panel of Counsel to undertake public law and employment work. He was appointed to the panel as counsel and serving the Equality and Human Rights Commission with effect from the 2nd of March 2015 for a term of 4 years. He's also on the panel of arbitrators of the Indian Council of Arbitration, of which he's, of course, a life member. He has written widely in various journals in the UK and in the USA, and is author of 5 books, including International Migration and Global Justice, and he's in fact currently has accepted briefs from many countries, including the governments of Trinidad and Tobago, Belize, and Bermuda. Ladies and gentlemen, please join me in welcoming Professor Satvinder Juss, who will now present his paper entitled Legitimate Expectations.
And warm words. Not sure if you want to hear anything further from me, given that subversive background that's just been outlined. But even so, recently there was discussion on the meaning of words used in common parlance, and a panel member was asked to distinguish between the meaning of to complete and to finish. He confessed to some difficulty, given that both Roger's Thesaurus and the shorter Oxford English Dictionary seemed to imply that both words had exactly the same meaning, to which someone from the audience quipped to say that there was a distinction. If one married the right person, one was complete, and if one married the wrong person, one was finished. To which one might add that if the right person catches you with the wrong person, then you're completely finished. Take heed, all of those you who were partying late last night. I mention that simply because I have 20 minutes in which to cover a very difficult area, vast area, and I propose to do so in the following way. Firstly, to tell you why legitimate expectations is such a crucial area. It is, as Ramesh told me even yesterday, the most important explosive area of public law in Trinidad. There are, an entire spate of cases coming through that have to be resolved, and that's one reason. The second reason is this, that the doctrine itself is hugely problematic. Lord Brown, in a 2020 case, to which I hope I shall have time to take you through, referred to it as a little more than a mechanism to dispose palm tree justice. He picked that up from an academic article, someone no doubt with a whiff of envy, given that there are no palm trees back in England. Begrudge you rather for having yours. But in any event, that just shows how difficult the area is. What I propose to do, therefore, is to simply take you firstly in just 5 or 10 minutes with the basic nuts and bolts of legitimate expectations, and just to give an understanding of how clients, practitioners, others listening on the radio would be able to use this very difficult doctrine, judge-made doctrine, at the heart of the English common law, entirely created by the judiciary. And secondly, then also, once I've gone through that, to take you through maybe one or two time-permitting cases to see exactly how this has panned out in real life. And Trinidad produces, a rich tapestry of such case law. There's Paponet, there's the Clico case, there are other cases coming through. So really, it's right at the forefront of developing the jurisprudence here. So let me then begin, firstly, with the nuts and bolts. Legitimate expectation is a judge-made doctrine which protects the citizen from changes of mind, changes of policy by public bodies. The basis of the court's protection is said to be fairness rather than any private or legal right per se. The thing to watch out for is this, that the conduct of the authority has to be so unfair as to mount to an abuse of power. Unless you can show that there is a real abuse of power, you get nowhere. So that's the critical thing to bear in mind. Let's then look at how this would really work out. Well, I have a dozen points on that. Let's begin with the first one. Firstly, the statement. Your statement from the government body can go to two issues. One, either creating a procedural legitimate expectation, which is the older of the two. That has a much more difficult, much less difficult basis, or a substantive legitimate expectation. Let me deal with the easy one, the procedural. The second point is this, that the procedural legitimate expectation is to do with an interest or the continuance or acquisition of a benefit where the law requires the body in question to adopt a fair procedure before they reach the decision in question. So really, it's what they must do. I mean, procedures, as you know, are very, very important. They are gateways to justice. They really are the steps that enable you to acquire the remedy which you're after. The procedure may also be based upon an expectation that a particular procedure would be followed because it has been followed in the past. or promised for in the future. So it can be either past in terms of established practice or future in terms of what you want the government to do before they reach the decision in question. Thirdly, let's then look at substantive legitimate expectations. Well, this, as I say, is much, much more difficult, and what this requires is this. It says that for a public body in question, there must be a representation which is, quote, clear, unambiguous, and devoid of relevant qualification. And that third is really where the difficulty lies. You may very often have clear, unambiguous representations, but are they really devoid of relevant qualification? And in addition, secondly, the government or public body must be one which cannot show that there is an overriding public interest which justifies reneging from that expectation, defeating that expectation. So unless you can point to such public overriding interest, it really is bound to follow the representation that it gave. Fourthly, what is the burden of proof that has to be satisfied? And upon whom does that burden lie? Well, obviously, first and foremost, it lies on the claimant. He who alleges must prove. The claimant must show that there is an undertaking given. There has to be a sufficient evidence giving rise to a substantive legitimate expectation. And secondly, once the claimant has dealt with that burden of proof upon him, it then shifts upon the government to show that there is ample evidence justifying the necessity for a breach of that expectation. Now, I go through this area of burden of proofs, even though Lord Brown in the Papanet case said that, look, this is just far too unnecessary because the whole talk of burdens of proof is entirely inappropriate in the context of what is being argued here. But even so, the rest of the board, the majority, took the view that burdens of proof was a useful thing to engage in and to satisfy. Fifth, the clarity of representations. And what this means is that how, on a fair reading of the promise, it would have been reasonably understood by those to whom it was made. The Court of Appeal, in a case called Nyala in England, has said that what this imbibes is a rigorous standard. So the clarity of representations is subject to a rigorous standard. Unless you can show that rigorous standard being applied, the court really ought not to touch it. It's a matter for the government how they deal with that representation in question. Sixthly, there is a requirement of settled practice. You look to what had gone on before. It's not enough to point to statements at large made by a variety of people in a variety of fora, in a variety of disparate circumstances. There must be settled practice. And what that means is that you must look for a specific undertaking directed at a particular individual or group of individuals before you can say that there was that statement subject to a rigorous standard of proof. Seventh, the number of beneficiaries normally on the whole must be small, because a small number of beneficiaries make it possible to say that in reality there is an expectation that can be made good. The larger the number of beneficiaries, the more difficult it becomes, and the more easy it is to say for the government to be able to say that there is a supervening public interest that has arisen since the making of the statement and what has transpired since now, allowing it to provide for an overriding public interest that will enable it to range from the undertaking. Eighth, rather more difficult, the whole question of detrimental reliance. You've obviously got to rely upon the statement, but do you have to act to your detriment? And what the courts have said here is just that normally it's certainly right that you have to show that, because if there's no hardship, there is no reason why the government should not be able to change its mind. But having said that, there is no requirement for a monetary loss. And given that that is the case, the question of detriment will essentially be a question of fact rather than a question of law being imposed upon you. Ninth, obviously, a legitimate expectation cannot contradict a statute, because otherwise the promise is acting contrary to law. So it's got to be a lawful promise. 10th, mistake. Sometimes representations are made which are made mistakenly by a government department. Well, if that's the case, then the claimant must show that the statements were made in earnest, they were made correctly, and they were made so as a matter of law. The claimant must show that those statements would be able to bind the government. 11th, the maker must be authorized in law to make the statements. So plainly, one government department making the statements will not bind another government department, must be authorized to make that. 12th and lastly, my dozen points, is the whole question of what happens when you are in a field that is so huge that it's not really for the courts to be telling the government how it may make that decision. Central government, the point here is this, the central government must enjoy a wide discretion to change policies from time to time, which reflect the broader conception of public interest. Constitutional governance allows for the liberty of the government to make changes in policy. And this is especially so where a different political party takes over from one which made those statements. That's why it's not appropriate to look at the content of political speeches made during election time, because people promise, heaven on earth, and they're not going to be bound by that. So often, the delivery of a project promised, the scale, the duration, the ambition of it is always going to be conditional upon the availability of finance and the requisite policy decision. Something very important to bear in mind. And the critical point here is this, that obviously this must be right in terms of constitutional law, because otherwise a predecessor government would be able to bind a successor government. It would be able to fetter the successor government's discretion, and that simply would be contrary to the very basics of constitutional law. So, that being so, the decision to grant a benefit is a decision vested in the decision maker, not vested in the court. All the court can do is simply look at the legality of the decision. Otherwise, the court is going behind the government decision in a macro-political or macroeconomic sphere. So, those are the basics, and I'm glad to say that I've managed to cover that in 10 minutes. So let me take you to the first of my cases, the well-known case of Paponet, which I think very neatly describes the problems at hand. Now, this is the well-known case which involves the Maxi Taxi Association. I am, of course, mindful of the fact that as guests of the Trinidad and Tobago Legal Network, we have been the beneficiaries of the Maxi Taxi Association. They were kind enough to pick us up at the airport. They've been whisking us around the city at our asking every single day. I've taken that into account, and so naturally I am entirely biased in their favour in terms of what I'm about to say. Paponet involved the Maxi Taxi Association because back in up to 1995, they operated routes 2 and 3, being based at the Broadway. And in 1995, what happened was this, that, they had control of their own affairs. They did not have to pay a fee to use the taxi stand at the Broadway. In 1995, the government proposed that they move, and they moved to Citygate in South Quay. Now, that area was controlled by a competitor organization, the Public Transport Service Corporation. And certainly it was the case that at all material times, the maxi tax operators regarded the PTSC as their competitors. And so what naturally the Maxi Taxi Association asked of the government was this, that they would not be under the control of the PTSC, that they would not have to pay any dues, that a skywalk would be constructed to allow their passengers a pathway from the city centre to the city gate. And of course, what then happened was this, very quickly, the government decided not to follow that through. In fact, what it did was in 1997, regulations were passed under the Motor Vehicles and Road Traffic Act. And Regulation 4 is particularly interesting because what this says is this, that on the payment of a fee of $100, the PTSC will decide, once it is satisfied that the applicant is a quote-unquote fit and proper person, to then, on the payment of the fee and on satisfaction, to issue them with a permit in a manner set out in the schedule, so that they have to pay for every exit, every time that they use this particular service. And so what they argue now is this, that rather deflated by this change of turn of events, they bring a claim based upon legitimate expectations. The reason I go to this case is to highlight how ambivalent and tricky the whole situation is. Pretty much anything and everything I've said so far is open to dispute. I mean, all the basic principles I just set out allow for a multitude of different views. And it's really a tremendous sort of a arena for an astute lawyer to enter, because you could argue it, quite frankly, either way, couldn't you? Here is what the Maxi Taxi Association argue. They say that they were given clear and unequivocal representations, which gave rise to a legitimate expectation. They say that they have a substantive benefit. They say that they were given to a defined group of people, namely the members of the association. They say that these were given with the aim of persuading them to agree to move from the Broadway to the City Gate. And they say that the government acted in breach of the representations in a way that was unfair and amounted to an abuse of power. All the things that they say they have to do. The case ends up eventually in the Privy Council, where Lord Dyson says this. He says, well, let's look at what needs to be satisfied. Firstly, what is the requirement of a clear, unambiguous, and devoid of relevant qualification to be met? How is that to be met? And he says, well, as I've already said earlier on, that, on a fair reading of the promise, it would have to be reasonably understood to those whom it was made that this is what it meant. And Lord Dyson says, well, look, if you look at the language of regulation of 1997, management and control are ordinary English words. And management and control mean that they, the Maxi Taxi Association, would have retained their management, would have retained their control. And there can be no doubt about this. He says that at paragraph 30, but he ends his paragraph 30 with the following words. He says, the fact that there might have been some uncertainty as to precisely what management entailed does not mean that the representations were not clear and unambiguous. They certainly were devoid of any relevant qualification. Now, you read that, and then you read a absolutely devastating dissenting judgment in the highest court of the realm by Lord Brown, who says, no, it's precisely because, as Lord Dyson had said, the fact that there might have been some uncertainty as to precisely what the management entailed, it's precisely because of that there wasn't a clear and unambiguous statement made in the first place. So you can see straight away the difficulties you get into. Secondly, says Lord Dyson, is the government then, assuming that a representation has been made, entitled to frustrate the expectation that has reasonably arisen? And Lord Dyson says, well, this is a more difficult question. And he says, in recent years, the case law in England and Wales has grappled with this entire question of, is the public authority entitled to frustrate its substantive legitimate expectation? And for this, if you're a government body, this is what you've got to show. You have got to show the government must identify an overriding interest. In Papanet, says Lord Dyson, no overriding interest was identified. When the case went before the first judge, Judge Warner J.A., she was unable to identify a particular overriding interest. And what Lord Dyson says is that you have to show a sufficient public interest which will override the legitimate expectation created, otherwise you are in difficulty. He then deals with the whole question of burdens again. He says, well, it's true that the initial burden lies with to prove the legitimacy of the expectation, but thereafter it shifts, and the authority then has to show what the overriding interest was. They weren't able to do so, and so they are in trouble. The risk for the government, therefore, is this, and if you are the government body, listen up, is that you must place material before the court of sufficient public interest to override. Otherwise, you will lose. And if you're a claimant's lawyer, this is what you're gunning for. You're gunning for the fact that there hasn't been proper disclosure, because in 9 times out of 10, it's the government that's got that information. You, the claimant, haven't got it. So you make your requests to say, want disclosure. What exactly is this? And you don't leave it right to the last minute. And unless the government can cough up that information, they are really unable to show the overriding interest. And the reason for this is, again, constitutionally, utterly prim and proper. The principle, as the court said in Nadaraja, that good administration requires public authorities to be held to their promises would be undermined if the law did not insist that any failure or refusal to comply is objectively justified as a proportionate measure in the circumstances. So that's another way to look at these cases. Is the government's behaviour proportionate? in the way that they're dealing with the citizenry. And it's disproportionate if it's unable to deal with the burden of proof on it, to provide the information that's required, so on and so forth. What then transpires is this, that the court goes on to say, well, look, this entire business about the government being able to put information on the table to show why it's acted as it has is not a mere technical point, because it is only the authority which will know why it has gone back on its promise, and the authority is always better placed than the applicant to give the reasons. So they've got to show what the public interest is. That's the critical thing. It must, as one court said, articulate its reasons so that their propriety may be tested by the court. Now, sometimes, of course, it may be possible for the relevant overriding public interest, without disclosure, to be gleaned, to be discovered from the terms of the decision which is inconsistent with the promise given. But that will rarely be the case. In most cases, the government will have to tell you why it has reneged on what the changes be, what the overriding interest is. So you could say that the promise is only, this is something else that the government could do if it's not able to disclose information. The government could say that the promise, assuming that it was given, and in the Clico case, it was accepted by council, that the promise was given, it was accepted by council, leading for the government, that a legitimate expectation had been created. You could say that the promise is only for a limited period, for a specified period, or subject to conditions, or for a reasonable period. And after that, it doesn't bind, it lapses. Again, if that's what you're going to argue, you, the government, have to show that. Where you have been given promises, good administration and elementary fairness does then require you to take into the fact that you did give the promise, because if you don't take that into account, your decision will again be lacking in proportionality. So this is how the government decides that, the court decides that in Papanet there was a legitimate expectation and that the government had erred at all fronts. Now, just lastly, what about Lord Brown? Why does he feel that he's got to dissent in such a thunderous manner? Well, this is what he says. He says that, firstly, there was an affidavit which had been excluded before the first judge, Judge Ibrahim, albeit Ibrahim, but on appeal, the Court of Appeal had allowed the affidavit of Roger Israel. And Roger Israel's affidavit gave reasons for why it was that people were moved. He said, quote, for the purposes of eradicating traffic congestion, illegal touting, and other undesirable activities. The mind boggles, make up your own mind. Secondly, he says that the PTC, SCE, may have been the main competitor, but the fact was that by that stage, 90% of the passenger clientele had already been taken up by the Maxi Taxi Association, and only 10% were in the hands of the PTSC. And although it was the case that the maxi taxi owners wanted to still retain control, no guarantee was given. No guarantee was given at all. So what Lord Brown is saying, that there wasn't even, you don't even get off the ground. There wasn't even a representation that could be said to be binding. And he then goes on in the strongest terms at paragraph 62 to say, were these assurances such as could be regarded as clear, unambiguous, and devoid of relevant qualification, such as to commit the government to honour them on a lasting basis? Is it to be said that the association could, had they wish, have enforced the skywalk? Because remember, the skywalk was never built and it was never enforced. Why, one wonders, was there never a complaint made about this? Why was no complaint made about the failure to hand over management of the facility to the association 3 months later, 6 months later, or ever? Why was there no challenge to the 1997 regulations? Why indeed, he asks, was there no complaint ever made on the imposition of the user fee until nearly 3 years after it was introduced? He says, quote, none of this suggests to me that the association regarded itself as a beneficiary of a well-nigh enforceable promise. So he then ends really by saying that what this is a quote-unquote unmerited windfall for the association, at so great a cost to the long-suffering Trinidad taxpayers. That's all you people. So his view is that really this is just completely, off the wall. And he ends by saying, look, had the challenge been on a completely different footing, had the challenge been to the 1997 regulations, which imposed on the payment of fee, the ascertainment of whether you were a fit and proper person before you could be issued the permit, had that been the challenge, he said he would have been altogether more sympathetic. But on the whole question of legitimate expectations, not so at all. So there we have it. Now, just very quickly, the other case that I'm not going to mention really in detail is the Clico case, which really was just very, very quickly, I'm hesitant to deal with this simply because, not because I actually appeared with Martineau and Eleanor Honeywell, who's now since then gone on to the High Court, but really because it's quite inappropriate for me to say anything further, given that the case is now poised to be heard by the Privy Council in London on the 15th of February. But essentially, what I want to highlight is simply this, that here once again, what you have are undertakings given in January 2009 to Clico. There's a member group of CLF, which is the largest private conglomerate in Trinidad and Tobago, which really collapsed in 2009, and Clico then came to the government asking for some support. What happened was that in January, a MOU was signed to provide support. The governor of the Bank of England then made statements, including with Mr. Guthrie, the Minister of Finance. And so what the statements were to the effect was that their short-term investments would be fully honoured. But of course, then what then happened was that you get the global financial crisis, the price of oil plummets, much else is at stake, and the change of government happens here in May 2010. In 2011, a revised plan is put in place. What's interesting to note here is, again, that the judge at first instance, Judge Charles, takes a very different view. Her view is that there was a legitimate expectation. The government wasn't able to provide an overriding interest. Evidence is not put before, once again, the court to show what it was that justified what they did. It then goes to appeal last year, almost exactly a year ago, June 2014, when Chief Justice Archie takes a contrary view, and he says no, that there wasn't a legitimate expectation, and in any event there were macroeconomic policies here and so on and so forth. And so I shall say nothing no further on that. Just quickly to say that even for us back in England, we are also having to deal with these very, very similar questions. A case that I just looked at before setting out, and I must say that I read it with one eye shut, like Ulysses bound to the mast of his ship, very, very quickly indeed. A case called DM. I mean, it's a case where an asylum seeker comes in from Afghanistan, makes an asylum application, invited for an interview, once doesn't attend, twice doesn't attend, eventually gets married, settles, and he then says, well, look, he's given discretion leave to remain. He says, what about my asylum claim? I heard about a government policy the government announced, a legacy policy, where they said that long-standing cases on which there had been no decision, given that he'd never attended an interview for asylum, there had been no decision with respect to his asylum claim. He said long-standing cases would be taken care of by grant of some kind of leave. And he said, well, look, what about me? You made this promise. And in the case of DM, which the Scottish Court of Session decided in 2014, what the court said here was this, and this is really the thing to bear in mind. The court says the Home Secretary statements and the legacy policy issued in July 2006 comes nowhere near satisfying the test of a promise that is clear, unambiguous, and devoid of relevant qualification. At best, and here is the word to remember if you're thinking about bringing these cases, at best it was aspirational. So there are aspirational statements that governments make without really thinking that they're going to be bound by them. So you've got to make that distinction. They do not constitute promises of any kind. Firstly here, because of the very large number of individual cases. And the cases here, with respect to the number of asylum seekers, were not even known to the British government. So that's how big the number is. They were in excess of 400,000, says the court. And in view of the fact that there was some doubt as to when the cases could be cleared up. Secondly, the time frame referred to was exceedingly long, 5 years. It was obvious that over such a period, circumstances would change, possibly radically. And of course, with not just the financial crisis, but also the austerity policies kicking in, we have many other things to be thinking about. And thirdly, the policy in question involved a significant commitment of government resources. So again, given that was the case, this case doesn't get off the ground. So there we have it. Whether I complete or not, I must, as I said at the outset, now finish, having consumed my 20 minutes, or as Jane Austen's Mr. Bennet would say, your services are no longer needed. You have delighted us long enough. Thank you.
Thank you, Professor Juss, for that very incisive paper. Just to let you know as well, the TTLN will be placing on its website shortly after this conference the papers which are presented in their original form, so that even if you're not able to take notes or you have not picked up all of it, you're not going to lose the benefit of that. I was intrigued by the contribution, and certainly I was very keen to hear his analysis of the very robust dissenting judgment of Justice Brown in the Papanet case. It underscored in my mind this importance of drafting and settling affidavits at an early stage. You would recall in his exposition, Professor Juss noted that Lord Brown said in effect that the affidavit of Roger Israel, which was filed by the respondent and which was excluded at first instance, was in fact reintroduced into the evidence in the Court of Appeal. And Justice Brown used that in effect to underscore that in fact there was a frustration of, well, firstly, there may not have been any expectation, but even if it was, that would itself have been frustrated because there was an overriding interest which was demonstrated by the respondent. In my mind, I'm not necessarily agreeing with the Honourable Justice Brown, but it does underscore for us, as part of our continuing professional development as attorneys, and happily we have many of us here and students, the significance and importance of drafting and settling affidavits at an early stage. Because if you do that without understanding the nuances of the law, and you do it badly or you do it wrong, the likelihood is that, notwithstanding the merits or otherwise of your case, that you would have done an injustice to your client. So I know as well that Thomas Rowe is speaking after lunch on dissenting judgment, so no doubt he may make that point and perhaps even talk about Lord Brown's very robust judgment. Good. Well, we've had a very good start and we're continuing. In terms of our program, just to let you know that we will have a comfort break at about 10:15 or so after Mr. Maharaj's contribution, and that we are pausing for lunch at about 12 o'clock or so for a broader concept of state responsibility in public law. It is being presented jointly by Ms. Vijaya Maharaj and Ms. Nyala Badal. Vijaya, in fact, graduated from the London School of Economics with an LLB in law, and from the University College in London with the LLM in public law. She is in fact a member of RLM & Company and was admitted in 2004. She is extremely knowledgeable about public law matters and commercial matters, and has appeared in numerous fora with the High Court and the Court of Appeal. Similarly, Ms. Badal is also a member of RLM & Company, more recent graduate in 2011, having been admitted to practice in 2011 following her graduation from the legal practice course, the LPC, at Staffordshire University. And she is now, in fact, at RLM & Company, and similarly is immersed in public and constitutional law, but also has an interest in personal injuries and medical negligence claims. So, ladies and gentlemen, perhaps you can join me in formally welcoming both Ms. Vijaya Maharaj and Ms. Nyala Badal, who will present jointly a paper entitled A Broader Concept of State Responsibility in Public Law.
And good morning, everyone. My contribution this morning is in relation to the widening of state responsibility by the courts under the concept of a public authority. The decisions and actions of public authorities can be challenged under the Constitution of Trinidad and Tobago and by way of judicial review. Under the Constitution, the court can give redress to a citizen where his or her constitutional rights under sections 4 and 5 have been infringed or are likely to be infringed by a public authority. Judicial review, on the other hand, is a means by which the decision-making process of a public authority can be reviewed by the courts. So then, what is a public authority? The Constitution does not define a public authority. In 1979, Lord Diplock and Maharaj, the Attorney General No. 2, defined a public authority for the purposes of sections 4 and 5 of the Constitution to be the state or some other public authority endowed with coercive powers. He went on to widen that definition in Thornhill and the Attorney General to include central authorities and any individual officer who exercised executive functions. It's been over 30 years since those decisions, and the functions of the state have changed since then. They are no longer limited to matters affecting just law and order, defense, and foreign relations. In fact, its functions now also include financial regulation, environmental protection, utility regulation, the regulation of monopolies, and the fostering of markets. A number of its functions are now commercial in nature and also include the provision of services. In reality, there are a number of privately incorporated companies which do perform executive functions. In recent times, European law has broadened the concept of state responsibility in response to this change in nature of state functions. For instance, the European Court of Justice has held that a body such as a statutory hospital authority or a statutory gas corporation is an emanation of the state, so as to found state responsibility for its shortcomings in compliance with European directives. In 2013, the courts of Trinidad and Tobago followed this approach of broadening state responsibility under the concept of public authorities as it relates to the enforcement of human and fundamental rights under our Constitution. In the recent case of Boxill and the Attorney General, the Honourable Mr. Justice Abood, in a judgment described by the Privy Council as impressive, recognized this change in nature of state functions and further extended the meaning of public authority as devised by Lord Diplock in 1979 by applying the tests set out in the European Court of Justice in Foster and British Gas. The Court of Appeal of Trinidad and Tobago considered that this test was now appropriate and affirmed that in considering whether a relevant body is a public authority for the purposes of sections 4 and 5 of the Constitution, the question will now be, 1. The authority is a body, whatever its legal form, which has been made responsible for providing a public service. 2. That public service is in the control of the state. And 3, for that purpose, it has been provided with special powers beyond those which result from the normal rules applicable to relations between individuals. Barrow J.E. recognized that a body which performed a function which was governmental in nature could not escape the provisions of sections 4 and 5 of the Constitution, simply because it did not fall within one of the traditional functions of the state or legal forms of government, and that its decisions could be challenged before the courts if they infringed upon rights and freedoms of citizens. The Court of Appeal upheld that decision of Abuji, that the Port Authority of Trinidad and Tobago, a body corporate established for the purposes of operating port services in Port of Spain and the Port of Scarborough, is in fact a public authority for the purposes of sections 4 and 5 of the Constitution. The approach, however, of the courts as to what is considered a public authority for the purposes of judicial review is rather different. In the past, the courts focused primarily on the source of the power of the body in order to determine whether that body was amenable to judicial review. There was no dispute that a body created by statute could in fact be considered a public body. However, in light of the modern functions of the state, the courts have also now consider whether the exercise of the power in question or performance of a duty involves a public element. For instance, in the English case of ex parte Datafin, the court held that a self-regulating, voluntary takeover panel, which was neither founded on statute or common law powers, but exercising immense powers de facto, devising, amending, and interpreting the city code on takeovers and mergers, was in fact exercising public law functions. It was held that in determining whether the decisions of a particular body were subject to judicial review, the court was not confined to considering the source of that body's power and duties, but could also look to its nature. Accordingly, if the duty imposed on a body, whether expressly or by implication, was a public duty, and the body was exercising public law functions, the court had jurisdiction to entertain an application for judicial review of that body's decision. The issue was determined by our courts in the NH International Caribbean case and Udicot. The Court of Appeal held that Udicot, a limited liability company duly incorporated to carry out government's urban development policy, was a public authority amenable to judicial review, since the state was in effect acting through the agency of Udicot to design, finance, and construct the building. The state was either providing the funds or necessary government guarantees. The land belonged to the state, and all of Udicot's functions were carried out for the benefit of the public or a section of the public. Recently also, Caribbean Airlines was considered to be a public body, as in the case of Hamilton and Caribbean Airlines. Robin Mohammed J. held that since the government was a majority shareholder in the airline and the airline was established to undertake commercial activities on behalf of the state, that it was a public body. TSTT, a telephone service provider, was considered a public authority by Bess J. in Samaru and TSTT, as he considered government to be in a position to exercise control of the service provider, and it was supported with public funds. WASA, a water provider, was also treated as a public authority in Desmond Haynes and WASA. It would appear, however, that the courts of Trinidad and Tobago are not prepared to hold that a decision taken by a public authority, whatever its legal form, to enter into or determine commercial contracts or to supply goods and services could be the subject of judicial review in the absence of fraud, corruption, or bad faith, where there is no statutory underpinning for the decision taken. However, this divide between private and public law actions does not apply in an action brought pursuant to Section 14 of the Constitution. There is no requirement in claims under the Constitution for the act in question to be of a public law element. As Barrow J. held in the Box Hill case, any act of discrimination will attract the sanction of the Constitution. No pattern of discrimination is required. A single act will suffice. The provisions of Sections 4 and 5 themselves provide the basis of the complaint. They found the claim itself. That is a sufficient basis which a claimant may proceed. The fact that the act for which there is a complaint arises out of a contract will be of no relevance to the viability of a constitutional claim in those circumstances. The private law nature of the act, therefore, will not be the sole basis by which the notice of motion will be judged. The decision will turn on the facts and circumstances of the case. That is to say, the nature of the allegations and the nature of the act complained of, and the evidence led in support of the motion. It is clear that the courts of Trinidad and Tobago have adopted an approach of broadening state responsibility under the concept of public authority in order to meet the evolving functions of the state. There is no fixed definition of public authority, and the categories are not closed. As Lord Parker CJ said in Ex parte Lane, the system remains open-ended, and new territory can be annexed to the judicial empire as opportunities offer. Thank you. I'll now pass you on to Ms. Nyala Badal.
Very much, Vijaya. Good morning, everyone. My contribution this morning focuses on the widening of state responsibility and accountability through the Freedom of Information Act, Chapter 22 of 02. The Freedom of Information Act became law on the 30th of August 2001. This act embraces the concept that information collected and generated by government is a resource of the people, for the people, and is to be accessible as freely as possible by the people. It seeks to promote the principles of accountability, openness, transparency, and increased public participation. As Justice of Appeal Narayan stated in the case of Ashwath Sankar and Public Service Commission, open quotes, the object of the Act is to make information freely accessible to the public with a view to promoting transparency and accountability in the decision-making of public authorities. It is an important piece of legislation in a post-colonial society in which bureaucrats have historically been reluctant to expose their decisions to the glare of public scrutiny. Freedom of information is also important in a society that is politically polarized along ethnic lines and in which appointment to public office and decisions involving the allocation of state resources are often the subject of speculation and mistrust. Against this historical and social background, the right to access information from public authorities must be jealously guarded and must not be allowed to be whittled down, end quote. An applicant can request the public authority for official documents pursuant to Section 13 of this Act. The public authority must notify an applicant of its decision whether to disclose the requested documents or to refuse its request no later than 30 days from the date on which the request was made. If the public authority does not notify the applicant of its decision or indicates that it is refusing to provide the requested information within this stipulated 30 days, then it is open to the applicant to file a judicial review claim challenging the said authority's refusal to make a decision or its refusal to provide the requested information. This act is a good start, but it is only a start. In my contribution, I would highlight the position which the local courts of Trinidad and Tobago have recently adopted in respect of the implementation of the Freedom of Information Act and the widening of states' duty of disclosure pursuant to the said Act. Firstly, the courts have held that where a public authority makes a decision that requested documents are not to be disclosed, the public authority has a duty under Section 23, subsection 1 of the Act to notify the applicant of its reasons of its refusal. It is the duty of the public authority to provide all of its reasons upon which it has based its decision to refuse to disclose the requested information. The courts have determined that a public authority is not entitled to seek to rely on additional reasons for its refusal at a later stage if an applicant challenges its refusal by way of judicial review. In the case of Ashworth Sanker and Public Service Commission, Justice of Appeal was very clear in the court's interpretation of this. He states, "The Commission failed to comply with the clear provisions of the Act to provide proper reasons for its refusal so as to enable the appellant to make an informed decision as to whether or not he would challenge the refusal by way of the judicial review. In these circumstances, it is clearly undesirable that the respondent should be permitted to provide new reasons or to add to or augment vague or insufficient reasons originally advanced for refusal of access. In my view, to do so will ultimately frustrate the clear purpose of the Act, which is to permit the public to access information unless refusal of access can be brought within one of the exceptions specifically set out in the Act, and adequate and intelligible reasons are provided for such refusal," end quote. The courts over the years have been increasingly reluctant to receive evidence to supplement inadequate reasons where there is a statutory duty to provide reasons for a decision. Secondly, the courts have also known that they can review a decision of a public authority that a document is exempt. A public authority can refuse to disclose a document if it is an exempt document under Section 33 of the Act. For instance, under the Act, a document can be exempt if its premature disclosure would be contrary to public interest, if it would have an adverse effect on the economy, if it would be contrary to financial interest by giving an unreasonable disadvantage, if the information is of a competitor public authority, if it contains information from a third party, or if it would disclose instructions issued. Justice of Appeal Jamada, in the case of Caribbean Information Access Limited and the Honorable Minister of National Security, set out a test which a court ought to apply in reviewing the decision of a public authority that a document requested is exempt. He stated, open quote, "The exemptions are also to be approached in a careful and contextually sensitive manner. A delicate balancing of competing policy interests must be engaged. Thus, in my opinion, the appropriate test is one of reasonableness. Is it reasonable balancing the competing interests and in light of the explanations given and where necessary the evidence supplied to uphold the exceptions claimed? This is an objective test and the public authority must satisfy the court on the civil standard of likelihood, end quote. The courts have been clear that there is no presumption in favor of exemption from disclosure or of access to documents held by public authorities, as per Justice of Appeal Jamada in the said case of Caribbean Information Access. Thirdly, Section 33 of the Act is another aspect of the Freedom of Information Act which the local courts have had the challenge of implementing in order to transform the culture of public agencies. Where a public authority considers a document to be exempt under the Act, Section 35 of the Act provides that, notwithstanding any law to the contrary, a public authority shall give access to an exempt document where there is reasonable evidence that significant abuse or authority or neglect in the performance of official duty or injustice to an individual or danger to the health and safety of an individual or of the public or unauthorized use of public funds has or is likely to occur. The public interest in Section 35 of the Act has been described by Justice Mosai in the High Court judgment of Ashford Sanker as a term embracing matters, among others, of standards of human conduct and of the functioning of government and government instrumentalities tacitly accepted and acknowledged to be for the good order of society and for the well-being of its members. The interest is therefore the interest of the public as distinct from the interest of an individual. The burden is on the public authority to show that the public interest in withholding the information is greater than the public interest in disclosure. The courts have held that a public authority has a duty to conduct the Section 35 overriding assessment and analysis to consider whether the documents requested, though exempt, should still have been disclosed, and to have explained this in its written response to the request. This is succinctly stated by Justice of Appeal Jamada in the said case of Caribbean Information Access, where he quotes, the Section 35 public interest override assessment and analysis must be undertaken by a public authority. It follows a decision that a document is exempt, end quote. The learned Justice of Appeal went on to state that, in my opinion, fairness and justice require that in these judicial review proceedings and in the interest of good public administration, that these requests be remitted to the respondent for its reconsideration in light of Section 35 and the opinion of this court, end quote. In conclusion, it would seem to me that the courts of Trinidad and Tobago have interpreted the Act in a manner which promotes greater transparency and accountability by public authorities in their duty of disclosure. As I close off, I would like to end with a quote taken from a recent judgment of Justice Frank C. Prasad in a High Court case of the Joint Council, Consultative, in which he stated as follows, open quotes, it must always be in the public interest to ensure that the activities and projects undertaken by government are transparent, and all attempts should be made so as to dispel any perception of misappropriation of public fund and or financial impropriety. After 51 years of independence, the society must demand transparency, and legislative moves in that direction should be welcome and applauded. Thank you very much.
The Caribbean Court of Justice, Ms. Miriam Samaru, Principal of the Hugh Wooding Law School, and Ms. Leela Ramdeen, Member of the Equal Opportunities Tribunal. Our next presenter is Mr. Peter Knox, Queen's Counsel. Mr. Knox is head of 3 Hare Court and was called to the bar in 1983 and took silk in 2006. He specializes in a range of appellate work in the Privy Council, including constitutional cases, contract and public law matters, as well as, in fact, criminal cases, particularly as it relates to pro bono matters in capital appeals. He frequently appears in the Privy Council and is an extremely competent and able advocate in commercial law. with substantial experience in litigation and advising in property disputes and of professional negligence claims, as well as matters in banking, disputes resolutions, mortgages, matters involving commercial agency regulations, and claims concerning investments. He has a wide range of experience of obtaining and what are recalled as garnishee orders and freezing orders on an urgent basis in commercial disputes. He has also conducted substantial litigation involving investments and solicitors' negligence. Ladies and gentlemen, please welcome Mr. Peter Knox, and he will be presenting his paper on an overview of recent Caribbean cases.
Almost exactly 800 years ago today, King John put his seal to what became known as the Grand Charter, or Magna Carta. So I thought I would talk today about recent Caribbean cases about the separation of powers, but prefaced by some comments on Magna Carta. Now, to gauge the importance of this document, I think it helpful to consider the immediate reaction of its great opponent, Pope Innocent III. Now, Pope Innocent III, despite his name, was an intelligent, worldly, and apparently rather humorous man. He trained, it seems, as a lawyer, and perhaps like many lawyers, taking the view that attack is the best form of defence, he was responsible for launching 3 crusades. He was also, by virtue of recent events, which are rather tangled, the ultimate lord, both temporal and spiritual, of England, not King John. You can imagine, therefore, his surprise when he found out that King John, without any authority, had gone and put his seal to this new charter on the 14th of June, 1215. He immediately issued a papal bull when he found out about it on the 24th of August, 1215. This noted first that the charter had been entered into, quote, by force and by fear, which might have assailed even the most courageous of men, with the clear implication, unlike King John. He then went on utterly to cancel the charter and its pledges and its obligations, quote, so that neither now nor hereafter shall they be of any validity. But what is most interesting is why he saw this document as such a bad thing. I quote, we, not wishing to close our eyes to such audacious wickedness, whereby the Holy See is brought into contempt, the royal prerogative diminished, the English nation outraged, and the enterprise of the crusade gravely imperiled, he was planning yet another crusade. He then finished on. Now, lawyers and judges have often been accused by historians for unhistorically reading back into Magna Carta ideas representative of their own era, but alien to that of the barons and King John. But I think this particular point made by Pope Innocent just months after Magna Carta was entered into is its most significant and long-lasting feature even today. Quite simply, as Pope Innocent recognised, it provided for the diminution of the royal prerogative, or the royal discretion. Whatever the position might have been before, some things were now clearly a matter of right, not a matter of discretion. In other words, Magna Carta contained the first clear expression of the doctrine which we would now call the separation of powers. Most famously, it did this by restricting the king's power to withhold, sell, or delay justice from his subjects. Now, it seems that initially Magna Carta, albeit in revised forms, was seen as a central, indeed uncontroversial part of English law for a good 200 years or so. It then appears to have receded in significance for a while until the Stuart kings brought it back centre stage in the 17th century. In essence, they took the view that they ruled by divine right, and that the monarchy was free from constitutional restrictions. Thus, although by now there was a House of Commons and a House of Lords, the Stuart kings had no objection to sacking judges if they didn't like their judgments, or indeed imprisoning members of Parliament in the Tower of London if they didn't like what they said or did in the House of Commons. In the end, in 1689, after James II's flight to France and William III's invasion from Holland, the Bill of Rights was passed, the English Bill of Rights was passed, which at last, in Article 9, protected MPs' freedom of speech in Parliament by ousting the jurisdiction of any court, any other court, to question it. And in 1701, a couple of years later, the Act of Settlement, passed under the same king, laid the foundation for judicial independence by providing that judges were to hold office as long as they did not misconduct themselves. Since then, I think it is fair to say that gradually The executive's discretion has been brought in most areas under judicial control by the development of judicial review, in particular in the second half of the last century. Even the royal prerogative itself can in principle be reviewed by the courts if the nature of the subject matter is such as to allow it. That, of course, is the famous decision in the Civil Service Union's case in 1981 in the House of Lords, when Lord Diplock, to everyone's surprise, suddenly came down on the side of the Liberals. But just as the executive's power has diminished, so too, in that period, so too Parliament's power has on the face of it increased. In classic constitutional theory, Parliament is free to pass such laws as it pleases. Of course, its freedom to do so is limited to the extent that the Constitution itself provides in terms, as many do, and indeed as does the Constitution of Trinidad and Tobago, that no statute passed by Parliament can infringe one of the protected human rights and freedoms. In such a case, the court simply looks at the apparently infringing statute, asks if it does infringe the fundamental right, and upholds it, or sets it aside as it must. That's easy. But often the protection given by a constitution to human rights and freedoms is limited. For instance, it may provide that laws already in existence when the constitution came into effect are to continue to have effect, notwithstanding any inconsistency with the human rights provisions in the constitution. In other words, it may contain what we lawyers call an existing laws clause. Or it may provide that the law can take away the human rights protection as long as it is passed with a certain majority, say 3/5 or 2/3, as in, I think, the case of Section 13 in the Trinidadian Constitution. Or it may not even purport to protect any fundamental rights at all, such as, I think, the Constitution of the Cayman Islands. On the face of it, you might think that if the law passed by Parliament cannot be struck down for inconsistency with the human rights provision, then it cannot be struck down at all. But you'd be wrong. The story starts in 1953 with the famous case from Ceylon, as it then was, Sri Lanka is now, Lionage and the Queen. In this case, special laws were passed by Parliament, the local Parliament in Ceylon, after a coup to widen the class of offences which could be tried without a jury, and to widen the scope of the offence of waging war against the Queen, and to increase the range of penalties, and also, for good measure, to change the rules of evidence. Now, there was no fundamental rights clause in the Ceylon Constitution, but nonetheless the Privy Council struck down these laws on the basis that they were directed to the trial of particular prisoners who had taken part in the coup for a particular criminal offence, and that this therefore involved a usurpation by the legislature of the judicial powers. That, it was said, was inconsistent with the implicit intention of the Constitution, nowhere spelled out expressly. Now, to similar effect, in 1977, in a case in Jamaica, Hines and the Queen, the Privy Council struck down a law which created a new court, called the Gun Court, which had been set up by Parliament to hear specific offences of violence, because, the Privy Council held, the judges to this court would not be appointed in accordance with the appointment procedures for judges set out in other parts of the Constitution. In other words, you can't have people who are really acting as judges but haven't been appointed in the way the Constitution provides. Now, in my view, neither of those decisions is particularly surprising. Indeed, in the first, the Lionage case, the Privy Council was careful not to state a point of great principle. They were rather hesitant. They obviously didn't like the look of the law. But in 2002, the Privy Council, in another case in Jamaica called DPP and Mollison, considered an old statute which provided for juveniles to be detained during the Governor-General's pleasure, rather than under the court's control. This was an existing law. It was the traditional way the common law had always dealt with juveniles, and was therefore saved from challenge for inconsistency with the fundamental rights provision, because Jamaica had an existing laws provision. But nonetheless, the Privy Council still struck that down. But in doing so, Lord Bingham said something which I think is very striking indeed, and bears repetition. And he said this: whatever overlap there may be under the constitutions on the Westminster model between the executive and legislative powers, the separation between the exercise of judicial powers on the one hand and legislative and executive powers on the other is total, or effectively so. Such separation, based on the rule of law, was recently described by Lord Steyne as, quote, a characteristic feature of democracies, end of quote. I emphasise the word total there. There is a total separation. Now, this line of argument was taken a step further in 2007 in a case from Mauritius called Koirati. Now, in this case, new legislation taking away the grant of bail pending trial for certain drugs offences was passed by a constitutional amendment with a three-quarters majority. That being the majority necessary to introduce, under the Mauritian constitution, a provision which derogated from the constitution's prohibition against cruel and unusual punishment. In other words, Parliament thought we've done the necessary. We've got the necessary majority to get that one through. Supreme Court and Privy Council wasn't having any of it. Section 1 of the Constitution of Mauritius provides that Mauritius shall be a democratic state. And this provision, that provision, could be altered only after a referendum and a unanimous vote by all members of the House of Assembly, not, in other words, by a mere three-quarters majority. Now, repeating Lord Bingham's dictum, the Privy Council held that the usurpation of the court's role over the grant of bail was inconsistent with the very nature of democratic state, and it therefore simply couldn't happen, in effect, as long as Mauritius remains a democracy. These last two cases, I think, are very strong cases indeed, not least because it's very rare to come across a proposition of law expressed in such absolute terms, namely, the separation of powers is total, or effectively so. This brings me now to three recent cases from the Caribbean which have considered this doctrine. The first is one which I'm sure is well known to all of you, the great Section 34 case of Steve and Ish, as I understand it's called, or more properly, Ferguson and others v. the state. Now, in this case, as you no doubt know, the government of Trinidad and Tobago, in, I think, September 2012, brought into force, by proclamation, Section 34 of an act which I'm reliably informed is called the Administration of Justice and Indictable Proceedings Act. I have to admit, I asked about 5-10 people here what the name of that act was. No one was able to answer it until someone kindly went online to find the name for me. Anyway, Section 34 had the effect of giving those accused of very many serious crimes, including corruption and the like, the right to apply to the court to be discharged if more than 10 years had passed since the crimes had been committed, subject to certain exceptions. There was immediately public uproar and some public suspicion, I think it's fair to say, and 12 days later, Parliament passed an Amendment Act to repeal and to reverse the effect of Section 34, with the result that all those who thought they had the benefit of this new 10-year limitation provision had now lost it again and could be prosecuted after all. This, in turn, prompted an attack on the Amendment Act by those who thought they had the benefit of the limitation period and who had indeed, rather quickly off the mark, already got round to applying to the courts to be discharged from the criminal offences they've been charged with, including Mr. Ferguson and others accused of corruption in relation to the Piarco airport contracts back in the late 90s and early 2000s. Now, one of the central attacks made by Mr. Ferguson and his co-applicants was, on the amending legislation, was that it infringed the principle of the separation of powers. Now, this was tactically a very important argument in the case, because the amending legislation had been passed with a 3/5 majority, indeed I understand in the House of Representatives unanimously. And so, by virtue of Section 13 of the Constitution, it couldn't be attacked for inconsistency with the fundamental right to due process, protected through the Constitution, unless it was shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. That is never such an easy thing to show. That is why it was important for the applicants to try to rely on the separation of powers principle instead. The argument went that by reversing Section 34, Parliament was illegitimately interfering in the court process. That is to say, the process of applying for a discharge granted by Section 34 of the previous Act. Now, both the judge, Madam Justice Dean Armourall, and the Court of Appeal, Mr. Justice of Appeal Mendonça, Jamadar and Smith, rejected that argument in fairly stinging terms, I think it's fair to say. In essence, they held that the amending Act had been passed simply to correct a manifest flaw, maybe oversight, in the previous legislation, and that it was not seeking to prejudge or direct the outcome of criminal charges, but rather simply seeking to restore the position to what it had been and to enable a fair trial to take place in accordance with the pre-existing rules. That matter is now under appeal to the Privy Council, and the appellants are contending that the judgments below miss the point, which is that the amending legislation interfered retrospectively with their applications to the court to be discharged under Section 34. Now, I have been instructed to act on behalf of the state in that appeal, and so it wouldn't be appropriate for me to say anything more about the case, other than to say that the Court of Appeal is plainly right and the appellant's plainly wrong. The second recent case that discusses this doctrine of the separation of powers is the Attorney General of Belize against Zuniga, a decision of the Caribbean Court of Justice on an appeal from Belize, decided in January last year. Now, in this case, legislation was introduced in Belize to create the offence of knowingly disobeying or failing to comply with an injunction, in particular an anti-arbitration injunction. And further, the legislation prescribed very severe penalties for this offence, including mandatory minimum penalties. This legislation was to apply not only to the parties themselves who tried to breach the legislation, but also to their advisors. Now, what had happened was that an arbitration award had been made against the government of Belize, ordering it to pay damages, I think, of about 38.5 million Belize dollars for breach of contract. The government, however, obtained an interim injunction in Belize, I think, to restrain the successful claimants from seeking to enforce the award against it. One of the claimants, called Dunkeld, however, ignored that order and proceeded in any event to try to enforce the award, not in Belize, but in another jurisdiction. Hence, the act that I've just mentioned was passed, creating the offence and prescribing the minimum penalties. Now, in the end, the act was challenged by a group of advisors who thought they might be affected by it, known as the Zuniga Group. They feared that they might be charged under the Act. They contended that the legislation was introduced specifically to target members of their group in their recourse to international arbitration and to get remedies under it, and also, they said, because it introduced a special regime for the prosecution and punishment of a breach of an anti-arbitration injunction at the complete discretion of the executive. The Caribbean Court of Justice rejected these arguments. In the main judgment given by Mr. Justice of Appeals Saunders, Nelson and Hayton, it said the following, and I quote, because it's a very important passage which I think can be taken more or less to be the most authoritative exposition now of the doctrine of separation of powers. Quote, legislation prompted by the acts of a particular individual or group, accompanied by the introduction of steep mandatory penalties and providing for rules to be made by the Attorney General, might raise a red flag, especially where the government has or may have an interest at stake. Undoubtedly it did in that case. But even if present, these indicia by themselves alone do not necessarily establish that the separation of powers doctrine is compromised. To offend the doctrine, it must be shown that the legislature is undermining the decisional authority or independence of the judicial branch by compromising judicial discretion. The court's ability to address legal principles in a pending case, i.e. its adjudicative process, must be negatively impacted so that it can truly be said that the legislature, in order to guarantee a particular outcome, is prescribing or directing or constraining the court in its application or interpretation of those principles. And then they continue, the litigant must be protected from a situation where he or she has to contend in court with both the opposing side and the interference of the legislature seeking, in the midst of proceedings, to direct the judge as to the outcome of the contest. End of quote. Accordingly, the court held, although the minimum penalties were on other grounds objectionable, there was no question here of an infringement of the separation of powers doctrine. This is because there was no direction in the legislation to the judiciary as to how to exercise its new powers granted by the legislation. The court also held this, so far as material, that although the Act may have been passed with the Zuniga Group in mind, and indeed others specifically in mind, that wasn't enough in any event to make the legislation ad hominem, as the phrase goes, because it wasn't expressed to apply to specific individuals, or indeed arbitrations, but was expressed in general terms. The court concluded, subject to the Constitution, Parliament was at liberty to exercise its legislative power so as to abrogate existing rights and liabilities which would otherwise be subject to judicial determination. That, it held, was not the same thing as telling the court what to do. So in other words, you can remove a right, but you can't leave a right in place and then tell the court how to adjudicate upon it. Quite a fine distinction. The third case I wanted to mention, third and last, is a case from St Kitts, a decision this year of the Privy Council concerning the recent election there, called Brantley and Others and the Boundaries Commission. This time, a decision on the separation of powers which went the other way. And briefly, the facts were this. the Constitution of St Kitts and Nevis provides for an Electoral Boundaries Commission. On the 16th of January this year, this commission, by a 3-2 majority, abruptly decided to recommend a change to the electoral boundaries in St Kitts and Nevis. Now, the effect of the recommended change, surprise, surprise, would be to mean that on the past voting patterns, the current government would sweep up all 11 seats in St Kitts. The government decided to call an emergency meeting of the National Assembly, that's its local parliament, on the same afternoon as the Electoral Commission's decision, and gave last-minute notice to the opposition MPs about this emergency meeting, some of whom managed to turn up after the debate had already started, and who, need to say, objected to the whole procedure. And there's a wonderful moment in Hansard where it reports that the cameras turn towards the opposition benches and no one is there at first. And then when someone does eventually turn up, they turn to him and they turn to the government benches where all the members of the government are laughing. Of course, the objection was, how on earth could this possibly be an emergency? We're just talking here about changing boundaries. The debate continued, and eventually the National Assembly approved the new boundaries, and that same evening the Governor-General immediately signed a proclamation purporting to bring the new boundaries into effect. Now, the reason why the government acted so quickly was that Section 50, subsection 7 of the Constitution provided that once new boundaries had been proclaimed by the Governor-General, then there could be no challenge to the Boundary Commission's recommendations. Whereas before the proclamation was made, you could challenge the new proposed boundaries by judicial review under Section 96 of the Constitution. So it was terribly important from the government's point of view to get this legislation pushed through as quickly as possible before anyone could get to court to challenge it. That was what was really going on. And that way, of course, they could guarantee winning the next election too. Now, unfortunately for the government, on the same evening, 16th of January 2015, after the proclamation had been signed by the Governor-General, but before it was published in the local gazette a few days later, representatives of the opposition parties got an injunction from the High Court in St Kitts against the Governor-General, ordering him not to make the injunction, and it was then served on him. The government then applied to set that injunction aside. They said it was all far too late. It was all totally irrelevant, because by the time the injunction had been served, the proclamation had been signed, and that meant the proclamation had been made. Therefore, the injunction was too late, therefore it was useless, therefore the new boundaries had come into force, therefore the whole thing was immune from challenge, therefore they must apply to the next election, which of course by now had been declared to be held on the 16th of February 2015. Now, that argument succeeded at first instance in St Kitts and in the Eastern Caribbean Court of Appeal, but the Privy Council rejected it, holding that the proclamation had not been made until it had been gazetted after the making of the injunction. It followed, therefore, that as the proclamation had been made or completed only after the injunction, it was of no effect. Therefore, the election had to be held on the old boundaries, not the new boundaries. But the Privy Council went on to deal with the other point that was made by the opposition, that anyway, the way the government had tried to introduce the new legislation was a deliberate attempt to deprive the opposition parties of the opportunity to mount a legal challenge to the Electoral Commission's report under Section 96 of the Constitution. And the Privy Council concluded, and I quote, "At least there was at least a strongly arguable case that a deliberate attempt by one branch of government in the control of the governing party to prevent individuals from obtaining access to the High Court for constitutional adjudication under Section 96 of the Constitution would be unconstitutional, as it would deny the protection of the law, contrary to Section 3A of the Constitution. It was therefore strongly arguable that the proclamation was on that other ground unconstitutional in any event, and therefore void." Now, what does one draw from these last three cases? Very briefly, I think one can make the following three propositions. First, Parliament is entitled to change the law in such a way as to take away existing rights. That does not amount to a breach of the separation of powers principle. Parliament is perfectly entitled to do that, even if you might think they're rather fundamental rights. You might have protection under the fundamental rights clauses, you won't have protection under the separation of powers doctrine. Second, Parliament is not entitled to leave an existing law and existing rights in place, but then tell the court how to adjudicate on those rights. That does amount to a breach of the doctrine of separation of powers, and even if it does not amount to a breach of the fundamental rights provisions. Thirdly, Parliament is not entitled to use its own process in such a way that individuals cannot get to court in time to assert their existing right to challenge proposed new legislation, which is recognised by the Constitution itself. Those, I think, are the three principles one can draw from that. Thank you very much indeed, ladies and gentlemen.
Now, in fact, many of you are taking notes, and I just want to also let you know that we have a very wide listenership, in fact, a global listenership, because our broadcasts are being carried live by I-95.5, Power 102 radio stations, and later on this afternoon, the panel discussions are being broadcasted by Heritage Radio 101.1. These proceedings are also being carried by CNC3. And therefore, our global audience will have the benefit of hearing from our next speaker, Mr. Ramesh Lawrence Maharaj, and his paper is entitled The Supreme Court as Guardians of the Constitution. Mr. Maharaj needs no introduction, but notwithstanding that, for those of you who may not be familiar with him, he was called to the bar in 1967 and took silk in 1996. His considerable experience in practicing as a practicing attorney at law in the Caribbean, Commonwealth, and has also practiced extensively before the Judicial Committee of the Privy Council. He's appeared in numerous cases in public and constitutional law, and in fact has seen the law from all angles, as a litigant, as a lawyer, as Attorney General, and I dare say as a prisoner, because some of you may recall that in 1976 he was briefly imprisoned for contempt of court. A matter which in fact prompted Attorney General A. Maharaj versus Attorney General in several forms, and also a book, Barrister Behind Bars, which in fact is in our library, the Hewelling Law School Library. Some of you should read it. Good. Mr. Maharaj has also been responsible for the development of the law, and in fact has appeared in numerous cases, some of which we cited, the Papanet case this morning, as well as the Oswald Allen and others case, which came out very, very recently. We also have the Lennox Phillip case, the Guyadine, Mitchell, many, many of them. I hope he gives us an opportunity to have a discussion with him and perhaps take up his own views in relation to those matters. Mr. Maharaj served as Attorney General of our dear Republic between 1996 to 2001. And during his tenure in office, and this is something he's very proud of, and I think with the fullness of time we now appreciate that, he was responsible for an aggressive law reform program which included the Freedom of Information Act, which we talked about earlier this morning, as well as the Equal Opportunity Act, and Mr. Ambean from the Equal Opportunity Commission is here, and of course the Judicial Review Act, number 60 of 2000. And if I can just add this personal contribution in terms of the Judicial Review Amendment Act, those of you who have read it may well agree with me that it is an incisive and perhaps an extremely provocative extension of the law as it relates to public law, and has codified for the first time in many Commonwealth jurisdictions many of the private law elements, which in fact makes judicial review not only a model, but in fact a very practical and workable remedy. And for that, certainly on behalf of generations of constitutional lawyers, Mr. Maharaj, I thank you for that piece of legislation. So let us invite Mr. Maharaj to make his contribution in respect of the Constitution.
Good morning. Thank you very much, Mr. Bisessa. May I first say that I am very privileged to be here, to be with you, to be able to share these thoughts with you. And I would like to congratulate the members of High Court and all those who have participated in Trinidad and Tobago to make this possible. I think it is very important for lawyers to have continuing legal education, and I think it's also important for judges to have continuing judicial education, because without that it is not possible for the law to be developed to its maximum. In speaking today, I want to take it from a different angle. I want to take it from the angle that, as you would have heard this morning, the law has been developed. Although we know what the law is, what the Constitution says, but the law has been developed, and it depends upon lawyers, it depends upon judges, and it depends upon litigants and members of the public to develop the law. And in that context, I would like to discuss the challenges which the legal profession face in the quest to develop the law, and taking that in the context of the Supreme Court as a guardian of the Constitution of the countries of the Commonwealth Caribbean. I know that I'm addressing a lot of law students who are going to be potential lawyers, and I think I would like to take this opportunity of sharing some of my experiences with them so that it might inspire and motivate them to be able to take steps to have the law developed. And sitting here, I heard some of the cases like Box Hill, Papanet, even Maharaj, and the Attorney General number 2. And the judges would not be able to decide cases and to pronounce on the law unless you have the cases before them. And therefore, lawyers have to understand that they have to have a passion for justice in order to take some of these matters forward. We have in Trinidad and Tobago and in the Caribbean a situation in which, since independence, the Constitution made the Supreme Court the guardian of the Constitution. A new remedy was created by the Constitution to give to every individual the right to approach the High Court if that individual believes that his or her right was being infringed or is likely to be infringed or has been infringed. And the court is given the power, omnipotent power in my view, to grant redress. So one sees that whether it is the legislative arm of the state or the judicial arm of the state or the executive arm of the state, if any citizen believes, any person believes that the state in whichever arm is violating his or her right, that individual is entitled to approach the court. Now, the individual would need lawyers, would need, in order to go to court. But that individual would be able to approach the court to have the court declare rights infringed. Now, taking, for example, Maharaj and the Attorney General, number 2, we may not have had the right of a litigant recognized in that case unless there was a decision to go forward. After the imprisonment of the barrister in 1975, the barrister had to decide to fight the system, and he needed lawyers to assist him to fight that system. If the barrister did not get assistance from lawyers in the United Kingdom to take the matter to the Privy Council, lawyers in Trinidad and Tobago and in the Caribbean, and I don't know if Sir Fenton Ramsahoye is here, oh yeah, he's sitting here, we would not have been able to take that case. So lawyers have a duty to be able to take cases in order to challenge the system. And therefore, Maharaj and Attorney General number 2, if I may say so, it's a landmark case, but it shows that not even the judicial arm of the state can violate the Constitution and a citizen will get no redress. The judge is not liable, but the state is liable. So there is a great jurist who I read from time to time. He was the Chief Justice of India, Bhagwati. When I was Attorney General, I brought him to Trinidad and Tobago, and he assisted in drafting, in helping us to draft that Judicial Review Act. And you would see from some of the decisions of the Supreme Court of India, you would see that the lawyers take the matters to court, and the Indian Supreme Court has held that you could only write a letter. And as long as the court is aware of a violation of a fundamental right, the court will perform its duty to determine whether the right is being infringed. Without any legislation, the court can appoint assessors, investigators, get a report, serve it on the state, and you can have a decision And when you read some of the decisions of the Indian Supreme Court, you would see how proactive and dynamic the judiciary has been in ensuring that the Constitution is a living instrument. Because the Constitution must not only speak of justice, it must deliver justice. Chief Justice Bhagwati said, "Law is not like an antique to be taken down, dusted, admired, and put back on the shelf. It is rather like a vigorous tree which has its roots in history, but takes on new grafts, put on new sprouts, and occasionally drops dead wood. It is a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment of human relations by eliminating social tensions and conflicts, and it must therefore change with the changing political, social, and economic conditions in society." So when we talk about cases and when we talk about developing the law, we as lawyers have a duty to the public in order to assist the public and assist the courts in developing the law. And that is how the system, in my view, must work. I believe the legal profession should not be a profession which should merely be concerned with going to chambers, going to the law courts, dealing with cases, and earning a living. I believe the lawyers have to give back something to society, and therefore they should be involved in the society. They should work with communities, and they should take steps to bring before the courts matters which the judiciary should determine in order to vindicate the rights under the Constitution of the peoples of the Caribbean. Law must be constantly on the move, adapting itself to changing society and not lag behind. Now, there is a case in Trinidad and Tobago recently which would in effect show how important it is for the courts in dealing with the Constitution to be able to be very liberal in permitting public-spirited individuals and groups to bring before the courts matters which involve the violation of the Constitution. There is a case which was decided in the High Court and the Court of Appeal, and it is now before the Judicial Committee of the Privy Council. The name of the case is John Reginald Dumas versus the Attorney General of Trinidad and Tobago. And let me briefly tell you what that case is about. I think most of the people in Trinidad and Tobago know that Mr. Dumas is a recognized public-spirited individual. He writes a lot on the newspapers, but he was a distinguished public servant. And Mr. Dumas decided that what His Excellency the President did in appointing 2 members of the Commission was wrong. He thought that the President did not comply with Section 122(3) of the Constitution in making 2 appointments to the Police Service Commission. He felt that the appointments were illegal. He wrote about it. He wrote the Attorney General. He pointed out matters to His Excellency the President, and there was no action. So what did he do? He decided to file a claim. He filed a fixed date claim in the High Court, asking for the High Court to interpret the Constitution, to declare that what was being done was illegal. He said a Police Service Commission is an important authority in the country, and you cannot have a Police Service Commission operating illegally. The Police Service Commission is responsible for appointing police officers, promoting police officers, transferring police officers. So he went to the court. So we went to the High Court, and the High Court upheld the submission of the Attorney General that the court had no jurisdiction. And the court had no jurisdiction because, according to the points made by the Attorney General, that it's only if a citizen right is violated under Section 14 of the Constitution, and he can show that his right is directly violated, he can approach the High Court to get redress for a constitutional violation. So what the High Court was saying, that even if there are violations of the Constitution by top public officials, including the head of state, and your right is not directly violated under Section 14, the Supreme Court is impotent to redress the situation. The constitutional violation must continue. Now, as a lawyer, I felt that that was unacceptable. I felt that there was no way the Constitution can function in a country in which you can have violations of the Constitution and the court, which is the guardian of the Constitution, is impotent to deal with it. So we appealed to the Court of Appeal, and we were successful. The Court of Appeal, Justice of Appeal Jamada, Justice of Appeal Smith, and Justice of Appeal Barrow said they were there. Nothing of that. A citizen has locus standi to make the claim because the citizen has a legitimate interest in upholding the Constitution and the rule of law, and the court has an important role as a guardian of the Constitution, and the court must uphold the Constitution and the rule of law. As a matter of fact, Justice of Appeal Jamada held that the court was recognized as a guardian of the Constitution, and held that it was the duty and responsibility of the Supreme Court was to ensure that the Constitution and the rule of law were upheld in Trinidad and Tobago. Now, if Mr. Dumas did not have the determination and the passion to take this matter to the court, we would not have had the law recognize that a public-spirited individual, if there is a violation of the Constitution, can approach the court in order to have that issue determined. And this matter, the matter of John Reginald Dumas, I must pay tribute to Mr. Carl Hudson Phillips. He was the person who decided that he was going to take this matter to the court for Mr. Dumas, and unfortunately I had to take it over because of his sad death. So one sees the importance that litigants play in developing the law, in ensuring that the courts recognize the rights of the individual and to ensure that the Constitution is not violated. I think there is one case that I want to talk about again, and that is a case referred to by Mr. Knox. And that is a case I have a lot of interest in, because I see that there's a possibility for, it's an opening of the gates for the law to be developed, in which governments cannot use its majority in Parliament to rush through legislation in such a way, or rush through decisions in such a way to deny access to the courts, because it's a denial of the protection of the law. And in Trinidad and Tobago at this time, it can be very relevant, because as you would know, the government had introduced a runoff legislation in order to change the rules for the general election, the upcoming general elections. That measure had a lot of criticism, and the bill was debated, but it was not proceeded with, and more than 8 months have passed. And recently the government has stated that it is going to go ahead with the bill, although the Parliament comes to an end in a few days' time, and general elections are due within 90 days after the Parliament is dissolved, which must be dissolved in a few days' time. So the objections to the bill were no consultation, that you cannot change the rules of election just before an election. And although the bill seemed that you can pass with a simple majority, there are important issues which you cannot change just before an election. So I think this case is important, because what the case decided was that there's a strong arguable case, and I just want to, I know Mr. Knox referred to it, but I think since it's a very topical event in Trinidad and Tobago, I think law students would like to look at this too, and lawyers would like to look at it. In the board's view, there is at least a strongly arguable case that a deliberate attempt made by one branch of the government, control of the governing party, to prevent individuals from obtaining access to the High Court for constitutional adjudication. So, very interesting in the development of the law, it may be that the Supreme Court of Trinidad and Tobago may have to determine, as the guardian of the Constitution, as to whether a government can, on the eve of a general election, use its majority to pass a law in Parliament when you will have a restricted period for a litigant challenging the proceedings in the court, a right that the litigant would have from the High Court to the right of appeal to the Privy Council. In conclusion, there is one other case that I was involved in. There was one case that I was involved in, and which involved a former Commissioner of Police from St. Vincent. The name of the case is Tuitt and the Attorney General. That was a case in which the Prime Minister Gonzalez went to the Parliament and he made a speech. And in that speech, he basically gave an attack on the former Commissioner of Police, made statements which showed that there was some political venom by him against the former Commissioner of Police, on the basis that it was his view that the former Commissioner of Police supported the previous administration. But at the same time, the government decided to acquire Mr. Tuitt's land for what he said was a public purpose. And the public purpose given in the notice in the Gazette was a learning resource center. So Mr. Tuitt filed a constitutional claim. And he filed a constitutional claim saying that this was not a genuine acquisition of the land. It was a sham. It was for a political purpose, not for a public purpose. So Mr. Tuitt applied to the court for the court to permit him to use the statements made by Mr. by Mr. Gonzalez in the court in order to show the court that this acquisition was not for a public purpose. The courts in St. Vincent and the Grenadines and the appeal court ruled in favor of Mr. Gonzalez. The matter went to the Privy Council, and the Privy Council said no. Mr. Tuitt was entitled, with notwithstanding parliamentary privilege, etc., was entitled to use these statements in order to show the motive for the acquisition. And it ruled also that although the Act in St. Vincent stated that the Speaker had to give permission for such matters to be used in a court of law, that Act which gave the Speaker those powers must be construed with such modifications as to give effect to the Constitution. So one sees the importance of the litigant and the importance of lawyers and the importance of judges recognizing that the court is the guardian of the Constitution. Mr. Tuitt subsequently won his claim. He won his claim for damages, and he has been awarded substantial sum of damages for the wrongful acquisition of his property. So in conclusion, may I say that the Supreme Court is the guardian of the Constitution, but the Supreme Court would not be able to perform that role effectively unless members of the public are encouraged by decisions to take matters before the courts when the constitutions are violated. And also the court would not be able to perform that function effectively unless there is continuing legal and judicial education for all members of the legal profession. Thank you very much.
Thank you very much, Mr. Maharaj. And those of us who witnessed the presentation would not have no doubt that the passion and zeal that he espouses is very real, and it actually belies the often felt thoughts that law is a very sterile thing, but in fact it's quite the opposite. It's so dynamic. The enthusiasm that is generated from being in this room and And hearing that would certainly underscore, I think, the zeal and passion that some of our...
The ILP, the MSJ, and the other political parties would split their votes. So therefore, they want to be able to prevent that. And so therefore, that is why the legislation is not for the peace, order, and good government of Trinidad and Tobago as the Constitution requires. The legislation is to try to keep the UNC and the partnership government in power. And it's for political purpose, and therefore it's illegal. It's a denial of the protection of the law.
Will you work with the opposition in order to
Oh yes,
help them?
certainly, certainly. If the opposition parties want me to assist them, we can put a team of lawyers together, and we'll be able to, with a combination of a team in Trinidad and Tobago and a team in London, and we'll be able to have it dealt with.
Okay, Mr. Maharaj, excuse. One last question. What could happen between now and before the dissolving of Parliament? What could be the play-off?
In the Parliament?
Yes.
Well, the Parliament is passing a lot of laws which are not properly, there are no proper consultation. And although the government has the majority, some of those laws may not be able to be properly tested later. I could tell you about the law with respect to squatters. They're misleading the population. A certificate of title does not give the squatter any right to land. As a matter of fact, it's only a temporary measure, and the government, after the elections, as they have done with other matters, can change the policy. So really and truly, that is an attempt to fool 60,000 squatters in Trinidad and Tobago for them to believe that they're getting land, when in truth and in fact, they're decisions of the courts in Trinidad and Tobago in which a certificate of comfort does not give you a right or a legitimate expectation to get any land.
So what does it give these squatters?
It just gives the squatter the peace that for a period of time no one will come to demolish their homes. That was the purpose of it. As a matter of fact, when I was Attorney General, the certificate of comfort was introduced by the then Minister of Housing. And the whole purpose of it was to put their mind at ease that until applications are made to the Land Settlement Agency, and if it is that it is possible to assign them to any land, their houses would not be broken down.
Getting back to the runoff bill, do you believe that this 8-month delay, I bring it right on the eve of the dissolution of Parliament, do you believe it's deliberate on the part of the government?
Well, I think the government was thinking not to proceed with the bill, and they were probably thinking that they would have struck a deal with probably the MSJ or the ILP. And I think that they now see that a deal is not possible, and therefore I think that has prompted them to decide to bring it back.
Do you think that people should stand up against this bill?
Well,
with the government using their majority to pass the bill?
I think everyone in Trinidad and Tobago, including members of the partnership, the electorate should stand up against it, because this is in effect telling the country that a government can use an election for political purposes and can use the Parliament to promote a political party. Now, the Prime Minister said, what is wrong in using the Parliament for that purpose? Well, that in law is criminal. That is misconduct in public office. The Parliament is to be used to pass laws for the peace, order, and good government of Trinidad and Tobago, not for the Prime Minister to pass a law so that she would get more votes, directly that she would get more votes. This is a kind of law that you didn't have any public consultation with. You had no consultation. You just came with it out of the dark and come just to pass it to satisfy 60,000 squatters on state land.
So you think that the election could be delayed by all of this?
No. The election cannot be delayed. Under the Constitution of Trinidad and Tobago, the Parliament must be dissolved on that date in June, and within 90 days, the general election must be called. The only thing to prevent a general election in Trinidad and Tobago is a state of emergency.
Okay.
And there is no state of emergency, and this partnership government is not well noted for creating a genuine state of emergency. So the Constitution of Trinidad and Tobago requires the Prime Minister to call a date for the election. She could keep it as long as she wants, but she has to call that date in a short while, and she has to face the polls. I know there may be anxiety and fears by governments which believe that they may lose, but the Constitution and the law provide that. They have to do it.
Okay, Mr. Mr. Maharaj, switching gears, we want to get a little bit about Mr. Jack Warner. How do you feel about this whole fiasco that has unfolded?
There's the latest allegations from the Egyptian government that
Yes.
he asked them for a bribe, and that they're not bringing that.
Well, you know, extradition proceedings. I was the Attorney General when the extradition treaties were negotiated between the United States of America, Britain, and England. And as a matter of fact, the Secretary of State, Mr. Warren, came to Trinidad and Tobago to sign that extradition treaty. In negotiating that treaty, it is recognized that the Americans and the British and the Canadians, in any extradition request, has to recognize that there is a presumption of innocence and there is due process of law. So the government would have to produce evidence that can be accepted in a court of law, that there is a case against Mr. Warner. And therefore, until that is done, there must be the presumption of innocence. Until that is done, there must be, as in all of these cases, criminal cases, presumption of innocence. So all that probably the Egyptian, the South Africans, the Americans, the British, whoever are saying, there has to be evidence of that in a court of law. Mr. Warner will be entitled through his lawyers to cross-examine and to show that there is no case against him. And that has to be done in the court. And Mr. Warner would be entitled, like any other individual, to apply to the magistrate to have the proceedings quashed on the ground of a breach of public law principles or on the ground of a violation of constitutional rights. Under Section 14 of the Constitution of Trinidad and Tobago, Mr. Warner can ask for the matter to be referred to the High Court to determine whether his rights have been infringed, and the Judicial Review Act of Trinidad and Tobago give him and his lawyers the right to go to court to apply for judicial review in respect of the matter. And in respect of all those matters, he has a right of appeal to the High Court and a right of appeal to the Privy Council. So this process can take 2 months, and it can take 5 or 7 years. This is not a process where, because a country asks for you to be extradited, you are automatically extradited. I mean, that is what we decided when we were negotiating this treaty, because you're asking a national or someone from Trinidad and Tobago to face trial abroad. And there are many other legal considerations. Are the offenses which you are charging Mr. Warner for, are they also offenses which, if committed in Trinidad and Tobago, can be prosecuted? And there are many other points that can be taken. I do not know the facts of the case. I cannot determine the merits of the case, but that is what the magistrate is going to determine, and if necessary, a judge.
Have Mr. Warner approached you for any...
Mr. Warner has not approached me for any assistance, but I've spoken to Mr. Warner, and he has spoken to me since his arrest.
Any comment on the walkout of the Prime Minister from the Parliament?
Well, that is a sign of desperation, because I think the Prime Minister had a duty as Prime Minister, having made the comment she made about Mr. Warner and having heard his response, should recognize that Mr. Warner is entitled. He's cooperating, as he said, and he's entitled to employ due process of law, which is a requirement under the Constitution, and the Prime Minister took an oath to uphold the Constitution and the law, and the Constitution gives to Mr. Warner and the laws give to him the right to due process of law. So she cannot overthrow due process of law for Mr. Warner.
Mr. Maharaj, last question. What were your topic of discussion when you and Mr. Warner had spoke?
Mr. Warner and myself have been friends. We have had our misunderstanding. And if you remember that we were on a political mission together, and then he and Mr. Dukran and Mrs. Bisessa decided to snatch him away. And I've remained friends with Mr. Warner, and we talk. But I don't think it's right for me to discuss what me and Mr. Warner talk
about. How do you feel about the whole incident with Mr. Warner? I mean, as a friend going way back when, and you all still maintain that relationship now.
Mr. Warner has assisted the UNC. I was in the UNC. He has given financial, political assistance to the UNC. He has assisted the Prime Minister. He has given financial donations to the party. In the last general election of 2010, if you wanted to give a donation to the partnership, you had to write 3 checks, 1 to the party and 2 to other individuals. it is well known the time will come when some of those checks would surface. So I do not know why people are trying to say that Mr. Warner did not help the UNC.
Do you have an idea how much money Mr. Warner pumped into the UNC for the 2010 general election?
When I was of influence in the UNC, Mr. Warner made substantial contributions. In the 2010 general elections, I know of Mr. Warner's assistance to the UNC, financial.
Are we talking millions of dollars?
Oh yes, millions of dollars, millions of dollars. And if Mr. Warner, if Mr. Warner pay a bill for the finance campaign, he's making a contribution to the UNC campaign. If he pays Mr. Ross, he's making a contribution to the campaign.
Were you privy to these checks, Mr. Maharaj?
I think they were.
All right, okay.
Ladies and gentlemen, I wish to formally acknowledge the presence of Justice Wilson Nelson of the CCJ, who's here with us. Justice Witt, of course, is also here. Justice Carol Rowan of the Supreme Court of Judicial, we're grateful that she's in attendance. We have, of course, Professor Rosemary Valentine, who's the head of the Faculty of Law at the University of Westmeath. Thank you so much. Ladies and gentlemen, our next presenter is Robert Strang of 3 Cambridge.
And the proper approach to constitutional rights in an emergency. The first question concerns the justification of a state of emergency. Declaring an emergency in 2011, the President described a spate of murders and a surge in gang violence. He said this was related to recent drug seizures. There was a risk of reprisals. Innocent people were caught up in violence between gangs. He said, the unprecedented escalation of murders and other serious acts of violence and lawlessness warrant the adoption of more decisive and stronger action to ensure the safety of the public. A common response was that this was not a crisis justifying emergency powers. In an exceptional crisis, the normal institutions of state might be disrupted or rendered inadequate by events or put under direct attack. When that happens, we tend to accept the state's use of emergency powers to perform its duty to protect us and restore the normal institutions to full function. The criticism of the emergency in 2011 was this was a different kind of case. The justification seemed to be that the emergency powers were needed to boost the ability of the state to perform its duty, allow it to act more decisively against crime. So the President's statement raises the question, what is a public emergency? And that debate entails the second question, who decides? We may find compelling arguments for saying the crisis described wasn't an emergency. But does the Constitution permit review by the courts of the decision to declare one? Or what should the scope of that review be? And the third question, raised by the invoking of emergency powers, is whether the emergency justifies the specific measures taken. The emergency regulations of 2011 restricted freedom of assembly and expression. They gave the government power to order indefinite detention without charge. Were they justified by the threat described? So the first question, was there a public emergency? Well, the Constitution provides that there's a public emergency when the country is at war, or when Parliament has by special majority declared that the democratic institutions of the country are threatened by subversion, or when the President has declared that a public emergency exists. And under Section 8, he may so declare if he's satisfied that a public emergency has arisen because A, a war is imminent, B, because of a calamity such as an earthquake, hurricane, Or section 8.2c, and this is the relevant one, that action has been taken or is immediately threatened by any person of such a nature and on so extensive a scale as to be likely to endanger the public safety or to deprive the community or any substantial portion of the community of supplies or services essential to life. In 2011, the President declared himself satisfied that the public safety was endangered. The public safety is a reasonably familiar, if broad, term. How much danger to the public safety constitutes a public emergency? Now, looking at subsection 8.2c as a whole, and at the other examples of a public emergency in the Constitution, we might posit that the danger to the public safety should be of a widespread and exceptional nature. And we get the same message from the international covenants. The International Covenant on Civil and Political Rights, of which Trinidad is a signatory, Article 4 says, "In time of public emergency which threatens the life of the nation, states may take measures derogating from their obligations under the Covenant to the extent strictly required by the exigencies of the situation." Article 15 of the European Convention uses a similar term, a public emergency threatening the life of the nation. The European Court has considered the meaning of that phrase. Its definition of a public emergency is an actual or imminent crisis whose effects involve the whole population and which threatens the organized life of the community. And the crisis must be exceptional in that the normal measures permitted to the state for the maintenance of public safety, public order, are plainly inadequate. In 1985, the UN promulgated the Syracuse Principles to expand on the international covenant, and they propose a similar definition to the European Court. And they say the crisis must be one that threatens the physical integrity of the population or the existence or basic functioning of institutions indispensable to ensure and project the rights recognized by the Covenant. And they go on to say that internal unrest doesn't qualify unless it's a grave and imminent threat to the life of the nation. There is actually one case where a court has considered the meaning of the phrase found in section 8.2c of the Trinidad and Tobago Constitution, and that was in Papua New Guinea, a case of Southern Highlands provincial government. In that case, the head of state declared an emergency in the Southern Highlands province, took control from the local government on the ground that corruption and bad administration had led to a breakdown in law and order. He said that was a public emergency, as defined in section 226c of the Papua New Guinea Constitution, because it was likely to endanger the public safety or to deprive the community of supplies or services essential to life. Rejecting that proposition, the court said an organized attack by criminals of wide-scale proportion on citizens or government, if it reaches a level which causes civil disorder or cripples civil government, may come within C. It's not intended to include ordinary criminal activities. So if we accept those definitions, there's plainly a doubt over whether the situation described in 2011 would amount to a public emergency. But who decides that question? Is it a matter for the court? Let's consider the Constitution first. We're concerned with the proclamation by the President. We saw that's provided for by Section 8. Then under Section 9, within 3 days the President delivers to the House of Representatives a statement setting out the specific grounds on which his decision was based. And the House must debate this statement within 15 days. The proclamation will lapse after 15 days unless extended by the House under Section 10. By Section 10.1, it can vote by simple majority to extend the emergency for up to 3 months at a time.
and no more than 6 months in aggregate. And after those 6 months, Section 10.2 requires that further extensions of up to 3 months at a time may only be made by special majority of both Houses of Parliament. So the Constitution sets a clear procedure for the declaration and continuation of a state of emergency, which is begun by the executive but ratified by Parliament. Can the court review those decisions? Well, the Constitution provides that a proclamation is not effective unless it contains a declaration that the President is satisfied that there's a public emergency in one of the categories. Now, if he must be satisfied, applying ordinary principles of judicial review, we might say the court can subject his satisfaction to a familiar judicial analysis based upon the Tameside case. In the words of Lord Diplock, did he ask himself the right question? And did he take reasonable steps to acquaint himself with the relevant information to enable him to answer it correctly? And that might entail checking that the President understood what he had to be satisfied of and assessing whether material existed from which he could reasonably be satisfied. So to do that, the first place the court will look will be the reasons given by the President, his statement setting out the specific grounds on which his decision was based. There lies a reason for caution on the part of the court. The statement is expressly for Parliament. It's to be presented to the House and debated. If the House has debated the grounds for the President's decision and found them adequate, there's an obvious reason for caution: respect for Parliament's constitutional function. The related reason is that the question whether there's an emergency is primarily a matter for administrative and political assessment and not a legal question. In the English case of A and the Home Secretary, commonly known as the Belmarsh case, the House of Lords said this was a matter of relative institutional competence. One issue in that case was whether the possibility of a terrorist attack could be said to be a threat to the life of the nation. Lord Bingham, with whom the majority agreed, found that there was no reason for the court to overturn the government's judgment that it was such a threat. On the question of the declaration of a state of emergency, he said that great weight should be given to the judgment of the Home Secretary and Parliament on this question, because they were called on to exercise a preeminently political judgment. And on the question of the court, of the role of the court in reviewing that judgment, he said the question was one of demarcation of functions, or relative institutional competence. In summary, which is a familiar principle, he said the more purely political a question is, the smaller will be the potential role of the court. And the present question was very much at the political end of the spectrum. Now that does not mean there's no role for the court. In the Belmarsh case, their lordships followed the judgment of Lord Hoffman in the case of Home Secretary and Raymond, where he asserted the importance of the separation of powers and the primacy of the executive's judgment in matters of security. But he also said it's important neither to blur nor to exaggerate the area of responsibility entrusted to the executive. I think the effect of the English authorities is that if there's material worthy of respect from which the political authorities could reasonably conclude that there is a public emergency, then the court won't interfere with that judgment. But if the court was satisfied there was no material from which to come to that conclusion, or that no reasonable person could so conclude, then it would be bound to say so. And if the court was satisfied from the material presented that the executive hadn't understood the question, it would have to find the declaration of a state of emergency unlawful. Now, that was the conclusion that Lord Hoffman came to in his dissent in the Belmarsh case. He accepted the Home Secretary's judgment that there existed credible evidence of terrorist plots which threatened serious physical damage and loss of life. But he held that when the government said, therefore there was a threat to the life of the nation, it misunderstood the meaning of the phrase. And that may be a question the courts will be asked to decide about the emergency in 2011. Could the situation described by the President be said to meet the definition of a public emergency? Was he describing a threat to the existence or basic function of the institutions of state? That said, if the courts were to rule the declaration of a state of emergency invalid, they would be taking an uncommon step. Lord Hoffman's judgment in Belmarsh was a rarity in challenging the government's assessment of an emergency. A survey of other jurisdictions shows almost no decisions by the courts rejecting the government's decision to declare a state of emergency. The Papua New Guinea decision in the Southern Highlands case stands alone. Well, we know the reason for that. The question whether there's an emergency is highly political. Also, perhaps more important factor, it's not really the most important question for the court. The more important question is whether the emergency justifies the specific measures curtailing fundamental rights. And with that question, the courts are on more familiar ground. They are performing their acknowledged constitutional role. They can employ tried and tested methods, and they can use those methods to express doubts about the emergency with less fear of overstepping constitutional boundaries. In Trinidad and Tobago, the question is set by Section 7.3 of the Constitution, which permits emergency measures to have effect even though inconsistent with fundamental rights, except insofar as they may be shown not to be reasonably justifiable for the purpose of dealing with the situation that exists during the emergency period. The phrase reasonably justifiable entails a proportionality test. That was decided by the Privy Council in the Antiguan case of De Freitas and the Ministry of Agriculture. And in summary, that test goes, the aim must be important enough to justify limiting a fundamental right. The measures designed to meet the aim must be rationally connected to it. And the means used which impair the right must be no more than is necessary to achieve that aim. So that's a familiar test. The courts here are on familiar ground, and they have a clear constitutional role. The question still arises, how much deference should they afford to the executive's judgment of what was necessary and therefore proportionate? In the Belmarsh case, their lordships held that the area of discretionary judgment afforded to the executive is much less when restrictions on fundamental rights are being assessed. Their justification for that, in short, was that while the government is the expert on security matters, the courts are the specialists on protection of liberty and other important rights. They also took account of the requirement of the European Convention that emergency measures controlling rights must be strictly required by the situation. That invited close scrutiny by the court of the action taken by the government. The International Covenant, in the Trinidad context, contains the same phrase. States may only take measures derogating from their obligations to the extent strictly required by the exigencies of the situation. And that would appear to require the same close scrutiny. But in Trinidad and Tobago, that may meet a countervailing factor in the form of what is a somewhat thorny issue, the presumption of constitutionality. The words of Section 7.3, which provide that measures stand unless shown not to be reasonably justifiable, seem to invoke that presumption and place a burden on the complainant. And that burden's been in place since the 1965 judgment of Chief Justice Wooding in Beccles and Delamore. But that presumption and that burden seem to be at odds with the presumption often expressed in rights cases that there should be a heavy onus on the state to justify infringements of important rights. The Belmarsh case being but one example. So this is another stage in the decision-making where the court will have to accommodate opposing constitutional principles. Turning to the Emergency Powers Regulations of 2011, I'll briefly set out some matters that might come under scrutiny. One remarkable factor is that it appears the government didn't design the regulations for the situation it found in 2011. Rather, as many of you will be aware, they were copied from the Emergency Powers Regulations of 1990. And those regulations, in turn, were a copy of the regulations of 1970. So the measures introduced in 2011 appear to have been originally designed for the emergency of 1970. The Black Power Revolution, civil unrest, general strikes. That must have implications for the presumption of constitutionality and the question of justification. Section 7.1 of the Constitution says the President may make emergency regulations due regard being had to the circumstances of the situation. Proportionality requires that measures must be designed for the threat and rationally connected to it. So why ban public meetings except by permission of the police, as Regulation 7.1 did? Or the use of loudspeakers in a public place, as Regulation 14.2 did? The use of those measures in 1970 is easily explicable, but it's harder to see why it was necessary in 2011 to counter gang crime to place those restraints on free speech and assembly. As for the cases now in the courts, we can expect them to challenge the regulations which boosted the authorities' powers of arrest and detention. And of those, the most intrusive provisions were those of Schedule 2 of the regulation. They gave the Minister for National Security power to order indefinite detention of a person without charge if he was satisfied it was necessary to prevent that person acting in a manner prejudicial to the public safety. If the courts apply the proportionality test to those powers, they may be asking, what was it about the emergency of 2011 that made them necessary? What reasons were there for saying the criminal justice system, acting under normal restraints, was inadequate to deal with the situation? Were they good reasons for setting aside fundamental rights and giving the government the power of detention? So, as we've seen, in doing so, the courts will also have to ask themselves difficult questions as to the extent of their constitutional role and where to find a balance between opposing constitutional principles. I look forward to hearing the courts of Trinidad and Tobago give their answers. Thank you.
Thank you very much, Robert. Very interesting discussion. And in fact, in listening to him, I was reminded a year or two ago, I was invited to prepare draft legislation dealing with national disasters in Trinidad and Tobago. And in the course of my review, I was actually, I thought, remarkable that it does not appear in our present legislation that there is any provision for the declaration of a state of disaster, a little different from a state of emergency, but the consequence is pretty much the same, which is by way of an act or way of a declaration that public safety can be secured. And in relation to that, our existing legislation does not seem to make or have enabling powers. In fact, in the draft legislation which is proposed and which I hope will eventually find the light of day, what is contemplated in terms of disasters in Trinidad and Tobago is that there would be a three-tier approach, whereby the first would be those disasters which are localized or regional, or which can be dealt with by the local services. The second would be a national disaster, which does not overwhelm the national capacity to respond and which can be dealt with nationally, and of course which may well require the invocation of a state of disaster. The third would be those disasters which does in fact overwhelm our natural and national resources and requires, if you like, a regional or an international response, which of course also requires both the invocation of the state of disaster and the necessity for some sort of global response. So certainly your invitation to us to consider looking at our legislation, which seems to have still been underpinned by the events of 1970, has a remarkable parallel in national disaster issues as well. So thank you so much for that very incisive commentary, Robert. Good. These papers have had a lot of requests from persons who are interested, not just persons who are here, but who would need or want access to these papers which are being delivered. And I'm sure you'll agree with me that by their very scholarly content, it does require some sort of permanent record. And I'm pleased to say that the TTLN will be, by very early next week, putting them in their entirety on our websites, which allows me to invite our presenters to please ensure, particularly our overseas presenters, but before you go, I would be grateful if you can send me electronic copies of your various presentations. It would be a very important part of the repository that TTLN is compiling. We have several people who are outside who wish entry in, and I'm very grateful to the principal of the Hugh Wooding Law School who has made the moot court available as an overflow, so that there are persons in that particular room who are listening and hearing us and perhaps even seeing us as well. And this applies as well globally, because we are televised and we are going on various radio stations as well. And many of these persons would have come, not specifically, but particularly to hear from our next presenter, who is Sir Fenton Ramsahoye. Sir Fenton was born in Guyana in 1929. He became a member of the Honourable Society of Lincoln's Inn in 1950 and was called to the English bar on the 10th of February 1953. Now he's coming to the podium, but I will invite him to have a seat, because I will not do him the injustice of not going through his bio. So, Sir Fenton, please have a seat while I complete this. It's a very important discourse. He was called to the English bar on the 10th of February 1953, and he took senior counsel in 1971. He took his Bachelor of Arts, his LLB, his LLM, and his PhD degrees from the University of London. And in fact, and I didn't know this, his doctorate was taken at the London School of Economics and Politics in 1959 for his seminal work in English and Roman Dutch law. His thesis was published in 1964 as The Development of Land Law in British Guyana, and he was awarded the LLD honoris causa by the University of the West Indies in 2012. He was made a Knight Grand Cross of Antigua and Barbuda in 2004 and was appointed Attorney General in 1961 when Guyana was given internal self-government. While Attorney General, he had drafted numerous legislation which introduced into the Legislative Assembly in 1963 the ordinance which established the University of Guyana. This is a very happy homecoming for him, because in fact he has worked tirelessly in promoting not only Caribbean jurisprudence but also the work of the various law schools. He was from 1961 a cabinet minister in the elected government, which was overthrown in 1964, and subsequently he remained a member of parliament sitting on the opposition benches until 1973. He worked for the Council of Legal Education as deputy director and had a responsibility for setting up our very law school that we are in, the Hugh Wooding Law School in Trinidad and Tobago. In fact, he was head of the law school when it accepted its first students from the Faculty of Law at the University of the West Indies in Barbados in 1973. Sir Fenton has been in regular practice in several territories of the West Indies and has appeared in the Privy Council on numerous occasions. In fact, for the past 50 years. He has appeared before the Caribbean Court of Justice on appeals from Guyana, which abolished appeals to the Privy Council in 1972, and which acceded to the Caribbean Court of Justice as its final court, or its final appellate court, in 2005. Ladies and gentlemen, please join with me in inviting Sir Fenton to present his paper, The Justice Trajectory Post-Independence.
Thank you, Ronnie. Ladies and gentlemen, I speak to you as one who has lived in the system for over 60 years. As a litigator, almost every day, every working day. And this is what I have to say now about the trajectory of the justice system before independence and after it. Within 2 decades of the end of the Second World War in 1945, the United Nations as an international organization was established, and the demand for independence of colonial territories, which had already been granted on the Indian subcontinent in 1946, became louder with each passing year. The British West Indies created a problem because the colonies were many and scattered, and while a benefit from their political unity was foreseen by the British, the colonies themselves were not unanimous at such a prospect. The British tried a policy of federation in 1958, but it did not succeed, and the territories went their own separate ways. They could not survive without the rule of law, and throughout the territories, a system of civil and criminal justice was developed to deal with contentious and non-contentious business. That system constituted the colonial inheritance which the territories which became independent enjoyed after the middle of the 20th century, when internal self-government and later independence were the signposts which ended colonial rule. The justice system was at the heart of the colonial inheritance when countries became independent. It was characterized by the reception of English law, which gradually overtook other legal systems with inherited laws from the French, the Dutch, and the Spanish. It was a colorful inheritance overlooked by imperial officials who were responsible for the creation of the legal framework in which the justice system was to be administered. From meager beginnings, the colonial system developed to the point at which a workable system of justice was in place at the end of the 20th century in every territory under the Pax Britannica. The system of justice in every colony depended upon the nature of its economy, and by that its efficacy was judged under imperial rule. In the West Indies, the economy was for the most part a plantation economy, with trade and commerce taking a less important place, apart from the trade in sugar and its derivatives. Inquiries into the administration of justice were undertaken from time to time, and the legal history of the West Indian territories recorded consistent development because of the imperial interest and the appointment of competent officials. Many of them had experience in other territories of the British Empire, where the same process was taking place. The West Indies did not have systems of customary law as there was in Africa and Asia, but the administration of a mixture of English law and practice with principles of law and practice of other European countries, which had ruled some colonies, was a challenge which had to be met. The uniting feature was that under British rule, the legal profession was drawn from persons who were required to be qualified in Britain in order to be allowed to practice in the colonies. The appointment of judges and other judicial officers was in the hands of the imperial rulers. The governor had some responsibility for the appointments of a lower order, but higher appointments were made by what was then the colonial office. With the passage of time, appointments were made from the colonial legal profession, and the colonial office relieved itself from the burden of finding appointees among the professionals in Britain and its dominions. For this reason, there existed at independence judges who owed their appointments to the colonial office but were drawn from the colonial legal profession. These judges were all men. They held high office with distinction at independence. Any fair analysis will conclude that at independence, the countries had a secure foundation to promote and sustain the rule of law. The justice system was, until independence, on an upward trajectory. The judges who served the justice system in the 19th and 20th centuries up to the time of independence, which Britain commenced to grant in the early 1960s, worked in a framework of courts which changed from time to time. The main institutions or courts described as high courts and supreme courts, courts of appeal, including the West Indian Court of Appeal comprising colonial chief justices, the Federal Supreme Court, and the British Caribbean Court of Appeal. Throughout this time, final appeals could be taken to His or Her Majesty in Council, but appeals were restricted, and the Privy Council had made it clear that it was not a court of criminal appeal and that it would defer to local courts where the judges were likely to be more aware of conditions in the territories than persons sitting in Westminster. When independence came, the legal environment, which had provided an improving system of justice, changed with the introduction of independence constitutions establishing an altered system of courts. Expansive changes in constitutional law came about because of constitutional guarantees which were sought to safeguard public rights and the public interest when the Pax Britannica came to an end. Changes brought about by the Treaty of Rome did not alter the legal position in the British West Indian territories, but when independence came, the work of the European institutions in the area of human rights soon became most influential, while the expansive reach of administrative law in Britain also influenced the legal systems post-independence. The legal environment began to change considerably, and for justice to be administered in legal systems with increasing sophistication, heavy burdens were imposed upon the judicial officers and the legal profession. The system of courts was not unified after independence, neither was the legal profession. Territories retained separate courts, appointed separate judges, and the legal profession was separate in each territory. The Caribbean Court of Justice was an attempt to have an overarching final appellate court to replace the Privy Council, but the courts, save for the Eastern Caribbean, have remained separate with their separate legal professions and separate access of litigants to bodies charged with the discipline of lawyers who repudiate ethical obligations. Prior to independence, there was a link between the education of colonial lawyers and the system of legal education in England. Post-independence, the link was almost entirely broken because lawyers are trained within the territories under a system with a council of legal education at the apex. The right to practice involves accreditation by institutions of the Council. The characteristic features of the system of justice prior to independence was a common training in Britain before admission to practice and rigorous discipline in the work of judicial tribunals and judicial officers. It is these features which saw the absence of the most serious infection which has affected the legal system post-independence, and that is delay, which has become the system's characteristic affliction in most territories. Adjournments are many and easy, and this is the result of indiscipline. Judges and lawyers are to blame. A system whereby in the high courts a matter is passed from hand to hand among judges contributes to this. A judicial circuiteer has no sense of responsibility for any matters, even though the rules allow the same judge to deal with a matter so long as this is practicable. It is always practicable, unless administrative fault makes it impracticable. Once heard, a litigant may suffer enormous delays in having judgments delivered. This was never the case prior to independence, but it is a feature now. The question may be asked, why this is so? The answer is that persons who have the responsibility are not able, ready, or willing to undertake it, even though delay hurts litigants and bars them from proceeding to appeal if a judgment is adverse. It has been declared in a judgment arising in Trinidad that the Constitution of Trinidad and Tobago does not provide for a hearing within a reasonable time, and so the benefit of that particular guarantee, which appears in all the other independence constitutions, is not available in Trinidad and Tobago. It is perhaps appropriate to say that the common law has always assumed a fair hearing within a reasonable time. For that reason, judges made efforts to empty the jails where persons awaited trial. The principle can be no different in relation to civil cases, where delay can and will amount to a denial of rights. Judges must be aware of this. The constitutional guarantee will not add to their awareness. The West Indian Territories inherited a system with Magna Carta as one of its foundations. When King John was asked to agree to the clauses of Magna Carta, one was a promise that only qualified persons were to be appointed justiciars. They administered justice in the king's name. What was expected was that persons sufficiently learned and with intellectual and moral integrity were to be appointed. 8 centuries later, there is still in these territories a doubt whether the promise has always been kept. Once in argument before the Privy Council, I felt obliged to observe that the Constitution spoke of an impartial tribunal, but it did not mention a competent one. Lord Gough, who was on the bench, responded by saying that surely the provision must mean a competent tribunal. He was correct. The problem is whether those responsible for the creation of the tribunals to which the constitutions refer always understand it in that way. The infection of delay has not affected every territory in the same way. In some territories, it is far worse than in others. And for that reason, there is usually a backlog of cases which will never be dealt with in the system. Litigants and witnesses, as well as lawyers, die during the delay, with the consequent loss of rights and the denial of obligations. The delay in delivery of judgment may be caused by different reasons, but a judge who is assisted by competent counsel who set out the facts to be ascertained, the issues to be resolved, and the authorities which are relevant, ought to be able to deliver judgment at the end of the hearing without delay. It may take some time to write a judgment and to have it printed and circulated, but that ought not to involve the kind of delay which will hurt a litigant who will usually crave a written judgment. A delay bars the entry of an appeal, and this is a serious breach of a court's constitutional obligations if the delay is longer than is necessary for a competent tribunal to do its work. Where there is delay, a litigant must wait. If the delay takes place in the higher courts, he can complain to no authority. Complaints to Chief Justices have been known to be useless where other judges have caused litigants to suffer by delay. The independence of the judiciary is considered to be an ever-widening concept which embraces immunity for causing harm and loss to litigants. It is part of the legal historical tradition that judicial power should be exercised by persons with learning and with intellectual and moral integrity. In the system we have inherited, this burden is put upon lawyers who have earned distinction in the practice of law. A culture in which it is believed that a person is qualified if appointed, against one in which a person must be qualified to be appointed, can lead only to decline and the subversion of the rule of law. At independence in the 1960s and later, it was thought that the problem of judicial appointments can be resolved by independent service commissions. The system has not worked. It has made little difference to who gets appointed because the considerations which lead to appointments are varied. There has been constitutional change in one territory where judges are appointed on the recommendation of a prime minister. This will only work if the prime minister can be the subject of criticism in Parliament, but that is unlikely to happen. No West Indian Parliament has seen any such criticism, be it of a service commission or a prime minister. The bar is still divided, as it was prior to independence, into an inner and outer bar. It has come about that the system of elevation has been abused in some cases because elevation has become the reward of political patronage rather than for professional distinction. In these cases, elevation to the inner bar has become a license to secure higher fees for those who have the fortune to have been elevated without achieving professional distinction. Legal education has been delinked substantially from Britain and remains costly if undertaken abroad. The system post-independence has suffered from underfunding, and this has led to decline in the strength of teaching. Political aspirations call for a lowering of entry requirements so that legal education will become available to more aspirants, and this reduces the level of competitiveness which generates distinction. This situation is unlikely to improve because the economies are weak and the call upon resources continues to limit what can be made available for education, including legal education, which is the main support of the rule of law. The trajectory of the legal system has been downward. It was stable at independence, but the changes which have come about since then have led to decline. An analysis of the work by judicial functionaries shows that they are fair and not compromised by reason of character. Only in one of the territories is it known that justice is bought and sold like a commodity. In that territory, appeals to the Privy Council were abolished within 6 years of independence, with the object of preventing the development of a legal system removed from political control in the administration of civil and criminal justice by removing the independent judicial body, which was at its apex. Hair-raising complaints are made about persons who are highly placed to administer justice, but compromising judges is not a widespread post-independence feature of the justice system. Judicial integrity post-independence is hardly ever assailed. The colonial system of justice owed its originating allegiance to two of the great legal systems of the world, the Roman and the English. Roman law did not influence the development of the law of ownership of immovable property or the law of procedure, which was inherited, but it was pervasive in many areas of private law, including the law of servitudes, which is a considerable part of the law of property. Many of the concepts which are used today are derived from Roman law and were integrated for over 8 centuries with the common law, which was developed and was passed down to the colonies while the imperial power carried out the responsibilities of government. It was a striking feature of the justice system that at the end of the colonial period, strong foundations had been laid, and responsibility for maintaining and improving the system was transferred to the newly independent nations. Even where some territories remained dependent, it was expected that they would participate fully in the maintenance and improvement of the inherited system. If the question were to be asked whether there was confidence in the system when colonial rule came to an end, the answer, an affirmative answer, was likely to be forthcoming. If the same question were to be asked of the same period since the independence movement took root, the answer will be different. The political systems which developed after independence came did not produce effective legal administrators in all the territories. Some fared better than others, but the system as a whole is in decline. At independence, the imperial rulers offered to provide a final court at their own cost, while members of the legal profession in Britain always stood ready to give of service. Nationalism provided the urge to break with the final court, and the establishment of the Caribbean Court of Justice was the response. The Caribbean Court of Justice will not stop the decline which came about by reason of the failure of discipline and the absence of the required sense of responsibility which became pervasive within the independent justice system. A litigant desiring to settle a dispute of importance must have his case heard usually by a high court and a court of appeal before it can reach the Caribbean Court or the Privy Council. The two preceding steps along the way can be characterized by delay, and very often there is a failure to write reasons for what is decided in the High Court or the Court of Appeal. This can also cause delay. In this respect, standards vary within the territories because there is no unified system of courts and procedure and no unified legal profession. These two features are the source of much of the decline in the efficacy of the justice system. It is a truism that once the system is allowed to weaken, it quickly reaches the point where it becomes irreparable. In that event, money thrown at it will be found to be useless or ineffectual. These matters are usually the subject of statistics, but there is little publicly available. If funding was provided, there will be lawyers and research students to study the cases, the judgments dealing with the grant or refusal of leave where required, and final or interlocutory adjudications with appropriate commentary from qualified persons who have researched and digested the documentary material. It is of the greatest importance that for every territory, The public should have statistics of the number of cases brought, the number determined, the number of judgments written and by whom, and the figures showing how many cases were brought and abandoned along the way for one reason or another. Despite rumblings that the Caribbean should resort to its own courts for the settlement of disputes, the Privy Council remains willing as a matter of constitutional obligation to hear appeals. Whether an appeal is heard depends upon whether an appeal is of right or whether it is heard by special leave. The system is restrictive, but it is necessary if numbers of matters dealt with are kept within bounds. But it happens that many litigants are aggrieved by the refusal of the Privy Council or the Caribbean Court to refuse to hear an appeal, and there is no further tribunal to which resort can be had. The final courts remain supreme, even though they may sometimes be fallible. A justice system is not an imposed institution. It develops from need and is organized from time to time as society develops. There is a societal aspect in every element of it. It involves issues relating to race, class, and gender. The system seeks to resolve the varied problems arising from economic and social activity, and of late, the rise in technology. For anyone to understand how the system works, it is necessary to consult the reports in the media, where publicity is available. But the surest source of information is the lawyers and litigants who, as of this time, a half a century after independence, have the most harrowing stories which involve delay as well as wasted costs and expense. The situation is confused because judicial officers and lawyers share blame, while governments always claim that budgetary constraints prevent them from doing all that may be needed for a properly functioning system. The reality is that there is much mismanagement in the administration and wasted costs as lawyers and litigants who use the system become aware. Lawyers within the system are of varying abilities and character, and the system loses many of them in court practice because they become frustrated and decide to avoid any kind of court work. Much talent is lost by this process because it is pervasive. Unless the court system functions efficiently, lawyers in litigation, who tend to be the ablest that the profession can produce, realize that they cannot earn sufficiently by a dilatory system, and their departure from or avoidance of it accelerates the decline. These changes have increased since independence as frustration increases. The guarantee of a fair hearing within a reasonable time by an independent and impartial tribunal is of no benefit unless it is enforced by skilled judicial officers, an effective administrative organization of the courts, and a competent and honorable legal profession. A constitutional framework for the justice system was put in place at independence. There was agreement that the Privy Council, which was at the apex of the colonial legal system, would be retained as long as it was needed. Its retention reflected a desire that competence and independence should underscore the work of the final court, and there was ample provision for appeals involving matters of substantial monetary value to be allowed as of right. The bar was not set high, and while the appeals were to be heard in England, there were members of the legal profession there who were always willing to lend support to practitioners both before and after independence. Writing on the rule of law, Lord Bingham observed that in some states of the southern United States and in parts of the Caribbean, The poor quality of defense representation is a source of unfairness. The reality is that there is no effective system of legal aid because funds are always inadequate for a program which will enable the more competent and skilled practitioners to represent litigants who have important issues but cannot meet legal costs. Even where a litigant meets costs from his own pocket, the costs may be wasted for inefficient or unskilled representation. The criminal justice system's failure is enormous. Persons await years before trial and may suffer loss of liberty in the meantime. Excuses for delay proliferate, including a regular one that the court file cannot be found by the prosecutor or witnesses have not yet been found. One lawyer in Barbados described himself in terms he considered appropriate. He says he was not a lawyer, but an adjourner, because he was made to appear many times without being able to secure a hearing for his client. This event fades into insignificance when one considers the laxity with which judicial officers grant adjournments for reasons which are contrived in a system in which part-heard cases generate delay. So long as there is under the rules of procedure the power to adjourn cases, there will be abuse with resulting delay and judicial injury to litigants. Theoretically, the legal system presents opportunities for a widening of jurisprudential concepts, but this is at a higher level. The injustice which most affects litigants because of delay in hearing and the delivery of judgment. It is related to the legal skills of those who adjudicate, but standards are falling in the legal profession. The field is written in the English language, but this is the language in which performance at the tertiary level in the universities is weakest. Many lawyers are not sufficiently competent in English to be involved in legal practice at a satisfactory standard. There is political pressure everywhere to ensure that an increasing number of people secure the declaration that they are qualified professionally, even where standards of entry and standards of academic competence have to be lowered so that politicians who provide funding can see such a result. This is a unique post-independence phenomenon. It is a major contributor to the degradation of the justice system. Independence did not destroy insularity. The legal systems remain separate and distinct, and the functionality of the justice system must be judged with reference to each country separately. Where a system is dysfunctional, the lawyers and litigants are aware and they bear witness to decline. The effect upon social and economic activity becomes apparent with each passing day. An independent judicial system is inconsistent with autocracy and despotism. And during the last 60 years, there have been cravings for control of the justice system and the abrogation of its independence in at least one territory. The Privy Council and the Caribbean Court of Justice will not defeat this functionality because that is generated at the lower levels of the system, over which those two final tribunals have no control. It is the task of the government, the appointed judicial officers, the administrative functionaries, and the legal profession to maintain the system and to resist decline. The system becomes dysfunctional when they fail to fulfill their obligations and to discharge their responsibilities. They cannot be supervised. There is no imperial master. It is a case of self-discipline or no discipline. A sense of responsibility is inherent in the human condition. A functionary suppresses it at his peril. There are not many lawyers in the former British territories of the Caribbean who worked in the period before and after independence came, and who are still alive to record the anxieties of clients and the frustrations engendered by the justice system as it is known today. A century from now, lawyers, scholars may wish to know what was the daily experience of those who served within the system at this time. It is to be hoped that all inquirers will be told that the lawyers knew the importance of the rule of law, and the work they have done was intended to serve those who relied upon the justice system for their protection, even though their success varied. The years between 1950 and 2015 mark a unique period, culminating with the anniversary of Magna Carta, which marked the concessions given by King John to the barons 800 years ago. The justiciaries of the 13th century and the judicial officers who followed them carried an immense burden which they still carry today. The manner in which the burden has been discharged has varied from territory to territory and from time to time. But while the justice framework continues to exist, the burden will remain while litigants hope that the responsibilities will be discharged. Those who have served the states and the litigants from the benches and the bars have had a unique privilege. They have been privy to both an upward movement and its decline. The questions for the future are whether the decline can be reversed and whether societies which will not sink can survive by adjusting to the changed conditions. The national cultures over the past 2 centuries have been influenced by the legal systems and the kind of justice which was and is being produced. People must live within the system. If rights are denied, and obligations are dishonored, without any adequate redress, there is none to complain to. The justice system does not take directions, and there is no one and no authority to correct it. It determines for itself how its responsibilities are discharged. It knows that the rule of law is of the essence of civilization, and if it fails or is subverted, economic and social consequences which no one intends will surely follow. A nation must adjust to failure in the same way as it enjoys success. Institutions are administered by individuals who may poison them or preserve and improve their strength. That is always an option. The justice system we inherited is a proud inheritance, born of the ablest communities the Western world has known. It is hard to lose that inheritance or to allow it to be lost. To remember it is to inspire ourselves to adjust and readjust so as to leave for those coming after us the kind of inheritance of which we have been a most privileged beneficiary. Thank you.
Thank you, Sir Fenton, for that very powerful paper entitled The Justice Trajectory in Post-Independence. Yes. Earlier I told you I was intrigued by the title, and perhaps some of you were as well, and having listened, certainly Sir Fenton's views that the justice trajectory is downwards, and there is a certain amount of pessimism associated with his remarks. Certainly from a civil proceedings point of view, and those of us who are involved in Trinidad and Tobago in the civil arena will recognize that the civil proceedings rules, which took effect, I think, in 2006, has to some extent addressed, and I think functionally addressed, the many delays that were embedded in our institutions, and happily for us, and I practice in the civil courts, I can say happily, the delays that may have occasioned before are not as apparent as they are. In fact, many matters are being resolved as quickly as possible, so that there is some room, Sir Fenton, in Trinidad and Tobago, certainly from the civil arena, for optimism that not only our judges are dealing with matters decisively and quickly, but that judgments are being delivered with one or two exceptions generally. So it's something that we applaud and certainly which we encourage. But thank you so very much for that very, very powerful, incisive commentary. Our next paper is being delivered by James Guthrie, Queen's Counsel. Miss Guthrie was called to the bar in 1975 and took silk in 1993 and was made a recorder in 1999. He has considerable experience of litigation in most Commonwealth jurisdictions, both in an advisory capacity and as an advocate, and has been called to the bars of variously the Turks and Caicos, St. Lucia, St. Vincent and the Grenadines, Trinidad and Tobago, St. Christopher and Nevis, Grenada, Bermuda, Belize, Antigua, and the Cayman Islands. He's truly a Caribbean man insofar as to his juridical attempts and juridical practice. He is, was in fact head of chambers at 3 Hare Court from 2002 to 2010. His current work, that's in 2015, is in several categories of constitutional law, human rights, judicial review, and civil fraud. These cases typically involve either appellate work or work that is connected with the Judicial Committee of the Privy Council, both at first instance and at appellate levels, and in fact in many Commonwealth countries, including Trinidad and Tobago. He regularly acts for Commonwealth governments and law officers. And in fact, and I noted this with interest, that he appeared before the Privy Council at his very first sittings outside of London. This would be in the Bahamas, and his first sitting in Mauritius in 2008. He has also appeared by special permission in the Court of Appeal of Mauritius. Guthrie has regularly appeared in fraud and political and criminal matters in the Caribbean, with current cases in Jamaica, Antigua, Belize, the British Virgin Islands, St. Kitts, St. Lucia, Dominica, and the Cayman Islands. Therefore, ladies and gentlemen, I'm sure, as me, that we are eagerly anticipating his paper, which is entitled Judicial Bias.
Thank you very much, ladies and gentlemen. I have actually spoken in this very room once before, and I'm ashamed to say it was 25 years ago when I was teaching a short course on advocacy. I don't know whether any of my former pupils will be here. It's of course an enormous pleasure to be back, and I have been back on many occasions since then. Most notably when Ramesh Maharaj instructed me to appear on his behalf in 2001 in the cases involving the previous election and the possible disqualification of 2 of the elected members. Also in that case were others present in this room, most notably, of course, Sir Fenton, also Fayyad Hussain. And all I can say is that it gives me the greatest of pleasure to see that their independence of mind and idealism remains undimmed, and that certainly all 3 of them remain in what I can only describe as showroom condition. Now, my topic is judicial bias, and I think it perhaps follows on reasonably smoothly from Sir Fenton's concerns about the system which we have to operate with. I chose it because it provides a neat example of the application of common law and constitutional principles to our work as lawyers, if not necessarily every day. Bias is, of course, rather a provocative concept. We hope and we like to believe that our judges are free from any taint of it. I would nevertheless suggest that the price of such freedom, as of any other, is unceasing vigilance, and that means unceasing vigilance by us, the lawyers. Now, at least three overlapping principles are involved with the avoidance of bias. It is more usually, of course, the avoidance of apparent bias, but the principles include judicial independence and the separation of powers, about which we've already heard something today. And the importance of those principles hardly need restating to the company assembled here. They're fundamental to the common law. They're enshrined in the constitutions of the free world among the fundamental human rights and freedoms provisions. And as to the values, the Commonwealth constitutions of the Caribbean speak with one voice. Now, actual judicial bias, or demonstrable actual judicial bias, may be rare, but of course it has been demonstrated from time to time. One of the first occasions on which I had the pleasure of appearing with Mr. Maharaj involved actual judicial bias. I understand that the judge concerned has since distinguished himself and redeemed his situation, so I won't mention his name, but he was a magistrate here, and he acquitted, some say rather surprisingly, a defendant charged with money laundering offences. That might have been that if he had not been unwise enough to have to take delivery of a large car the following week. When the paperwork was looked at, it appeared to have been paid for by the gentleman who had been acquitted only a few days before. He's now served his term of imprisonment. It's a very long time ago, and as I say, his name does not require to be mentioned. But much more usual is apparent bias. The relevant test for that is now well established, and it has been since its refinement in 2001 by the well-known case of Porter and McGill. In a recent Privy Council case from the sovereign base areas of Cyprus, Yaqub, Lord Hughes said this: "The relevant test is not in dispute. It was set out by Lord Hope, with whom the remainder of the court agreed in Porter and McGill. It is entirely consistent with the approach of the European Court of Human Rights to the requirement that a court be impartial, not only in fact, but from an objective viewpoint. Lord Hope expressed the test in these terms: the question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased." That and similar formulations use the word biased, which in other contexts has far more pejorative connotations, to mean the absence of demonstrated independence or impartiality. Lord Hope made this clear in the case of Miller and Dixon. The appearance of independence and impartiality is just as important as the question whether these qualities exist in fact. Justice must not only be done, it must be seen to be done. The function of the right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires this matter to be viewed objectively. The aim is to exclude any legitimate doubt as to the tribunal's independence and impartiality. So the cases emphasize that it is the appearance of justice that counts. In Pinochet, which you'll all know, Lord Nolan said, "In any case where the impartiality of a judge is in question, the appearance of the matter is just as important as the reality. It is no answer for the judge to say that he is not in fact impartial, or he is in fact impartial, and that he will abide by his judicial oath. The purpose of the disqualification is to preserve the administration of justice from any suspicion." Now, in the Caribbean context, complaints of judicial bias can be articulated in straightforward constitutional terms. What can be said is that the case concerned has not had a fair hearing by an independent and impartial court. That right is equivalent to the fair trial guarantee of Article 6 of the European Convention, and it is enshrined in the common law. Now, the consequences are these. If the complaint is upheld, then that is the end of the matter. The consequences may be inconvenient, they may be extreme, but that does not matter. The judge's decisions and orders cannot stand. The qualities of judicial, I'm quoting here, the qualities of judicial independence and impartiality are absolute and permit no compromise. And I take that statement from a case in Brunei involving the son of the Sultan, who said that nobody could give him a fair trial there because the Sultan was the plaintiff effectively and he was the defendant, and no court would decide against the Sultan. However, as we shall see, he was wrong. But the sanction that the law affords is that the court's decisions will be set aside, and that will be that. I think on reflection, it will be accepted that that must be so. The clearest explanation, perhaps, was given by Lord Hope in Miller and Dixon, a case which you may know, but involved the terms upon which temporary judges were appointed in Scotland. They were appointed on one-year renewable contracts, and it was held in those circumstances because their continued employment would be in the hands of the executive on a fairly regular basis. They could not be regarded as safe hands to decide persons' rights. And Lord Hope said that the right was fundamental to the right to fair trial. And just as the right to a fair trial is incapable of being modified or restricted in the public interest, so too the right to an impartial and independent tribunal is an absolute right. It is an essential element if the trial is to satisfy the overriding element of fairness. It has to be judged, ladies and gentlemen, for the moment that the judge or tribunal first becomes seized of the case. It stands apart from any questions which may be raised about the character or the quality or the effect of any of the decisions that the judge which the judge makes in the proceedings. If circumstances exist which give rise to a suspicion about the judge's impartiality, those circumstances are sufficient to disqualify, although in fact no bias exists. That was the rule which was applied in Pinochet. The result was in no way dependent on the judge personally holding any view or having any objective requiring the question whether Senator Pinochet should be extradited. The fairness of the proceedings is not what is in question, but it is impossible to uphold it if the issue of the judge's fairness itself is decided against him. So it makes no difference at all if the orders made by the judge may be justified, or even if they were made by consent. And that was the case in Miller and Dixon. Some of the defendants tried by the judges concerned had pleaded guilty, but their pleas had to be set aside because the judge was not sufficiently independent to be sitting in the court at all. So, members of the jury, there are two Caribbean cases which I would like to mention. The first comes from Belize, and it deals in particular with the concept of the notional fair-minded and independent observer, who is the person whose objective assessment of the situation provides the relevant test. The case is called Belize Bank and the Attorney General of Belize, and the circumstances were briefly that the new government of the day, this was in 2011, had appointed an appeal board, and the appeal board was to hear complaints about the government's predecessor, complaints which had a political character. So the case was both political and it was fact-sensitive. It resulted in a majority decision in the Privy Council, rejecting the complaint of apparent bias, but with an interesting and, I think, persuasive dissent by Lord Brown. The contribution to principle as I say, is most notably to be found in the discussion of the attributes of the notional observer. Lord Kerr, who delivered the leading judgment, said this: "The notional observer must be presumed to have two characteristics: full knowledge of the material facts and fair-mindedness." One should recall Lord Steyne's approval in Lowell and Northern Spirit of Mr. Justice Kirby's comment in Johnson & Johnson: "A reasonable member of the public is neither complacent nor unduly sensitive or suspicious." And Lord Hope had said in Gillies and the Secretary of State for Work and Pensions, "The fair-minded and informed observer can be assumed to have access to all the facts that are capable of being known by members of the public generally, bearing in mind that it is the appearance that these facts give rise to that matters, not what is in the mind of the particular judge who is under scrutiny." Of course, one needs to be alert to the danger of transforming the observer from his essential condition of disinterested yet informed neutrality to that of someone who, by dint of his engagement in the system that has generated the challenge, has acquired something of an insider's status. The phrase "capable of being known" from Lord Hope's formulation holds the key. This does not signify a need to restrict the material to that which is immediately in the public domain. It acknowledges that the observer must have such information as may be necessary for an informed member of the public without any particular specialized knowledge or experience to make a dispassionate judgment. As Lord Bingham put it in the Prince Geoffrey case, the requirement that the observer be informed means that he does not come to the matter as a stranger or complete outsider. He must be taken to have a reasonable working grasp of how things are usually done. Now, that seems perhaps to be all very well, but the case provides an example of the difficulties that the application or the imagination of such a person leads to in practice. In considering the notional observer, the Chief Justice in Belize, who was hearing the case at first instance, referred to the ordinary person in Queen Square Market. In the Privy Council, Lord Dyson referred to the fair-minded and informed Belizean. He said that the local context was important and that deference had to be given to the local courts on the issue of what the Belizean observer would have thought. Lord Brown was critical about this. He said, "Lord Dyson suggests that the board should recognize that the judges of Belize are better equipped than we are to assess how the fair-minded and informed Belizean would view matters. With the best will in the world, that seems to me to come close to urging an abnegation of this board's proper role in so politically fraught a case as this. Ironically, the very last Belizean appeal to come before us. I had always understood that role to carry with it the responsibility for ensuring, to the benefit of Belizeans themselves and of their standing in the wider international community, that the highest international standards of justice are maintained in that country. On the issue of apparent bias, there can certainly be no stronger case for deference to the Belizean judges than the Strasbourg court would afford our judges on a complaint originating in the United Kingdom. I do not believe the Strasbourg case would reject a challenge to the United Kingdom in a comparable case." So the question, which I leave open for present purposes, is whether any safe distinction can be made between the views of a notional observer and the views of the court itself. Can there really be a difference in principle? The court must apply an objective test. Has the administration of justice been compromised? And then it has to ask, well, what would the fair-minded and informed observer think? And that is, of course, the question when these problems come up, that you, as lawyers, will be asking yourselves to apply. We're worried about possibly the judge's connection to a particular part of the country or a particular business which is affected by his decision. And you ask yourselves, well, what would a fair-minded and informed observer think about that? Now, the second Caribbean case that I wanted to mention is from St. Vincent. It involves the application of the same test to a different situation. What is to be done when a judge expresses views that indicates his mind has been made up. And I mean, of course, made up before the time when he's supposed to make it up. Now, in Mitchell and George's, which was decided at the end of 2014, a number of us, and on this occasion I actually mean a number of us present in this room, were concerned with remarks by a judge sitting as a commissioner in an inquiry. I appeared on one side with Mr. Maharaj and Mr. Strang, and my learned friend Mr. Rowe appeared on the other side. Although he cancelled at the last moment, we would also have had Mr. Astafan here, who had appeared at an earlier stage of the proceedings. So I suppose if I get this wrong, there'll be a number of people who will be able to put me right. But the judge concerned was sitting as a commissioner in an inquiry into conduct alleged against the former Prime Minister of Belize, Sir James Mitchell. I'm sorry? St. Vincent, I'm sorry, what did I say? I said Belize, good Lord. I knew I'd be put right. In St. Vincent, there had been an unsatisfactory attempt to develop an island for tourist purposes. And it was known as the Otley Hall Project. And Sir James Mitchell came in for a good deal of criticism. And the new government, which took over from him, thought that the way to deal with this would be to appoint a commission of inquiry to look into the matter, which obviously had political overtones. And such commissions of inquiry, as you will know, are not unknown in this part of the world. It's not unknown that new governments institute them for the purposes of investigating what has been done by their predecessors and making such political capital out of it as they think they can. Anyway, in the course of an interim report, the judge made a number of remarks which suggested that he had not been impressed with Sir James's part in the project. Sir James challenged those decisions by way of judicial review and sought orders that the judge concerned, Mr. Justice Georges, should play no further part in the commission of inquiry. Now, he succeeded in the High Court. I'm sorry, Sir James Mitchell's case was unsuccessful in the High Court and the Court of Appeal, and the criticisms that he made of the judge's lack of independence and bias were rejected. But he succeeded in the Privy Council, and I would respectfully suggest that he obviously should have succeeded in the Privy Council, because when one hears what the judge had to say about him in his interim report, it was, well, I'll read you an extract from the report, or from the Privy Council's summary of what the report said. It contained far too many firm statements of the misbehaviour of the appellant. The judge's conclusions may be summarised in this way. Armed with knowledge of the deception, the appellant continued to provide assistance to the developer, which facilitated his fraud. The appellant, that is Sir James Mitchell, was the moving light behind the project. His failure to inform the Cabinet and Parliament was inexcusable. The decision to exclude senior members of the public service was obviously made by him, which suggests that such action and deliberate failure to act in accordance with the law was tantamount to misbehaviour in public office. Now, that was not all. Those sorts of remarks continued over a number of pages. And the reason I draw them to your attention is because the Privy Council said, well, what reaction would the fair-minded and informed observer have when they heard that the judge, at an interim part of the case, had reached such firm conclusions against one of the parties before he had heard all the evidence, before he had investigated the whole of the facts. Now, the judgment was couched in fairly polite terms, but Lord Clark said this. He said, the extracts from the report set out above strongly support the conclusion that having regard to the context and all the surrounding circumstances, the fair-minded observer would conclude that there is a real possibility that the respondent had made up his mind by the date of the interim report that the appellant was at the heart of the wrongdoing which led to the project and its collapse, and would not be willing to change his mind so that his final report would not be impartial. So that focus on the impartial observer led inexorably to the conclusion that the judge was not independent and impartial, and that meant that his participation in the commission had to be put to an end, and an order was made preventing any further part in the inquiry. Now, I suggest that that was plainly and obviously the right application of the test. What would the fair-minded and independent observer have thought? And I suggest that it emphasizes the need for us lawyers to keep that test in mind. Because although it's worth noting that that case, as I've summarized it, and as I believe it was straightforward and led to a clear result, that wasn't what happened in the High Court or in the Court of Appeal. They had both found against Sir James, and if the matter hadn't been taken all the way, the inquiry would have continued. And if the inference is right, he would have been held up and put into disrepute by someone who lacked the attributes of the independent tribunal. He would not, in effect, have had a fair hearing. He would have been denied the right to which the Constitution guarantees him. So that is why I believe that the test is important, and that if it is not strictly applied and upheld, justice will suffer. And it is why I believe that the freedom from judicial bias deserves our unceasing vigilance, by which I mean the unceasing vigilance of all of us. Thank you very much.
James Guthrie, QC. Very compelling paper, and in discussing it, of course, and one thinks of, the reference in the Belizean case to the informed, or rather the fair-minded and informed Belizean, and I could not help but reminded, of course, of the test of the reasonable man in the Clapham omnibus case, of the reasonable man test. And what is clear is that there are two different people and two different tests. I'll be intrigued to see what is, in Trinidad and Tobago, whether or not the person in the St. James maxi taxi falls within one category or the other. It may well be something that we can look forward in the future. Many of you know that the TTLN is a membership organization. It is, in fact, governed by a board of directors, but we are driven by our constitution to have members who appoint the board. And we are very fledgling. We were only appointed on the 28th of April of this year. But one of the reasons for inviting your attendance here is to give you some insight into what we do and to invite you to consider being a member of our organization. And in your registration packages, you would have received a little note inviting you to provide some contact information so that we can have a continuing relationship after this conference. Not so much with the intention of you being a member, but perhaps of us exciting you enough to consider whether or not you should offer yourself a membership so that we can continue the work of the TTLN. So during the break, I would certainly ask you and remind you to have a look again at that, and perhaps if you can, fill in the forms, and you can deposit them right outside. There is a table outside with a very large box, which does not include lunch, but which you can put your completed forms. And speaking of lunch, I'm also been invited by Simon Davenport, who is chairing our panel after lunch, that there is also a in the very same package a note headed question time. With at the back it's blank, and it's intended to provoke you into perhaps burdening us with your questions and comments and remarks, and those that you would wish or invite the panel to answer or consider when we meet after lunch in panel. So again, and the point that Davenport was making is that you do not necessarily confine your questions or your comments to the papers which were presented, but perhaps feel spirited enough to perhaps go a little further and to request of the panel, their answers or their views on what I would encourage you as being provocative discussions. Let us have a really good panel, speaking in an informed way, of course, and an authoritative way, and dealing with lots of the papers that have been presented, but with the context of contemporary events in Trinidad and Tobago. So that's this afternoon, and again, during your break, if you can fill in the question time paper and submit them to the registration booth. They will be taken by the presenters, and we may not be able to answer all the questions, but certainly a large majority of them will be answered, hopefully. Good. Ladies and gentlemen, our next speakers, this is our final pre-lunch speakers, are Ms. Shaheera Allahar and Ms. Tynneille Tuitt. And they will be presenting on the role of the common law in the Caribbean. Ms. Allahar was called to the bar of the Republic of Trinidad and Tobago in 2005 and practices in the Civil Litigation Department of Dalton's. Her portfolio is varied and includes a wide range of civil litigation claims, and her principal focus and her pet interest is in the field of personal injuries, including road traffic accident claims, fatal accident claims, PIs, and also, of course, occurring in the course of employment and clinical negligence claims. Similarly, Ms. Tuitt, who is a more recent graduate, is also an associate at Dalton's, and she, in fact, graduated from the University of Warwick in the United Kingdom with an LLB in 2009, and was called to the bar in the United Kingdom in 2010 as a barrister at law. She is a member of the Honourable Society of the Inner Temple and was admitted to practice here in Trinidad and Tobago in 2011. She obtained her LLM in International Corporate Governance and Financial Regulations with the distinction from the University of Warwick in the United Kingdom. Ladies and gentlemen, please welcome both Ms. Tuitt and, of course, Ms. Allahar.
Good morning, everyone. We know it's close to lunchtime, so we will try to be brief in our presentation. Our topic is the role of the common law in the Caribbean. When we heard the theme of this conference, recent contribution of the Caribbean to the common and constitutional law, we felt that we first must know and understand what is the common law, and then also look at how it was introduced as part of our legal system. As young lawyers, we were initially taught in the undergraduate level about what is the common law. But we never really fully addressed our mind to understand truly the origins of the common law. So this paper is presented in two parts. Firstly, I will examine the history of the common law and its reception into the Commonwealth Caribbean. Thereafter, my colleague will focus on one area of the common law where post-independence, common law principles have been applied and developed to meet the needs of our society. Chief Justice Coke, one of the greatest English lawyers, wrote at the beginning of the 17th century that, beginning quote, "The reason of the law is the life of the law. For though a man can tell the law, yet if he know not the reason thereof, he shall soon forget his superficial knowledge. But when he findeth the right reason of the law, and so bringeth it to his natural reason, then he can comprehend it as his own. This will not only serve him for the understanding of that particular case, but of any others. Chief Justice Coke's words resonate the ideals that all practitioners and law students should strive for, in terms of being dedicated and prudent in one understanding of the law. Whether it is tracing the roots of the area of an area of law, so that you can gain an appreciation of how it's applied in the region. Now, when we think of what is the common law, the common law tradition describes the legal principles, substantive and procedural legal rules and institutions which started from the early courts of law in England after the Norman conquest, and it is still applied in the courts today. The tradition of the English common law has been gradual in terms of its development, as the courts advanced it on a case-by-case basis, particularly if the circumstances warranted a deviation from the present position. Now, most people would want to know, when did the common law truly begin? The first date at which it was associated is 1066. Yes, I'm going that far back. Prior to the Norman conquest of England in 1066, there was an absence of a unified legal system in England. Basically, there were circuit judges that were going from district to district, making judicial decisions based on local customs, in an effort to establish or maintain the king's peace. These common law principles started through oral pronouncements, and afterwards, with the introduction of court reporting, it was reproduced in a hard format that permitted litigants and their representatives to have access to the applicable laws and gain the associated benefits. In the 13th century, we saw the common laws taking a forefront in the roles of the Court of Exchequer, Common Pleas, and the King Bench. It was at that time we saw the emergence of common law principles based on custom and judicial decisions. However, as Slapper and Kelly in their book, The English Legal System, it described the common law courts as becoming stiff. Beginning quote, the courts developed an institutional scoliosis in that they were reluctant to deal with certain issues if it was not brought in a proper form of action. As a consequence, the people appealed to the Chancellor so that they could obtain relief and justice. And hence we got the principles of equity arising. As most of you know the proverbial description, equity was as long as the Chancellor's foot, which essentially was, it depended on the particular Chancellor and his application of justice in that particular situation. In consideration of the origins of the English common law, it should be noted that the manner in which the common law has grown, it has developed in a sort of organic manner, whereas the judges apply common law principles and precedents and allow some sort of degree of flexibility for judicial discretion and application of the relevant principles. Now, when we think of the reception of the English law in Trinidad and Tobago, we look to start with the expansion of the British Empire during the colonial times. The laws of England, the English laws, were transported or received by the Commonwealth Caribbean. The manner in which these laws were received differed from island to island. Some came via conquest and/or secession, and some came via settlement. In the case of settlement, it was widely accepted that the law was brought at the time the English arrived, in that it operated from the date of the first settlement. In contrast, reception by conquest or secession often created a turbulent introduction of the English legal system, since it meant that the laws that were introduced were a consequence of either warfare or through cession of the former metropolitan rulers. In Trinidad and Tobago, the application of English law was derived from us being conquered as well as being ceded. If we think back to our history classes now, in 1498, the island of Trinidad was colonized by conquest on behalf of Spain. And despite attempts by settlement by the English and Dutch, and the presence of the French during the next 3 centuries, Spanish authority was manifested in this country until 18th February 1797. At that time, the island was surrendered under a treaty of capitulation. This treaty was confirmed, and Trinidad was formally ceded to Great Britain by the Treaty of Amiens in 1802. The first conquest being by the Spanish. Spanish law governed the island during the period 1498 to 1797. Despite the English taking control of Trinidad from 1797, Spanish law and the systems of government continued until 1831, when a legislative council was established. Gradually, we saw the introduction of English-style ordinances, where it was that the English law was substituted for the Spanish law in a number of matters. In 1848, an ordinance was passed which repealed all Spanish law in this country. However, there was much controversy at the time in the Trinidadian courts as to the application of that particular provision. In 1940, however, a declaratory ordinance was passed that effectively stated the common law, doctrines of equity, and the states of general application of the imperial parliament was in force, and that it was enforced from the 1st of March, 1848. That effectively took away the Spanish law from being in operation in Trinidad at that time. It is true that Section 19B of the Supreme Court of Judicature Act recognizes and gives effect to all titles, rights, duties, obligations, and liabilities existing by the common law or by Spanish law or by any custom or by any written law. However, in present times, the influence of Spanish law is negligible. During the colonial times, common law and equity were also introduced. The common law aspects that we gained was the law of merchants on commercial law, ecclesiastical law, and customary international law and equity. The English statutes enforced were not generally applied to Commonwealth Caribbean territories unless specified. In the Grenadian case of Attorney General versus Stewart, the court held that English statutes at that time, the particular statute, the English Statute of Mortmain, did not extend to Grenada, since it was enacted to deal with a specified local public mischief that was occurring in England. Similarly, during those colonial times, the courts continued to apply and or retain some of the customary laws. For example, the use of the X mark and the thumbprint by blind and illiterate persons in Trinidad and Tobago, particularly to those seeking to execute legal documents. Although there has been some debate as to the validity of those executions, the courts have maintained its recognition of this customary tradition, which dates back to 1845, and the introduction of indenture and bonded laborers who were illiterate. In the 1960s and onwards, the majority of the English-speaking islands emerged as independent sovereign states. Many islands instituted constitutions, established parliaments, and enacted laws that encapsulated the customs, norms, and legal traditions of the colonial masters. A notable facet in most of the constitutions and or laws of these islands was saving law clauses that sought to retain the received law until such time or until a specified time or cutoff to ensure that there was a smooth transition and implementation of locally enacted legislation. In considering the extent of the common law received, one must look at what principles existed at the date assigned for the reception. In Trinidad and Tobago, by virtue of Section 12 of the Supreme Court of Judicature Act, any written law in operation on 1st March 1848 and any written law passed after that date, the common law, doctrines of equity, statutes of general application of the Parliament of the UK that were enforced in England on that day continued to be enforced as at independence. So in Trinidad, the cutoff date was the 1st March 1848, and in Tobago, it was from the 1st January 1888. Now, in terms of the common law principles that would have derived at that time, because of the limit of court reporting at that period, we cannot truly see and cannot truly record what were the common law principles. But mostly from 1962, when there was the introduction of more legal reporting, we can note the contributions and the development of the common law as time has progressed. Now, in terms of the cutoff date, this does not automatically translate to English decisions being made after that cutoff time being deemed irrelevant. Rather, the court treated those decisions as being of a highly persuasive nature, and as such was still willing to follow and or apply the principles depending on the facts of the case as well as the originating court. In the case of Mohammed versus Mohammed, Justice Kelsick recognized that any provision which incorporated the practice and procedure in England being enforced in the High Court of England incorporated that practice and procedure actually enforced at that particular point in time. Further, by Section 17 of the Court of Judicature Act, the principles of equity were retained. And when we look at Section 19 of that same Act, we note the elements that the court recognizes and gives effect to what we're dealing with in terms of the equitable rights, such as rights relating to all legal claims and demands, and all estates, titles, rights, duties, obligations, and liabilities existing by the common law, or by Spanish law, or by any custom, or by written law. Further, the courts have also applied the local circumstances rule, particularly where there was a need to accommodate local circumstances or conditions. In the Privy Council decision of Cooper versus Stewart in 1889, the court was called upon to determine whether the common law of perpetuities applied to New South Wales, given that it was a colony established by settlement. In the court analysis in that particular case, they said that given the time that it was brought, which was 1823, the rule was no longer applicable to crown grants of land in the colony of New South Wales, or to reservations or defeasance in such grants to take effect on some more contingency, more or less remote, unless it would apply when necessary for the public good. Now, in that case, what the court was really addressing was that they would look at the local circumstances to ascertain whether the particular common law principles would apply. If it did not in that instance, the court would follow what developed from the country. Now, in the area of personal injuries, we can truly see the shift in the common law system and the contributions of the Caribbean. And my colleague will be dealing with that further on. Now, one thing that we also noticed in terms of the common law, and when we're looking at it, in terms of the stumbling blocks to development of the common law in the Caribbean, in our eyes, there are two major stumbling blocks. The first major stumbling block, as I mentioned briefly, was the limited case reporting. Because of this stumbling block, we have not truly traced in terms of the common law development in terms of pre-independence and post-independence, in terms of when the cutoff period was and when the independence had gained. So we have not seen that, but we're continually developing our common law as the cases go by. Secondly, in terms of the common law, pre the cutoff point, a lot of our barristers were trained in the judiciary, as Sir Ramsahoye mentioned. They were trained in Britain, as that was a mandatory part of their training. And as such, the common law that was developed in the Caribbean was influenced greatly by what was present in England. I will now pass you on to my colleague.
Good afternoon. Thank you, Tynneille. Non in legendo sed intelligendo legis consistunt. The laws consist not in being read, but in being understood. As practitioners, we rarely see the importance of understanding the foundations and/or origins of our jurisprudence. This is something we left at the doorsteps of the law school before starting practice. But in preparing this presentation, it has forced us not just to state the law, but to seek to understand the origins of it. As my colleague has said, having considered the history and origin of the common law, we now seek to discuss the role of the common law in the Commonwealth Caribbean with specific reference to the law of damages in private law. There is no statute law as to how private law damages are to be assessed. It is an area governed entirely by the common law developed by the courts over hundreds of years. Since the development of the common law and the Trinidad and Tobago attained independence, the practice has been that the courts look at past cases in determining the quantum of awards for damages for loss and damage, including those as a result of tort. So that if there are previous cases in which other judges have made awards, the judge would usually rely on the awards given in those cases to guide them in making awards in later cases. Where there's a novel situation, judges sometimes look outside reported decisions for guidance, and the common law system allows judges to look to other jurisdictions or to draw upon past or present judicial experience for analogies to help in making a decision. This was the principle expressed in the case of Kieran Christopher versus Clarence Rampersad and another, when Justice Wendell Kangaloo, as he then was, held that in determining the quantum of damages, courts are enjoined to take, by way of comparison, awards in the jurisdiction in matters of a similar nature where such matters exist. Those awards are generally brought up to date using the Retail Prices Index. When no such awards have been made, then the court must look at other jurisdictions for guidance. These common law principles were developed for the purpose of ensuring flexibility to allow judges to deal with changes that lead to unanticipated controversies, whilst at the same time, stare decisis, the doctrine of stare decisis, provides certainty, uniformity, and predictability and makes for a stable legal environment. Wooding CJ, in the well-known case of Corneliac versus St. Louis, set out fundamental principles of law which a court ought to consider when assessing damages as follows. 1. The nature and extent of the injuries sustained. 2. The nature and gravity of the resulting physical disability. 3. The pain and suffering endured. 4. The loss of amenities suffered. And 5. The effect on pecuniary prospects. These principles are still being applied in personal injuries claims throughout the Commonwealth Caribbean today. For example, in Belize, in a case Adolphe Van Colbier versus Rommel Burgess and Manuel Perez, Justice Muria relied on the principles set out above in the interest of achieving consistency in determining the issue of damages for personal injuries arising from a road traffic accident. In the Eastern Caribbean states, the Court of Appeal in Alfred versus Thomas and another held that the principles expressed in the Corneliac and St. Louis case were the principles to be applied. Since then, the Commonwealth Caribbean and certainly Trinidad and Tobago have adopted these general principles to be followed, and in the assessment of damages in personal injuries matters, that is, 1, the purpose of damages is to compensate the injured party, not to punish. An award of damages is to restore the claimant to the position he would have been in if the tort complained of had not been committed. Damages should be full and adequate, and in most Commonwealth Caribbean jurisdictions, damages are assessed once and for all, and compensation is given not only for loss and injury, which has already accrued, but also for loss and injury which might develop at a future date. The Privy Council continues to be our highest court of appeal, and in recent times, the Privy Council has given guidance to judges and practitioners of the Commonwealth Caribbean as to how these principles of common law can be developed to meet their societal conditions and demands. In the case of Peter C. Prasad versus Theophilus Prasad and Capital Insurance Limited, the Privy Council set out their reservations about the usefulness of resorting to awards of damages in cases decided a number of years ago, with the accompanying need to extrapolate the amounts awarded into modern values. Whilst the methodology of using comparisons is sound, it is an inexact science and one which should be exercised with some caution. More so, it is important to ensure that in comparing awards of damages for physical injuries, one is comparing like with like, bearing in mind that where the authorities are of some antiquity, such comparisons can do no more than demonstrate a trend in very rough and general terms. Though in the Peter C. Prasad case, the Privy Council was reluctant to interfere with the award by the Court of Appeal, stating that it was a product of the views of the appellate court on a topic particularly within their own jurisdiction. In the case of Alfie Subaya versus the Attorney General, the Privy Council held that due to the passage of time and changes in the value of money, since some of the earlier awards, the level of compensatory damages may call for upwards revision by the courts of Trinidad and Tobago. In the circumstances, there has been a general trend towards an increase in the range of damages for general damages for pain, suffering, and loss of amenities, depending on the injuries suffered by the particular litigant and the effect which the injuries has had on his or her enjoyment of life. In the area of the assessment of damages for future loss of earnings, the traditional multiplicand approach applies. The Commonwealth Caribbean adopted this approach from the English law, and it is applied today. However, in England, the law has developed in that they now rely on actuarial tables prepared by the Government Actuaries Department to provide an aid for those assessing the lump sum award for continuing future pecuniary loss. The law in the Commonwealth Caribbean has not developed in the same way. In the Peter C. Prasad case, the Privy Council considered the approach adopted by the Trinidad and Tobago courts in selecting a figure for the multiplier, which, prior to that case, had always been a rough estimate based on the age of the claimant and the probable length of his future working life. In that case, the Privy Council held that in order to give a proper compensation to the claimant, in addition to the age and probable length of the claimant's working life, the interest rates in Trinidad and Tobago would have to be considered and some allowances made for the contingencies in life. In this area, the common law has developed further, and in certain circumstances where there are uncertainties or imponderables, the Trinidad and Tobago courts have considered whether they can reject the traditional multiplier and multiplicand approach of assessing damages and instead, in favor, choose a global broad brush approach as enunciated in the English case of Blameyer versus South Cumbria Health Authority. On the issue of mitigation of damages, the Privy Council in the case of Salvanyagam versus the University of the West Indies held that the burden of proof on the issue of mitigation was on the plaintiff to show that he acted reasonably in all the circumstances, and this was the law which was applied in the Commonwealth Caribbean. Though this was in opposition or despite the earlier case, English case of Ghana Grain Company versus HMF4 and Fairclough Limited and Burge Corporation, which set out the position that on the issue of mitigation, the defendant will have to establish not only that the plaintiff is able to return to work, but there is work available for the plaintiff to do. In an appeal emanating from the Courts in St. Lucia, Geest PLC versus Lansico, on this issue, that is the mitigation of damages and on whom the burden of proof will lie, the Privy Council held that the earlier decision in Salvanyagam versus the University of West Indies, that principle cannot be relied on as an accurate statement of the law on this particular point. The common law So we can see that the common law continues to play a dynamic role in developing the jurisprudence in the Commonwealth Caribbean, particularly in the area of personal injuries and damages. And it allows for a certain amount of flexibility, whilst at the same time providing certainty, uniformity, and predictability to some extent under the doctrine of stare decisis, and makes for a stable legal environment. And as we can see from the cases that emanated from the Privy Council, the English law and also the decisions from the Privy Council also plays an important part in the development of the common law in the Commonwealth Caribbean in two ways. One, as my friend had set out, it is the foundation for our existing law. And two, by having the Privy Council as our final court of appeal, we can still be guided to ensure that the common law continues to grow and develop to meet the needs of our current society. And in this case, and having regard to this particular lecture and what we're here to do today in terms of continuing legal education, one would hope that the Commonwealth Caribbean judges and practitioners and students alike all play a greater and more active role in terms of developing the common law in the Commonwealth Caribbean for themselves and to meet our own needs. Thank you.
Thank you, Messrs. Allahar and Tuitt. In fact, the organizing committee was an apology to both of them, because when we were devising or when we were inviting them to give us their topics, we were extremely, we said to them, there's no way you can crystallize and distill 1,000 years of English common law and the doctrine of stare decisis in 30 minutes, but they've proven us wrong. They've done that eloquently and extremely persuasively, because for my own right, I didn't actually know that Section 19 of the Supreme Court of Judicature preserved, I knew it preserved the common law, but I actually did not know it also preserved the rights, entitlements, estate of Spanish law as well, which in fact is extraordinary. But yes, the other point is that, and this is part of the recitation right up to the present, many of you may be aware that the Allen case from the Privy Council, which was reported on January of this year, has put the loss of a chance, or speculative damages, the Chaplin and Hicks notion of speculative damages in some context, and has in effect invited judicial officers who sit in an assessing capacity that, notwithstanding the difficulties of assessing and monetizing loss and damage, that there is an obligation to do so, and it's not as easy to just pull out the notion of a nominal damages to in effect reward somebody who has suffered loss and damage. So we can see the evolving and dynamic role of the common law, and I'm grateful that Trinidad and Tobago has played such a pivotal role in that. Good. Well, ladies and gentlemen, we are at lunch.
I didn't start there, but when I chose to go first as a student, I remember a friend saying to me at the time, he said, you're moving to England. I said, yes, I'm quite excited about it. He said, well, all I can say is, if you like the weather, you'll love the food. So it's nice to be here where there are no complaints about either the weather or the food. Thanks for hosting us. Now, in the interest of time, I'm going to cut back on the introductions. You have bios of our speakers in your materials. I would commend those to you. Please do read those. We're going to take things a little out of order to accommodate our next speaker's commitments this afternoon. And fortunately, our next speaker is somebody who needs no introduction, certainly in this audience. He's been Attorney General of Trinidad twice. He's been Attorney General twice, and Jeremie, Senior Counsel, has also been High Commissioner in UK, so he may have his views on English weather as well. But in any event, John, I'm going to invite you to come forward and just speak, and we'll see if we can catch up on some of the time. Thank you.
Good afternoon. This afternoon, I've been asked to speak on the topic, parliamentary privilege in the Caribbean. I wondered why I had been given this controversial topic, especially at this time, but I have, and I shall try to deal with it manfully. I've chosen in the brief time, I think I have 20 minutes, that I have been allotted to speak to current events, locating them through the lens of history, for it is only through that lens, I believe, that much of our current difficulties can be understood. And I have selected two events which, to my mind, disclose certain of the most flagrant forms of disregard for proper parliamentary process to ground my discussion of privilege. A privilege, to use the language of Hofeld, cannot exist without an obligation that serves to guard it from abuse. The first event on which I have chosen to speak is one that I feel sure that most, if not all, of you have long forgotten. It concerns the attempt by the then Speaker of the House and my friend, Barry Sinanan, to refer on the 4th of March 2009, the Urban Development Corporation of Trinidad and Tobago, UDCOT, a company owned by the state that had been mired in allegations of corruption when I was Attorney General, to the Privileges Committee of the House. UDCOT had placed a full-page advertisement in two of the daily newspapers, which enjoyed the widest circulation in Trinidad and Tobago, under the caption, "Statement by Opposition MP, Reckless and Irresponsible." The advertisement was in response to a speech made in the Parliament by the then member of the opposition, Dr. Tim Gopi Singh, in which the member had accused UDCOT of being involved in, and I quote, corruption, non-transparency, and non-accountability, end of quote, with taxpayers' monies. He had also severely criticized its selection for the construction of the Point Fortin Hospital. In its advertisement, UDCOT condemned the statements of the member. They correctly noted that they had been made under what is commonly described as the coward's cloak of parliamentary privilege. UDCOT dared the member, and I quote, to repeat his spurious allegations outside the parliamentary chamber, end of quote. The Speaker relied on a passage in May's parliamentary practice, which describes the molestation of members in Parliament as being capable of amounting to a possible breach of parliamentary privilege. He ruled that a prima facie case based on a breach of privilege had occurred and referred UDCOT to the Standing Committee of the House that is known as the Committee of Privileges. That's the first event. The second event that I have chosen as a backdrop to my remarks stems, perhaps inevitably, from our very recent past. Unlike the first, I feel certain that all of you will remember the facts that underpin this event. On the 6th of May, 2015, a mere 1 month ago to the day, the leader of the parliamentary opposition was suspended after a motion which described itself to be a motion of censure was passed in the House of Representatives. The motion, notwithstanding its description, provided for the immediate suspension of the member from the service of the House for the remainder of the parliamentary term, which is even now in progress. The motion was in substance rooted in an allegation that the member had breached privilege by reading into the Hansard what the leader of government business and the mover of the motion described to be false emails. If true, this would ordinarily, in the practice of this Parliament, have been the subject of a motion of abuse of privilege, which, once the Speaker had declared it to have been established on a prima facie basis, would have been referred to the Committee of Privileges for that committee to hear evidence and arrive at a decision which would then have been reported back to the full House for action. These two examples that I have selected are instances in which the parliamentary privilege of free speech that lies at the heart of the parliamentary privileges arrogated by the Commons at Westminster in the aftermath of the Glorious Revolution were in issue. The freedom of speech privilege was one that served individual members of the Commons as well as the Commons itself. Article 9 of the Bill of Rights contained other privileges. Not only were the proceedings in the Commons outside the writ of the King's Courts, but Parliament and its legislation was free from subjugation to the law of nature, the law of God, and the common law, all being areas of influence that the Crown had previously sought to assert dominance over the Commons. The Commons could punish for contempt as part of their unqualified jurisdiction to regulate their own procedure without reference to the ordinary courts, and could also exercise a penal jurisdiction all of its own. The two local events that I referred to clearly represent, in my view, parliamentary overreach. In the case of Udicott, the Speaker's ruling that Udicott, a limited liability state corporation, could not exercise the right of robust reply to a member who had, under the cloak of parliamentary privilege, and whatever its many misdeeds, for there were many on the part of Udicott, had quite clearly defamed the company. In the case of the suspension of the leader of opposition, the Parliament, dispensing with the ordinary procedure to remedy a breach of the privilege of free speech, a reference to the Committee of Privileges of the House, arrogated to itself the power to charge, to hear evidence, and to rule that a breach of privilege had in fact occurred in circumstances that would warrant the immediate suspension of the leader of the opposition. I think, as I have said, that both of these actions were not simply plainly wrong, but were also unlawful. And I say so for these reasons. Mayes defines parliamentary privilege as, and I quote, the sum of the peculiar rights enjoyed by each House collectively as a constituent of the High Court of Parliament, and by members of each House individually, without which they could not discharge their functions. The purpose of the privilege was articulated as long ago as 1675, when the Commons asserted that privilege existed so that members might freely attend the public affairs of the House without disturbance or interruption. It is difficult to comprehend how the exercise by Udicott of its right of reply, as robust as it was, or the suspension of the leader of the opposition could properly be said to offend against parliamentary privilege in this sense, the more so in the context of a written constitution that provides for freedom of speech as a guaranteed right. Neither of these events has, however, been challenged in the courts. This has, in my opinion, more to do with the time-honored reluctance of our courts to interfere in the internal processes of our Parliament and the concomitant reluctance of potential litigants to sue. But that reluctance, itself a reflection of privilege, we must remember, is rooted in British history, traditions, and conventions. In a host of cases, the Privy Council has affirmed the relevance of the British approach to parliamentary privilege that is articulated in Article 9 of the Bill of Rights. But as Adrian Saunders, Judge of the Caribbean Court of Justice, has remarked, and I quote, "It is not difficult to understand the wider principle of Article 9 in the context of parliamentary sovereignty and against the historical background of a House of Commons assertive of its independence and anxious to ensure that its privileges were not determined ultimately by the other house, the House of Lords. In Trinidad and Tobago, with a written constitution and no possibility of a trespass by the Senate, the other House of Parliament, that is not a House of Lords, the position ought to be different. There have been, it is true, tepid attempts to confront the principle of parliamentary privilege by our courts. One such was Toussaint versus the Attorney General, of which my colleague and friend, Mr. Maharaj, spoke earlier this morning. In Toussaint, the Privy Council read down the provision in the Vincentian Privileges Act, which required a litigant to obtain the Speaker's permission before evidence could be adduced as to what had been said in Parliament. That evidence was critical to a constitutional motion that Toussaint wished to pursue. The Speaker, a certain parliamentary privilege, refused to give it. The Privy Council ordered that it be given. But the more robust approach adopted by Hammersmith G, as he then was, in Boudram versus the Attorney General of Trinidad and Tobago, is probably to be preferred in our context. In Boudram, the privilege which was sought to be asserted was analogous to that which was sought to be used in Toussaint. The state argued that the publication in Parliament of a report, the infamous Scott drug report, was no business of Mr. Boudram, whose name was mentioned throughout the report, and that its publication could create no right of action against the state for a breach of Mr. Boudram's constitutional right to a fair trial. The argument was that the collective privilege that Parliament enjoyed meant that its proceedings could not be inquired into or impeached in a court of law. In that case, Mr. Justice Hammersmith held that as long as, and I quote, as long as what is said in Parliament by a member does not infringe the provisions of the Constitution, that immunity, and he's speaking there of the privilege, is assured. But he went on to say, crucially, that a democracy which claims not only to have respect for the fundamental rights of its citizens, but which makes express provision in its constitution to entrench and preserve those rights, should never appear to entertain the suggestion that members of Parliament are free to do what they like, provided it is done within its walls. The oath taken by its members demands of them respect for the Constitution. In the Trinidad and Tobago Civil Rights Association versus the Attorney General of Trinidad and Tobago, which is another of Mr. Maharaj's cases, and I must confess I happened to be on the other side of that at the time as Attorney General. Gobenji observed that parliamentary privilege must yield to the court's duty to give the Constitution the primacy which it is due. The case was subsequently overruled by the Court of Appeal, but that dicta, in my view, represents an accurate statement of principle. A similar approach was adopted by the Supreme Court of India in Raja Rampal versus the Speaker, in which MPs were shown on television accepting money for posing questions in Parliament. The MPs attempted to approach the courts for relief after being expelled by the Parliament. The Parliament asserted that the courts lacked jurisdiction and that the Parliament alone had the exclusive right to discipline MPs, a right in respect of which they were not answerable to the judiciary. This was, of course, an assertion of privilege. A majority of the Supreme Court of India held that if an allegation is made by a citizen that he has been unconstitutionally deprived of his fundamental rights as a result of the exercise of a parliamentary power or privilege, the court has a duty to examine this question, notwithstanding the claim to privilege. And that, colleagues, is, I think, the short point. Our Constitution in Section 55 is in terms similar to the Indian Constitution in Article 105. And it provides that parliamentary privilege is subject to the provisions of the Constitution. The precise words used in the Constitution are that subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the Senate and the House of Representatives, there shall be freedom of speech in the Senate and House of Representatives. A complicated issue arises in the sense that Section 55 also provides in Section 55(3) that in other respects, the powers, privileges, and immunities of each House and of the members and the committees of each House shall be such as may from time to time be prescribed by Parliament after the commencement of this Constitution, and until so defined shall be those of the House of Commons of the Parliament of the United Kingdom and of its members and committees at the commencement of this Constitution. The House of Representatives Privileges Act can arguably be said to be a prescribed act under Section 55(3), and that is so notwithstanding the fact that it was enacted before the passage of the 1976 Republican Constitution. If one analyzes carefully the savings and transitional provisions in the 1962 and the 1976 Constitutions, that is a result that is possible to arrive at. If this is correct, then the privileges of the Commons do not apply in Trinidad, notwithstanding the apparent express terms of Section 55(3). So that little regard, if any, ought to be paid to Article 9 of the Bill of Rights. In any event, I suggest that the Bill of Rights, framed as it was to treat with the struggle in England between Parliament and the monarchy should be of little significance in the context of written constitutions in states in which that problem simply never existed, and in a context where the written constitution itself makes provision for the privileges of the Parliament. Put simply, the time has perhaps come for the courts to exercise a greater role in overseeing parliamentary matters. It is not now enough, in my view, for the courts to have regard to what is said in the Parliament, as in Pepper and Hart and Toussaint versus the Attorney General. The courts must go further to inquire whether conduct in Parliament violates the supreme law, the Constitution, as is suggested in Budram versus the Attorney General and the Indian case of Raja Rampal versus the Speaker. If Parliament acts so as to breach entrenched rights, even those of a member, as was perhaps the case with the Leader of the Opposition, it is for the courts to sanction a breach of rights, notwithstanding the existence of the traditional privileges of the Commons at Westminster. The recent collapse of our parliamentary conventions, in my view, requires that now more than before, our courts and litigants should begin to exercise with increasing confidence the powers they arguably possess to ensure that parliamentary privilege does not operate to exempt from judicial scrutiny conduct which, in the words of Justice Hammersmith in Budram, would otherwise be unlawful outside the walls of Parliament. Thank you.
Very learned exposition for the reminder that parliamentary privilege was relevant in 1675, if anything, even more relevant today. The debate about it, the constitutional context that, in a sense, defines it, the role of the courts, and as a corollary, the role of lawyers in making sure that we keep it in its proper place. Thank you for that. I mentioned earlier that for good reason, over the last day or two, my waistline's been expanding. Now my chest is going to expand a little bit because it's my pleasure to be able to introduce the next 3 or 4 speakers, all of whom share chambers with me, and I'm delighted to keep their company. The first of those is Thomas Rowe, Queen's Counsel. Thomas, I invite you to join me here on the stage. Again, I'm not going to read Thomas's biographical note to you, but I commend it to you. When you read it, you'll see that Tom is a rising star at the bar, well respected for his advocacy. I think it was particularly noticeable that when Tom took silk last year, the fact that judges from the Supreme Court on down came along to that celebration when we celebrated it at Middle Temple. And I think, Tom, for good reason, you should be very proud of the respect that your work has commanded at the bar. But I think Tom is going to talk to us now about dissenting judgments. And the floor is yours.
The American behavioral psychologist, Professor Daniel Kahneman, in his book called Thinking Fast and Slow, describes a study which was carried out into the behavior of parole judges in Israel. The practice there is that a criminal seeking parole has on average about 6 minutes to persuade the panel that he is sufficiently reformed to deserve parole, after which the judges decide there and then whether to grant or to refuse. And the judges hear case after case in rapid succession with 3 breaks during the day for refreshment. Crucially for the study, the time of each grant or refusal is noted. On average, parole is granted to a sympathetic audience, and that lawyers, however conscientious, are no different. I was therefore slightly concerned to be driven from my slot immediately after lunch to make way for learned counsel from whom you've just heard. But I hope that I'm still roughly in the 65% territory and not in the nil territory. I'm going to speak to you for more than 6 minutes, but not for a very long time, about dissenting judgments. How is it that dissenting judgments have come to be a feature of our common law legal system? What role do they play? What role ought they to play? Should they be encouraged or should they be resisted wherever possible? What use should practitioners put them to when we read cases? And also I want to say something very briefly at the end about the style in which they're delivered. Now, most of us would say, I imagine in this room, that there is nothing remarkable about the fact that when a court comprising several judges decides a case, it is generally open to any judge to give a separate judgment explaining why he or she does not agree with some aspect of the majority's reasoning. Either a dissenting judgment, properly so called, I would have allowed this appeal, not dismissed it, or a concurring judgment, I'm going to agree with that we should allow the appeal, but I get to this destination via a different route. These sort of judgments are, of course, a common feature of judicial decision-making across the common law world and, of course, in the United States. But if we lift our eyes for a moment from the common law world, we find that it's actually a comparatively unusual thing. In France, in Belgium, in the Netherlands, Italy, and indeed across most of the civil law countries of the world, dissenting judgments are not merely not the practice, they are positively prohibited. The court must deliver a single judgment, a single statement of its reasons. And particularly in the French tradition, the judgments are terse and assertive, and they rely quite heavily on the repetition of identical verbal formulae. And this goes back a long way. Indeed, around about the time that Christopher Columbus was setting off in the direction, though he didn't know it at the time, of this island, there was an ordinance of Medina Sidonia in Spain which provided that any judge who did not agree with the majority decision could make a note of this fact. It was called a voto reservado, but only in a secret book that was never revealed. In other civilian jurisdictions, dissenting judgments are permitted, though they're scarcely encouraged, at least in the dedicated constitutional courts, which are a feature of many of the continental jurisdictions. For example, most of the cities and states which now make up Germany did not permit dissenting judgments. And when in 1877 the Germans came to draw up the rules for the courts that would rule in the newly unified Reich, they thought about whether dissenting judgments should be allowed, and they appointed a commission to decide this and other questions. But the commission rejected it, and their reasons are quite instructive. One was that the publication of dissent would be incompatible with the authority of the courts and good relations between the judges. Another was that it would foster vanity and disputatiousness. Well, dissenting judgments are nowadays, as it happens, allowed in the German Constitutional Court, but the single judgment is still very much the norm, and indeed in the ordinary courts, across almost the whole of continental Europe, with a couple of exceptions, no dissenting judgments are allowed at all. Why is it that the common law jurisdictions are different? It's tempting to think that our willingness to entertain the possibility of judicial dissent in some way derives from some fundamental difference about our societies. One might perhaps detect something of a correlation between those jurisdictions which routinely permit dissenting judgments and those jurisdictions which have enjoyed long political stability and the rule of law. But that would be a more sweeping claim than I'm qualified to make, and I'd hesitate to make it, especially in present company. But there are, and there are anyway, plenty of aspects of our system of government which, as it were, tell the other way. We don't, for example, permit open dispute, or at least not usually, amongst members of the cabinet. Members of the cabinet who get outvoted are not expected to issue dissenting opinions showing why they don't agree with the government's policy. A more modest claim is that the prevalence of dissenting opinions, dissenting judgments in our courts is, at least in part, a product of history. It results from a phenomenon which is perhaps similar to that about which Winston Churchill commented in 1943. He was talking in the House of Commons about why he thought Britain should resist the temptation to rebuild the bombed-out House of Commons, which had suffered a direct hit from a German bomb, in a different shape, in a semicircle, for example, like is common on the continent of Europe. And he famously said, "We shape our buildings, and afterwards our buildings shape us." Well, what has dissent got to do with that? Well, dissent self-evidently only arises at the appellate level, where there is a multi-member court. I suppose single judges sitting alone have their own internal dissents, but they've got to make their mind up in the end as to what they're going to do. And most common law appellate courts are, in historical terms, a relative novelty. The Court of Appeal in England was only established in 1875 in order to replace an assortment of other appellate courts, which had only themselves been set up piecemeal earlier in the century. But there was, of course, a much earlier form of appeal, namely to petition the king in Parliament, and that went back to the 13th century. Now, skirting over a lot of arguments in history, we come to the position that by about the 18th century, petitions to reverse judgments at first instance from England, Scotland and Ireland were coming from time to time before the House of Lords. Nobody appears to have thought to devise a special procedure for these cases. The constitutional fiction was that one was not dealing with a court at all, at least not a court in the ordinary sense. I suppose it was the High Court of Parliament. But one wasn't dealing with an ordinary court, but simply with a motion being debated in the House. And the cases were simply debated like any other subject on the day's order paper, albeit with the advantage, if you can call it that, of argument from counsel standing at the bar of the House. And each lord who was participating would simply give a speech setting out his own view of the outcome and why that should be the case. There was no such thing, in other words, as a judgment of the court. And of course that practice continued, albeit formalised by the creation of a special class of non-hereditary lord, the law lords, who sat on a special committee, the appellate committee. It continued right up until 2009, when a government with not much time for constitutional fictions swept it all away and created the Supreme Court of the United Kingdom instead. So in those circumstances, going back to the 19th century appellate courts, it's not surprising that the judges of those courts, and of course around the world where courts of appeal were set up in the common law world, took it for granted that their role involved each of them delivering an individual judgment, even if only to say, "I concur." Thus it was, to go back to my Winston Churchill analogy, we shaped the institution, and the institution then shaped our practice. Now, there are and have been, of course, exceptions to that. In criminal cases in England and Wales, the Court of Appeal is bound by statute to deliver a single judgment of the court in almost all cases. More fundamentally, there were those cases in which no appeal lay to the King in Parliament, because the place from which the appeal came was not part of the Kingdom of England. And I have in mind places like, for example, the Isle of Man, which, if you want to know what the Isle of Man looks like geographically, it's, for those of you who don't know, it's Tobago sort of rotated about 90 degrees and moved to the Irish Sea, and minus a few palm trees as well. But places like that were not part of the Kingdom of England, but nevertheless one could petition the King, but one did so by petitioning the King in council. In other words, the King, who was in theory advised, though in practice, except in the distant past, told by the Privy Council how to dispose of the appeal. Once again, it was really an appeal to a court, but one pretended otherwise. And this arrangement, as you of course all know, spread around the world, covering at its zenith about a quarter of the world's population. And it was put on a statutory footing, of course, in the 19th century by the Judicial Committee Acts. The countries to which it now applies, of course, are fewer in number, but needless to say, not in importance. Now here, of course, the constitutional fiction worked the other way around, because it would hardly do for the monarch to receive conflicting advice as to how to determine a case. So the convention grew up that there had to be a single report of the board, so there were no dissenting judgments. That didn't mean, of course, the judges actually agreed, and indeed, just as in medieval Spain, there was in practice a sort of secret book that people who didn't agree could sign. In 1877, somebody leaked to the press the extraordinary, amazing fact, it was thought, that some Privy Councillors had not agreed with the majority's decision on what, to our eyes, seems a most extraordinarily obscure case. It was a case about what vestments a vicar might lawfully wear while he was presiding at Holy Communion. Anyway, this was all sufficiently exciting for the press that somebody leaked a report of that to the press, and this prompted an order from 1878 expressly forbidding publication by any man, I'm quoting, publication by any man, how the voices and opinions went. And remarkably, that order remained in force, despite quite a lot of protest, especially from the Australian judges, with whom it didn't suit at all, until 1966, when there was a fresh order made which said that any judge who dissented in the result could explain why. And within weeks, the Judicial Committee saw its first dissenting judgment, and there's been a steady flow of them ever since, and indeed of concurring opinions too. Although, in fact, as far as I can see, strictly speaking, concurring opinions are still not allowed. But anyway, they're given all the same. Another possible explanation for the prevalence of dissenting opinions in the common law world, I think, relates to the career path of the typical judge. On the continent of Europe, it is not uncommon to find men and women who are in their 20s who have gone in at the bottom of the judiciary and are, as it were, working their way up through the judicial firm, learning the ropes as they go. Judges in the common law world, of course, have often worked as lawyers in the private sector for many years before moving to the bench, and their personalities are likely, one might say, to have solidified by the time they get to the bench. And it's obvious which arrangement is less likely to produce judges who feel obliged to go along with what the others say. Not to say, of course, there aren't exceptions to that. Judges trained in the civilian tradition who are not at all afraid to dissent, and one of them is sitting in the room at the moment, of course. Now, if those are some of the reasons why we have dissenting judgments, the question still remains, what are they for? Should judges feel any inhibition about giving a dissent and only do so if consensus proves really impossible? Or is the right approach for the judge simply to set out what he or she thinks, not to worry too much about what everyone else says? Oddly, for what might think are rather important questions about the nature of the judicial function, there isn't really very much guidance. And naturally, such views as I offer with an extreme diffidence, born, among other things, of the fact that I am not a judge. I am, as it were, very familiar with the end product of their work, but not with the manufacturing process, or indeed with the pressures under which judges labour when they're doing that manufacturing. But as for what dissenting opinions are for, I think there are at least two answers. One is simply the possibility that the possibility of dissent permits judges to state honestly what they think about the case. A judge who dissents doesn't necessarily have any agenda, but simply is not prepared to believe that what he or she considers to be the errors of the other members of the court are not in fact errors, and so sign up something that he or she doesn't agree with. But a second answer is that in many cases the judge who dissents hopes, of course, one day to change the law. An American who became Chief Justice once said rather portentously that a dissent is an appeal to the brooding spirit of the law, to the intelligence of another day. One thinks perhaps of Lord Atkin's celebrated 1942 dissent in the Liversidge and Anderson case, refusing to agree that the court was unable to review the reasonableness of the minister's belief that the plaintiff was a hostile person, in quotes, who could therefore be indefinitely detained by the government, and declaiming in words which of course would become written in every public lawyer's textbook in the future, that in this country, he said, amid the clash of arms, the laws are not silent. Something which no doubt will be pressed upon the courts when the cases about states of emergency come before them. But sometimes, oddly enough, it's the other way around. In fact, the dissenting judge holding out against a tide which is firmly going the other way. Consider, for example, Sir Gerald Fitzmaurice, who was the British judge on the European Court of Human Rights at the time in 1978, dissenting in a case in which the European Court of Human Rights held that the Isle of Man, there it is again, could no longer use the birch on its young miscreants. No boy at the school he had gone to, Sir Gerald confided, had ever felt the least bit degraded by being caned. So anyway, the tide moving the other way as far as that one was concerned. The other judges not agreeing with that as a reason for preserving the practice. Now, while the appeal to the intelligence of another day, so-called, might mean an appeal to another day long in the future, it's not always so. In a case in 2004 called Cartwright, the United States federal government wanted to extradite certain defendants from the Bahamas to face drugs trafficking charges. The US had an overwhelming case and they got their order for committal. The defendants applied for habeas corpus and for good measure they threw in an application for an order of certiorari to quash the order for committal. Now the judge, for highly technical and, it must be said, plainly erroneous reasons, granted habeas corpus and ordered the defendants' release. He made no order on the certiorari application, but he did say in passing that the orders for committal were void. And the United States appealed. The trouble was that in the Bahamas, at the time, there was no right of appeal against a successful habeas corpus application. The position there was as it had been in England until relatively recently. And the Court of Appeal got around that by saying, well, the judge had, I quote, based his decision on judicial review, and that since both sides had a right of appeal against judicial review decisions, they had jurisdiction to entertain an appeal and reverse the order, and the defendants stayed in jail. Well, in the Privy Council, where it went to next, a majority agreed with that, adding that they were adopting a, quote, purposive and dynamic interpretation of the law to make extradition work effectively. Well, Lord Hoffman and Lord Roger would have none of that. They gave a joint dissenting judgment, and I commend it to you if you're interested in this subject. It's a model of the genre, for those of you who don't know it. As they put it, the interpretation given by the majority to the judgment of the judge means that not only did he, presumably on the authority of Molière, if you look at my paper online when you see it, I've tracked down what they were talking about there and given you the reference in a footnote for those of you whose familiarity with French theatre is not up to the mark. Mine wasn't, certainly, until I looked it up. Not only on the authority of Molière did he make an order of certiorari without realising that he was doing so, but that he did nothing else. The notional order is conjured up, they said, in order to be set aside on appeal, and this being accomplished, the actual order, against which there is no right of appeal, vanishes in a puff of smoke. People, they said, facing extradition, however unmeritorious they are entitled to the law. Now, exactly the same point cropped up again in 2007, so 3 years later, in a case called Gibson, when a co-conspirator brought a separate appeal against the Court of Appeal's order. And a 7-judge panel of the Judicial Committee agreed unanimously with the view of the dissentients in the earlier appeal. The Judicial Committee agreed to depart from the earlier decision and allowed the appeal. So the dissenters in the first case were vindicated within the space of 3 years. But in fact, the second case itself included a powerful dissent, this time on the question of the law of precedent, because 3 of the 7, including ironically Lord Hoffman, who had been the author of the ferocious dissent I just referred to, would have followed the erroneous decision in Cartwright out of respect, they said, for the principle of stare decisis. Now, although that's a subject for another day, we may expect, I think, it to be a recurring theme, both in the Judicial Committee and indeed before the Caribbean Court of Justice. Indeed, a judgment is, as I speak, awaited from the Judicial Committee on a Trinidad and Tobago case called Hunt, in which the state, encouraged by a powerful dissent, and I can say that with some authority, having drafted the submissions, is appealing against, or rather inviting the court to depart from its ruling in a case called Ramdeen, as recently as last year, about its powers in death penalty cases. So when ought a judge to dissent? The starting point, I would say, is that dissents ought not to be entered into, as one says, of marriages, lightly or unadvisedly. The law, after all, is complicated enough, and in a way, one might say, if it is not necessary to dissent, then it probably is necessary not to dissent. Certainly this is true of the concurring opinion, which goes along the lines, I agree with the result, but not the reasons. In a system governed by judicial precedent, it is not helpful for the rule of law for Judge 1 to say, I allow the appeal for reason A, Judge 2 to say, I allow the appeal for reason B, and Judge 3 to say, I agree with both judgments, or I agree with neither judgment. As the late Lord Bingham put it in his great book, The Rule of Law, whatever the diversity of opinion, the judges should recognise a duty to try to ensure that there is a clear majority ratio. But in my view, it goes no further than that. None of us, I expect, is likely to be much attracted by the 19th century German view that the authority of the court is diminished by accepting that some questions are difficult and that judges, being human, sometimes disagree. The contrary view would be reminiscent, I think, of the justification now largely rejected in the common law world for the old offence of scandalising the court, namely effectively that people couldn't be trusted to know too much about the judge's failings and the process of doing justice. More practically, I think a court which strives to attain consensus on every point is likely quite often to be a bad court. And that indeed is verifiable if one tries to read, as we in England have to do, though you happily don't, the judgments of the Court of Justice of the European Union. In theory, giving answers to questions about EU law from national courts. There, dissenting judgments are never permitted. So one never knows for sure whether the decision was unanimous or a close run thing. But one suspects that often there has been an effort to accommodate everyone's views. And Lord Neuberger, not altogether diplomatically, has said in a recent talk on this subject, he says one only has to look at some of the judgments of the court in Luxembourg to see how compulsory unanimity can result in decisions which, 1, are incomprehensible, 2, have internally inconsistent reasoning, 3, do not answer the issue that has been referred, or 4, manage to enjoy all 3 of these regrettable characteristics. I think his view is fairly clear. I think I would be risking the fate of an Israeli convict just before lunch if I were to attempt to make that criticism good with too much citation. But the sort of thing he might have had in mind is perhaps the court's recent decision in a competition case, which I happened to have to look at a while ago, called Expedia. It was about Article 101 of the treaty, which invalidates agreements which have as their, quote, object or effect the restriction of competition. And in the course of its judgment, the court said that this only applied, quote, where that agreement perceptibly restricts competition within the common market. But then it appeared to change tack further on, as you read through, stating that an agreement, quote, with an anti-competitive object constitutes by its nature, and independently of any concrete effect that it might have, an appreciable restriction on competition. So you get, as it were, both the majority judgment and the dissent, all in the same single judgment of the court. It's interesting, but perhaps not very helpful if you're trying to advise your client what the law is. Now, even if that might be an extreme consequence of consensus, it does seem to me that the prospects of first doing justice in the individual case and secondly improving the law as a whole are promoted more by a general willingness on the part of each judge to speak, or as often nowadays to write, for him or herself, whether in concurrence or in dissent, than they are by any feeling that the objective is to get to consensus. As regards the chance of doing justice in the particular case, there are, of course, very many appeals, particularly in the Court of Appeal level, which are straightforwardly unmeritorious or perhaps wholly unanswerable. In those sort of cases, of course, it does make a lot of sense for the court just to give one judgment, whether it's a composite judgment or one judge saying what he or she wants to say and everybody else agreeing. But I think where the point is one of difficulty, there must be a real advantage, if the judges have got time to do it, in each judge attempting to put the matter, however briefly, into his or her own words. And I say that because, by and large, I think sound reasoning tends to right itself. Bad reasoning very often doesn't. And I think we'll probably come across this phenomenon if we've got experience of trying to draft a skeleton argument or write a letter to the other side in correspondence where you're really trying to express what fundamentally you know is a bad point. It's quite hard to get it down on paper. It's generally harder to do that. I think it's harder to do than writing a good point. So one quite good way of getting to test whether your judicial colleague, I would suggest, is saying something which is correct is to try and express it in your own words. I wonder whether that approach might have worked in two recent English cases about immigration. They were called Mirza and Satkota. In the first one, the claimant's argument was that when the Home Secretary turned down his application for leave to remain longer in the UK, as she had done, she was obliged at the same time or shortly afterwards to exercise her statutory power to direct that he be removed from the country. And that she hadn't done. That was the complaint. The reason for this rather counterintuitive complaint, that she'd acted unlawfully by not trying to evict him from the country, was that the mere refusal of further leave was unappealable, whereas the direction for removal carried a right of appeal to a specialist immigration tribunal. And there the claimant could argue that his human right to a family life, which, as you know, is very controversial in the UK these days, would be infringed by being removed. And so he could try to get to a stage where he couldn't be removed, and hey presto, he'd be back in the position he should have been in, he says in the beginning, where in fact he was given leave after all. So the Home Secretary, it was said, was obliged to exercise her apparently discretionary removal power so as to facilitate his access to the tribunal. And one judge in the Court of Appeal, in a 47-paragraph written judgment, accepted that argument. The other two judges simply said, I agree. In the other case, that argument was taken even further, and the point was, the argument was this: if the Home Secretary made an order refusing leave to remain, without at the same time making this removal decision, which the earlier case had said had to be made, then the order refusing leave was itself unlawful. And one judge, over 125 paragraphs of written judgment with 83 footnotes, accepted this argument. Another dissented. The third, without giving any reasons of his own, simply said he agreed with the first judge. Now, I suppose the arguments had a superficial attraction, but with all respect to the judges who accepted them, both were bad ones, and I'm protected in saying that by the fact that the Supreme Court shortly afterwards held so in a short and pretty withering judgment on the subject. When Parliament had said that the minister may decide to remove somebody, it was pretty hard to see that it could have meant that she must do in certain circumstances. And yet one judge in each case had managed to write a judgment which concluded that these bad arguments were good ones. I might, of course, be grievously wronging the judges who merely said, I agree, rather than setting out their reasoning for themselves. Perhaps they'd written a long draft judgment and then not bothered delivering it because there wasn't a point, because they agreed with the judge. But if that wasn't the case, I do wonder if the Supreme Court might have been saved some trouble if only there had been an attempt to write a concurring judgment. Well, why do I say that multiple judgments, including dissenting ones, are good for the law? It's a related point, I think, but it's because I think soundly based principles are likely to be capable of being explained in more than one way. And if a principle has been so explained, and indeed the arguments against its being the right principle have also been explained, then a court which comes to the problem later has a much better chance of understanding the underlying principle than if it is simply confronted with a unanimous sort of quasi-legislative pronouncement as to what the law is. This comes back to a point that one of the speakers made earlier about trying to understand the underlying principles that apply rather than simply looking at the superficial level. And examples of those sort of quasi-legislative statements crop up quite a lot in the case law of the European Court of Human Rights in Strasbourg. Even though it does permit dissenting judgments, in practice its judgments are on somewhat similar lines to the European Court of Justice. Some years ago, for example, the court was asked to rule whether it was an infringement of Article 5 of the Convention, which protects the right to liberty, except in certain enumerated cases, for a man to be detained in a super high security mental hospital, Broadmoor, rather than the more liberal establishment for which his doctors said he was now suitable. And the court said that while it is accepted that there must be, and I quote, some relationship between the ground of permitted deprivation of liberty relied on and the place and conditions of detention, Article 5 was really, they said, about detention or no detention, not about conditions of detention, and so his claim failed. But that formula that they put into their judgment, some relationship between the ground of permitted development and the ground of permitted deprivation of liberty relied on and the place and conditions of detention, has gradually acquired a sort of life of its own in the cases, and it's been applied over and over again, somewhat mechanistically, where in cases where really the complaint was about the conditions of detention. So the court has effectively executed a sort of 180-degree turn without ever actually saying that it's done that, simply by reapplying this formula over the years. And as a common lawyer, one wants to read a judgment where the judges really debate what the underlying principles are and how they apply. There are, of course, many other arguments in favour of dissenting judgments. As judges have pointed out, sometimes in articles and elsewhere, the need to respond to a dissenting judgment can often improve the quality of the majority judgment. It can force the judges to hone their opinions. And dissent can also curb the majority from making over-expansive claims. And, of course, in principle, one might say it's simply positively healthy for the fact that judges disagree about these things to be acknowledged and to be there on the face of the record. What about practical uses, though, for dissenting judgments? Except in those cases where we're actively trying to get a court to agree with the previous dissent, should we read them at all? I would say that we should. A majority judgment is likely to contain the facts, the legal background, the reasons for the decision. But it's very often by looking at the dissenting judgment that we get a direct route to the essence of the majority reasoning. Reading that can highlight, perhaps more easily, in fact, than reading the majority judgments straight off, not that I'm saying you shouldn't read them as well, the key point on which the case turns, and that's what it's really about. And indeed, often the essence of a particular subject can be quite well discerned from the dissenting judgment. So, to take some examples that you've already heard about in this conference, it seems to me one could make quite a good argument that Professor Juss's paper makes the point that if you want to know more about legitimate expectation, study Lord Brown's dissent in the Paponet case. Robert Strang's paper suggests that if you want to know more about the meaning of a threat to the life of the nation, look at what Lord Hoffman said dissenting in the Belmarsh case. Similarly, you heard from James Guthrie, QC, about judicial bias. Well, why not study what Lord Brown said in dissent in the Baileys case? Indeed, one might even say, although it's perhaps stretching it slightly, that as Peter Knox reminds us, if you want to know about the Magna Carta, read what Pope Innocent III thought was wrong with it, and that will tell you exactly what was right about it. The final thing I want to touch on, returning to my rather presumptuous advice about dissenting, is the question of style. How should one go about it? If I'm right to say that dissenting, like marrying, is something which is not to be done unadvisedly or lightly, then I suppose it might follow that when it is done, it should be done reverently and discreetly, if not necessarily in the fear of God. Certainly that's the common law tradition. Mr. Justice Wilson, who was then a relatively new first instance judge, was brought into the Court of Appeal a few years ago to make up the numbers in an appeal. And I think he got it right in a case called Medcalf. He said, notwithstanding my profound respect for the two senior members of this court, ... and then went on to explain why they'd got it completely around their necks. And must presumably have been not entirely displeased to have been vindicated when the case went to the House of Lords, and his view was the basis of the decision that the House of Lords took. There is, of course, a certain amount of what the Germans might call vanity and disputatiousness, to go back to their 19th century criticism of dissenting judgments, and dissent can be pointed, and it may not, perhaps, for example, have been strictly necessary for Lords Hoffman and Roger to allude to Molière in explaining why the majority had got it wrong in the Cartwright case, but by and large, I think that we can say in the common law world the tone is quite civil, and so should it be. Not so, of course, in the United States, which here, as in some other respects, performs, I think, that great nation's occasional role of serving as a living warning to other countries about how things might go wrong if they're not careful. I'm not an American constitutional lawyer, of course, so it's not my place to say whether Justice Scalia was right or wrong to disagree with the majority decision in the United States in Windsor, which was the case about same-sex marriage, nor indeed whether he was right to feel highly provoked by that decision. But I do hope that we do not see a day in England or in Trinidad and Tobago when the minority feels that it has to accuse the majority's reasoning of being jaw-dropping, bearing no resemblance to our jurisprudence, and of amounting to little more than a disappearing trail of legalistic argle-bargle. If it gets like that, I think we know we are in trouble. Thank you.
Thank you, Tom. That was both informative and entertaining. And coming from the land of hyperbole, I couldn't help but pay particular attention to it. Actually, I've always had a special interest, indeed a sympathy for dissenting opinions. I attribute that to another former professor of mine. I've already mentioned a couple, but Sir Karl Popper used to teach us that we actually learn not from getting it right and truth to truth, but by our mistakes and getting it wrong. And so I've often been tempted to turn, as I read my newspapers backwards, starting with the sports and man's achievement and going forward to where man's failings. I often start with the dissenting opinions, not just for the reasons that you gave, which I thought were very good ones, but for that reason as well. Well, again, bursting with pride, I'm going to invite two more rising stars from Three Hair Court to the platform, Hafsah Masood and Rowan Pennington-Benton. If you could join me here on the stage, and I'm going to once again truncate my introduction of them and refer you to the bios that you have, but you'll see that Hafsah has a broad-ranging practice, which is public law oriented and civil law oriented, and includes a developed human rights practice. And I particularly want to brag about the fact that she has co-authored with a former head of Chambers of Three Hair Court, a very important book that Oxford University Press has published on the protections of religious rights, law, and powers. Rowan is, again, someone who, both of these speakers have experience of this part of the world and have great interest in this part of the world. And Rowan is another one who has undertaken public law and human rights cases as part of his ranging practice. And I think they're going to both talk to you now about constitutional damages. I'll turn over to you.
Thank you, Jeff, and good afternoon, everyone. Rowan and I will be looking at the contribution of the Caribbean to the development of the remedial landscape in constitutional law, and in particular the development of the remedy of damages for infringement of fundamental rights provisions. Now, as it happens, many of the seminal cases in this area on the issue of constitutional damages are from Trinidad and Tobago. I will begin, I hope briefly, by considering some of these cases and charting the development of the jurisprudence in this area. I will then hand over to Rowan, who will consider the influence of this important jurisprudence in other Commonwealth jurisdictions. Now, starting with the relevant provision of the Constitution of Trinidad and Tobago, the relevant provision is Section 14, and this is a provision which has received mention a number of times this morning, and it provides that an applicant may apply to the High Court for redress for contravention of the rights enshrined in the Constitution, and the High Court may make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing enforcement of those rights. Now, this provision, or to be more accurate, the predecessor provision in the Constitution, felt to be considered in the case of Maharaj No. 2. Now, it would be a stretch to say that this is a recent decision, but as Mr. Maharaj rightly described this morning, this is a landmark case, and no discussion of this topic would be complete without at least a mention of it. Now, the facts are no doubt well known. Mr. Maharaj was committed to prison for 7 days for contempt of court on the order of a High Court judge. Now, the judge didn't make plain to Mr. Maharaj why he was committing him, what the nature of the contempt was. And Mr. Maharaj duly claimed redress for contravention of his right not to be deprived of his liberty save by due process of the law. By the time the case reached the higher courts, Mr. Maharaj had served his 7 days and had been released, so the contravention was in the past. Now, before the Privy Council, by majority, it was found that there had been a contravention of Mr. Maharaj's constitutional rights. But what was the nature of the redress to which he was entitled, bearing in mind the contravention was in the past? It was argued on behalf of the Attorney General that the right to redress didn't include compensation. And that was because payment of compensation didn't amount to the enforcement of rights within the meaning of what was then Section 6. The PC disagreed. It was held by Lord Diplock that the order for payment of compensation was clearly a form of redress which a person was entitled to claim when a right protected under the Constitution had been contravened. And in a case such as this, where the contravention was in the past, this may well be the only practicable form of redress. Now, the case is not only important for establishing that compensation is available as a right, as a form of redress in constitutional claims, but Lord Diplock also made some observations about the nature of the claim. He observed that it was not a claim for damages in tort, but a claim in public law for compensation. It would include, in this case, loss of earnings consequent on Mr. Marriage's imprisonment and recompense for the inconvenience and distress suffered. Now, as I say, Maharaj was undoubtedly a landmark case. However, it did leave unanswered many questions. Now, we've heard from Tom the value of dissenting judgments, and Lord Helsham, in his dissenting speech, anticipated some of the questions that the courts have since had to grapple with. He said, and I paraphrase, "We are told this is not an action of tort, but if it's not a tort but something sui generis, on what principles are damages to be assessed? Are punitive damages available? And if not, why not? How far may aggravated damages be awarded? And finally, are damages to include a sum for injured feelings or damage to reputation?" Now, Lord Hailsham, I would suggest, hit the nail on the head to this extent. It's clear, if one looks at the case law since Maharaj, that courts, whilst acknowledging that this is a distinct cause of action and that tort cannot be an exact analogy, have struggled to distance themselves completely from the language and principles of private law. Now, the question whether exemplary damages or punitive damages may be awarded by way of redress for contravention of constitutional rights was considered by the Privy Council in the well-known case of Ramanoop, which was also an appeal from Trinidad. Now, the significance of Ramanoop goes beyond the narrow point which was an issue in that case, which, as I said, was whether or not exemplary damages were available in constitutional claims. It also gave the board an opportunity to consider the function of constitutional damages. Lord Nichols, in a speech which has been recited in almost every case since on constitutional damages, held that when exercising its constitutional jurisdiction, the court is concerned to uphold or vindicate the constitutional right which has been contravened. So how might constitutional rights be vindicated? Well, Lord Nichols held that if the person has suffered damage, the court may award him compensation. Now, this is a concept which common lawyers will be familiar with. It recognises that the breach of an individual's rights may cause a person loss which should be remedied. This loss may well be pecuniary or it may be non-pecuniary. But Lord Nichols went on. He said that an award of compensation will go some distance towards vindicating the infringed constitutional right, but it may well not suffice. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, to emphasise the importance of the constitutional right and the gravity of the breach, and to deter further breaches. Now, this second limb, the additional award, is an acknowledgement that the enforcement of constitutional rights is something in which the public, and not just the individual, has a stake. What Ramanoop clearly establishes, and which has been a principle that's been restated in a number of cases since, and not just cases from Trinidad, but, for example, the case of Merson, which was from the Bahamas, that the overall purpose of constitutional damages is vindication. It's not to punish the state. And this is why, perhaps, constitutional damages, and in particular the additional award, has come to be known as vindicatory damages. Now, in Ramanoop and in other cases which involve misbehaviour by the police, there is typically often not an issue about whether or not the applicant is entitled to damages. The question is normally how much and how much are they entitled to, and what type of damages are they entitled to. The facts in a case called James and Attorney General were rather different. In that case, a police officer complained of the failure to grant him an exemption from the language component of the qualifying examination for promotion to the ranks of corporal and sergeant. Now, although he was not entitled to an exemption, other officers in his position had received exemptions, and so he claimed that he had been discriminated against and unfairly treated contrary to the Constitution. The issue that arose in that case, and I would suggest this is again a throwback to private law principles, was must the claimant prove that he suffered damage as a result of the breach before he can have access to the court's discretionary power? In the board's view, there was no requirement that damage beyond having been a victim of a breach of constitutional rights had to be shown before compensation for the breach of the right could be considered. Having said that, entitlement to compensation was not automatic, where a violation of a constitutional right had occurred. That, of course, would undermine the discretion that had been invested in the court by Section 14. So the fact that Mr. James had been a victim of discrimination did not bring with it an automatic entitlement to compensation. The board suggested that where there had been no major impact on the claimant, a declaration was more likely than not to suffice. And the board, on the facts of this case, concluded that there was no acceptable evidence that the appellant had suffered injury to his feelings or particular distress. Despite having been denied the exemption, he had in fact been promoted, and he had continued in the rank of acting sergeant. As to the additional award, the Court of Appeal had considered, and I would suggest entirely sensibly, that theoretically an additional award might be made even if no compensatory award had been made. The board, however, preferred to reserve its opinion until a suitable case arose. This, in the board's view, was plainly a case in which an additional award was not appropriate. Now, the most recent case on the issue of constitutional damages, at least from the Privy Council, is a case called Allain and Attorney General. Now, this case, in a sense, also concerns proof of loss. It was a claim by the, and again, it was an appeal from Trinidad. It was a claim by the municipal police officers whose complaint was that they had been treated less favourably than regular police officers, including the failure to enact regulations which, among other things, would have provided them with a mechanism for resolving pay disputes, and that would have included a scheme of consultation and dispute resolution. Regular police officers had the benefit of such a scheme, they did not. Now, the Court of Appeal, having accepted that there had been a violation of their constitutional rights and that they were denied such procedural provisions as they were entitled to, didn't consider it appropriate to award compensation because it was thought that an attempt at an assessment of compensation would be an exercise in speculation, and it would be difficult to compute because no one could predict what the outcome of a pay dispute would be. The Court of Appeal also refused to make an additional award since the failure to enact legislation was not so much a question of willful neglect in the Court of Appeal's view as one of administrative sloth or inertia. Now, I would respectfully say that the decision of the Privy Council in this case is not as clear as it might be. The board held that while an award under Section 14 need not necessarily amount to the full financial loss which the injured party may have suffered, conversely, in some cases, it is right that an award should go beyond the amount of pecuniary damage which the injured party may be able to prove. Indeed, the fact that it may be very difficult for the complainant to prove a loss measurable in strictly financial terms in a case where there has been a serious violation of his constitutional rights may be a good reason for adding an amount to mark the importance of respect for the constitutional right which he has been denied. Such an award has attracted the label vindicatory, and I'm reading here from the judgment, although any award is in a real sense intended to be vindicatory, but it has the character of a general award. Now, general award, according to the board, provided tangible recognition of the value and the importance of the complainant's constitutional rights and vexation caused by their denial, albeit incapable of measurement in financial terms. In this case, an award of damages was appropriate. There was cogent evidence that the municipal officer's inability to present their case conditions to an independent adjudicator was likely to have caused them loss, Denial of their rights were long-standing. The fact that there were speculative factors was, in the board's view, not a good reason for denying the assessment. Now, the reason why I say that the decision is not as clear as it might be is because it appears to me that it blurs the boundary between the distinction that was made, whether intentionally or not, in Ramanuk between the compensatory award and the additional award, what's now been styled as the general award. And I doubt that this is the last we've heard on the issue. At the very least, what it does is appear to suggest that even in a case where a complainant can't prove financial loss, they may still, in an appropriate case, be entitled to an additional award. Now, it's been over 35 years since the case of Maharaj, and we can see that the jurisprudence in this area is still developing. I'm now going to pass over to Rowan, who's going to consider the influence this jurisprudence has had in other Commonwealth jurisdictions and how they've dealt with the various issues that the Privy Council and local courts have had to grapple with.
Well, Hafsah is of course right that many of the most important cases in this area do stem from Trinidad and Tobago. I might suggest that there could be something of correlation between that and the presence of a certain Mr. Ramesh Maharaj, who appears to have something to do with the majority of those cases. But it is, of course, a very important addition to the case law, and it has had influence in other areas in the Commonwealth, including in particular Canada and New Zealand. I'll take you to those cases in a moment. Very interesting, of course, to hear from Thomas Rowan, his interesting talk on dissenting judgments. It was, of course, the dissenting judgment in the case of Ramesh Maharaj in the 1970s that was eventually upheld as being the correct approach by the Privy Council. I only wish I'd been advised earlier in my career, perhaps at university, that all I need to do is to read the dissent in the case to fully understand an area of law. I might have saved myself a few hours of time, but there we are. Those of you that are still studying can take that on board. And there's three main areas in which I say the Caribbean case law has influenced the common law, the development of the common law. I'm only going to flag them up in relatively brief terms because it's been a long day, and if it was 65% for Mr. Rowan, probably somewhere dropping some overlay there for me. But the headline, are as follows. First of all, I say that the Caribbean case law on constitutional damages has assisted in understanding in other parts of the Commonwealth what is meant by constitutional redress, and that such redress must include, in appropriate cases, an award of damages. First of all, the obvious point that the case of Ramanuk and those cases that have followed have been applied across the Caribbean in other jurisdictions with similarly worded constitutions. In Blomquist, Commonwealth of Dominica, a case called Innis, St. Kitts and Nevis, and Taki Tota, the Bahamas, and much more recently in a case called W in the Attorney General of Antigua and Barbuda in 2013. But that case law is not just about legislative interpretation and the meaning of redress under a constitution. It's about an underlying and important point of principle, and that is that there must be full and sufficient available redress under a constitution in order to give full effect to the rights contained therein. It is, I say, about the development of a modern conception of the rule of law. An example of this can be seen in a case called Gary and the Attorney General. That's a case from Grenada, 2001. The appellant sought to enforce an order that was requiring the Minister of Finance, the rice mile goes out to Mr. Maharaj at this point, requiring the Minister of Finance to pay the balance of compensation due in respect of lands confiscated by the state. It was contended that the court could not enforce the order against the Crown. The board went up to the Privy Council. The board rejected that analysis. It held by reference to the case of Maharaj, number 2, as follows, per Lord Bingham, to deny the appellant on the present facts the remedy he now seeks to enforce
his constitutional rights would run counter to the board's constitutional decision-making, exemplified by Maharaj and later another case called Observer Publications. It would also run counter to the trend of constitutional decision-making elsewhere. It refers there to a case from Canada. The Crown was held to be subject to the provisions of the Constitution in the same ways as any other individual. The right to claim damages for constitutional violations is part of a package of measures, essential, I say, for the effective protection and enforcement of constitutional rights. More recently, there's the decision of the Supreme Court of New Zealand in Mervyn Chapman and the Attorney General. In that case, the Court of Appeal, in accordance with its then practice in criminal appeals, refused the claimant, or refused the appellant, I should say, legal aid. He was intending to appeal against his convictions for, amongst other things, sexual violation. Well, I didn't say of what, but that's all the report said. But at that time, the Court of Appeal refused legal aid and then dismissed the appeal on an ex parte basis, which was held, perhaps unsurprisingly, by the Supreme Court to constitute a breach of the right to fair trial under the Constitution. Now, the Attorney General ran the argument there that your courts disposed of some 20 years previously, namely that constitutional damages could not be sought other than as against the Crown for its servants, in other words, not against a breach of the Constitution by the judiciary. Well, the board referred to the case of Maharaj, number 2, and noted that the Privy Council in that case granted a direct remedy by way of damages for judicial breach of constitutional rights of due process. The judge continued, speaking for the unanimous court, I would continue to apply the principle in New Zealand because I think the approach is consistent with the obligations imposed under the New Zealand Bill of Rights Act and is supported by international and comparative case law. So that's the first thing I think we can take from the Caribbean case law and its influence as far out as New Zealand. The second contribution is this notion that I think Hafsah touched on, that constitutional damages are a standalone public law remedy and that it's aimed at the vindication of rights. That important notion has assisted other countries in getting to grips with claims made for damages under even very differently worded constitutions. But similarly to Tobago, in case with constitutions that do not expressly say you can claim for damages, it simply says under the South African constitution at that time, the court has power to grant appropriate relief. In a case called Foes and the Minister of Safety and Security in 1997, reference was made to the Caribbean case law in this earlier, and it was held that that included and must include, to uphold this principle of effective redress under the Constitution, to a right to claim damages in an appropriate case, and highlighted once again that it's a constitutional right, a public law remedy for a public law wrong. The next case is a Supreme Court of Canada case from 2010 called Allen Cameron Ward against the City of Vancouver. This is a case which, in which the police had received information that the claimant had intended to throw a pie at the Prime Minister at some sort of ceremony. I can't tell you what sort of pie. It seems to me it could be a material consideration. I mean, different pies might cause different types of damage. But anyway, I don't know any more information on the pie. Perhaps I should have Googled that. But anyway, whatever type of pie it was, the police took the potential pie throwing incident incredibly seriously and rounded up the pie-wielding attendee of the ceremony and strip searched him and left him in a cell and impounded his car, only to realise, in fact, he wasn't the pie-wielding attendee of the ceremony, who apparently didn't face justice. Anyway, perhaps unsurprisingly, the actions of the police were held to be a breach of the Constitution. Again, the Supreme Court of Canada made reference to case law from this part of the world and drew from that properly that constitutional damages are there to vindicate the rights of the individual. The court said that vindication included in the sense of affirming constitutional values. That is because, quote, violations of constitutionally protected rights harm not only their particular victims, but society as a whole. This is because they impair public confidence and diminish public faith in the efficacy of the constitutional system. Particular reference was had again to Ramesh and the acceptable aim of the award of constitutional damages, including, in an appropriate case, whilst not being punitive, deterrence. I mentioned just very briefly the Supreme Court case of New Zealand, if I haven't already, called Mervyn Chapman. It'll be on my note that I post on the website afterwards rather than going all the way through it, but similar conclusions are reached. So again, we can see the Caribbean case law in this area is having a very significant impact and effect both on the argumentation before the courts and the final decisions arrived at. The last category of cases I want to touch upon in respect of which the Caribbean case law has had an impact is actually the development of the private law, of damages in private law. In Ashley and the Chief Constable of Sussex 2008, the claimants, this is a House of Lords decision 2008, the claimants were the son and father of a man shot dead by the police during an armed raid on his home. The family brought an action against the police in negligence for damages, but the Chief Constable very sensibly conceded liability for negligence and agreed to pay basically whatever damages they fancied. But undeterred by this, the family wanted to continue with their claim, and the issue that went all the way up to their lordships in the House of Lords was whether there was any purpose to continuing the claim in circumstances where in a private course of action, notwithstanding it being against a state body, in a private course of action, you've got your damages. What's the point? Well, Lord Scott said the point is, by reference, interestingly, to Ramesh and the Caribbean case law, vindication. And by majority, they were allowed to proceed with their claims on the basis that part of the award of damages and part of the finding of a court is actually about vindicating your individual rights. So you can see here quite heavy cross-pollination between public law, private law, and the jurisprudence of this part of the world on constitutional damages. So it's having quite an interesting impact across a wide range. The very last case, just to add something into the mix, is a case called Lumber, the Crown on the application of Lumber, UK Supreme Court case again in 2011. Claimants claimed damages for unlawful detention pending deportation. The Secretary of State effectively applied a hidden policy on the detention of unlawful migrants. But it was held in that case that even if she'd applied the correct published policy, they still would have remained in prison. So the question was, or not in prison, in detention, but the question was, well, again, the point, there's no damages. Well, up to the Supreme Court on one point, which was, well, should they get vindicatory damages? You're not going to get damages other than nominal damages for false imprisonment because you'd have stayed in prison anyway, but can you get vindicatory damages? Well, reference was made to Ashley and the House of Lords decision in that case, but Lord Dyson was rather less keen on this than Lord Scott, and had the following to say. Implications of awarding vindicatory damages in the present case would be far-reaching. Undesirable uncertainty would result. If they are awarded here, then they could in principle be awarded in any case involving a battery or false imprisonment by an arm of the state. Indeed, said Lord Dyson, why limit it to such torts? And why limit it to torts committed by the state? I see no justification for letting such an unruly horse loose on our law. well, what we can see from this, I think, as Hafsah indicated by reference to Alain, it's still very much an ongoing process. There's a dialogue. Much of that dialogue is being contributed to significantly and helpfully by jurisprudence from this part of the world. Let's hope that this continues and the exchanges like this continues and it keeps developing. Thank you very much.
And Rowan, thank you very much, particularly for the clarity of the presentations. I'm predicting that those are papers that people will want to read when we publish the proceedings from the program. It's certainly being reminded of the influence that jurisprudence from this region has had on the rest of the common law jurisdictions is impressive. It makes me think that perhaps we should revisit that question that was asked in Buchanan a couple hundred years ago about whether Cayman can pass a rule that should bind the rest of the world. I'm going to invite Richard Samuel to join me on the stage, another colleague from Three Hare Court. Richard has a wide-ranging practice, commercial practice, and with me, a particular interest in financial market cases and the relevance of arbitration, mediation, and more generally advocacy to those cases. He's respected for his advocacy skills and not surprisingly, therefore, much in demand as an advocacy trainer as well as an advocate. Now, Richard and I, we're just guessing, but it's a bit of an educated guess based on what we've been reading in the local press over the last couple of days, but we're just guessing that there might be heightened interest in this audience in international finance at the moment, on the way monies move around the international financial system. There is actually certainly heightened interest in London, where we packed our bags, in that question, in no small part because we have a case unfolding in front of us at the moment about benchmark manipulation, about LIBOR rigging in the markets. And I promise you, it's the tip of an iceberg. We're going to see that litigation run and run and run, and we're going to learn a lot that we may, until now, perhaps only could have guessed at. In the interest of time, I'm going to jettison a longer paper, and I'm really going to just try to make an observation, float a theory, reference a couple of things that, as we've thought about this, just don't make sense to us, and I want to get your reaction to that if we can. But also, in light of that, we want to throw out a few ideas about what some of us, and we need help for this, are trying to do to move us to a better place. We do all of this against the backdrop of the global financial crisis. And the observation that I want to make is that if you read your newspapers, I was just alluding to, if you read your newspapers, they're full of discussions about reform of the regulatory scheme of things, better financial market regulation, as a way of dealing with a number of the disappointments we've lived through as a result of that global financial crisis. So regulatory reform, though, regulation, to my mind at least, is more in the nature of preventive medicine. Now, preventive medicine is important. It's important in our personal lives, just as it is in the lives of our financial markets. But it's preventive medicine. And by analogy, the courts, judges, arbitrators, if that's where we go with our issues, they're our hospitals. And my question, my observation is, we just haven't seen anything like the coverage, the interest in reform and what we could do better to support our courts, our judges, to improve dispute settlement in this arena. Everything is looking at preventive medicine. That gives rise to a theory that I have, which makes that observation measure troublesome. And my theory is this, that judges who understand finance can be a huge ally of the regulators in mitigating global financial systemic risk. Judges who understand finance can do a great deal. In fact, when I was a young lawyer, I read the law and tried to keep abreast of the regulations, but I studied the cases. That's our common law tradition. That's where I got my roadmaps. The regulation is being rushed through. It's going to have to apply to a very dynamic marketplace. And judges who understood things could move us along that path as we needed to. But the corollary of my theory is that judges who don't understand finance are themselves a potential source of systemic risk. And that's particularly true in the modern scheme of things, where the markets trade frequently off of standard terms, standard contracts, a standard form contract that I had the challenge of holding the pen and writing when no one thought the business was very important, and now supports $600 trillion of trading, they tell me. I hope we got it right. But in any event, if a judge makes a mistake interpreting one of those terms, that mistake goes around the globe, infecting, contaminating trades far removed. It's given rise to a phenomenon that very often parties outside of a dispute may have at least as great an interest in the outcome of that dispute as the parties who are litigating it. And they may not spot the issue. They may have strategic reasons for ducking an issue. They may not have the resource to really develop it. Very interestingly, we've just closed a consultation period in London on a roles-building initiative, an initiative of the High Court and the Chancery Court, and they are proposing issuing advisory opinions in light of wider market interest in financial market cases, along with identifying specialist judges, expedited procedures, and other reforms. So that's my theory, if you like. And there's a lot at stake. It's complicated. It's very global, very international. No, these trades don't respect national boundaries. And it's troublesome, therefore, that historically our contracts have, without thinking about it, sent parties, wherever they may be located, to the same one or two courts for their dispute settlement procedures. Now, that may have made sense when it was a more homogeneous, localized, high credit marketplace. It makes less sense as the game spreads geographically as it has done, and as the matters at stake become as great as they are. It makes no sense, therefore, to put people on airplanes from some remote part of the world and say, you must go to England, you must go to New York, and maybe you have to convince a jury who would struggle to place your jurisdiction on a global map, to convince them of your case. It particularly makes no sense when you're doing that in a language which is not native to the parties, when you're doing that in a way that will bring, the most you can hope for is a judgment which may prove difficult, if not impossible, to enforce where it needs to be. That makes no sense. But at largest measure, that's what the game continues to be. Similarly, it makes no sense to send the parties to a local court where they can get a binding decision if the judges deciding those cases don't have the requisite experience, competence in a very specialized matter. That makes no sense either. My experience from the financial markets to date is that markets want certainty, but they'd rather have an unenforceable right decision than an enforceable wrong decision. And similarly, even in courts where there is, collectively speaking, considerable experience, it makes no sense to take the roll of the dice and hope that the judge that hears your case falls in that category of experienced judges. That makes no sense if we have a standing group of experienced judges, lawyers, marketeers who are standing ready to step in and provide that kind of specialized and expert determination. It makes no sense that we have special subject matter courts for everything from family law, juvenile crime, IP, bankruptcy, etc., but not for finance. World trade, the WTO has its own tribunal. Is world trade more, I don't know, global, more complicated, more systemically relevant than finance? I don't think so, but that's where we start from. It certainly makes no sense, with all that's at stake, to put all of our eggs in the single basket of better regulation. That makes no sense at all. So I'm going to turn to Richard, because we've been thinking about how we move on from this, and things that might make a difference. And as you'll hear, it's something that is not local to London. It's something that we're here partly to recruit and to, in a sense, hopefully excite people here to joining in the collaboration of getting us to a more logical place. Richard?
Well, it behoves me to be brief. I'm going to say a few words about the consequences of moving away from traditional forms of dispute resolution towards alternative ones like arbitration. Nowadays, financial services disputes may not be a large part of your practice, or the practice that you might be expecting to start as a student, because the banks your clients here are entering into agreements with banks on their terms, and those terms will choose New York or London as choice of law and choice of jurisdiction. So you would be handing those cases on to lawyers in those jurisdictions to deal with. So at the moment, it's not going to be a great part of your practice. But in the arbitration future that Jeff is talking about, then there's an obvious role for you. And the obvious role is to assist in the conduct of an arbitration if it's here, in Trinidad. Obvious also is your opportunity to help enforce the award. But less obvious is that wherever the arbitration is going on, if your client is here, as the matter is being arbitrated rather than litigated, you can continue to have a role in that case and collaborate with co-counsel around the world so that you can work together, as you do with counsel in the Privy Council, for example, to fight the case for your client. So in the future, as we move towards arbitration, arbitral resolution of these disputes, it will be part of your practice, we hope. So to make it part of your practice, you're going to need the right relationships with the right lawyers in New York and London to help you fight those banks. So what is it about the global financial crisis which is moving us in this direction? And what do you need to know if you're going to be fighting any of these financial services disputes? Well, the sentiment from after 2008 is that the system is rigged in favor of the banks because they'd been preaching the virtues of market discipline as an engine for economic growth. And they'd been visiting that market discipline on their own clients when they ran into headwinds and they were foreclosed upon. But when the winds, the cold winds of market forces blew against the banks, they were able to avoid those consequences. And it was the taxpayers who bailed them out. And so there's a sense in the markets, or in the political sense now which is developed, that there is an account which is yet to be settled in favor of the taxpayer at the expense of the banks. And so we have a global move towards heavy regulation from the kind of light regulation that we used to have pre-2008. So what does that mean for you as a lawyer? Well, when you're considering a case for a commercial client here, for example, with a hedging product against a loan that it may have, the obvious common law claims that you will be familiar with are misrepresentation of fact and negligent advice if the bank moved into the area of giving advice as opposed to giving no advice at all. That's what you'll be familiar with, of course, from your general commercial practices anyway. But since 2008, things have been moving rapidly in the regulatory sphere. And in London, for example, we've moved from the Financial Services Authority to the Financial Conduct Authority. And they have produced something called the Handbook, which sets out a whole series of statutory rights which are really rather involved and rather complicated. In fact, it's a bit of a misnomer because you can't even hold the book in your hand. You can't even print it out because it's so big. This is a large and rapidly developing area of the law. There's only one case I want to talk about, and that's the case of Rowley and Green versus the Royal Bank of Scotland. And this is a case from 2013 in the Court of Appeal in which there was, the issue in the case was whether these new statutory rights are coextensive with the common law. Is the common law following these statutory rights? Here's an example of one of the statutory rights to give you an idea of the kind of thing that we're talking about. I don't think they're drafted by titans of the common law, rather more by civil servants.
COB 5.4.2G, Principle 7, brackets, communication with clients, close brackets, requires a firm to pay due regard to the information needs of its clients and communicate information to them in a way that is clear, fair, and not misleading. Now, if that didn't reach its own high standard, it then goes on to explain the purpose of this section is to ensure that the firm takes reasonable steps to ensure that a private customer understands the nature of the risks inherent in certain transactions. So, if you cut through that, you can see that the judiciary, as these are now private law rights for certain kinds of customers, are having to cut through that kind of language to distill what rights your clients will have as against banks. And you can see, I hope, through that language, that we're moving from a situation in which the bank chooses whether it wishes or not to advise, to whether it is obliged to give sufficient information to its clients, so it is forced to give the advice to allow the client to make an informed choice. So that's the kind of stuff that you're going to need to know about. But the difficulty is that there's an awful lot of it, it's changing very rapidly, and the jurisprudence around it is only just beginning. So, as I say, the important thing is the right relationships with people in London to help, or in New York, to help you understand the latest regulatory changes which are giving additional private law rights to your clients which you're not necessarily going to be familiar with. So there we are, that's all I wish to say. I'm going to hand back now to Jeff. Thank you.
Thank you, Richard. By the way, it's not going to go away. If I ever thought that I was operating in a niche area, I'm constantly being reminded, if you drive into London on the M4 motorway between Heathrow and London, there's a big billboard. And remember, this is advertising to motorists and truck drivers. And it says, have you been missold a swap? If you have, call 0800, and there's a number. This is a different world that I think we're looking out at from the world we've looked back on. Well, we're again trying to save some time. I'm about to make myself the least popular person in the room. It's been suggested that we forego our coffee break. Anybody who needs a comfort break, please, by all means, take it, because it's going to take us a little while to get the next group, which is a panel, up on the stage. We're going to keep that as tight and as short as we can in order to get you also out on time. But we are trying to catch up a little bit, and Ronnie's at the right decision, you think, for us to make? So, sorry, don't shoot the messenger. But I'd ask Simon Davenport, Queen's Counsel, to join me on the stage and convene his panel. As he's doing that, I'll just say a word about Simon, and I'll let him introduce his very distinguished panelists. Simon, I've been talking about rising stars in the three-hair court. Simon's an established star in three-hair court. He practices in the areas of, in particular, and it's again wide practice that Simon has, but in particular in the areas of civil fraud, commercial dispute resolution, insolvency, and, as we've just been discussing, arbitration cases. But he heads our chambers groups in all those areas. So Simon, please, over to you. And, you know, somebody very clever once said, you're only as good as the company you keep. Simon's going to be keeping some pretty good company, so you'll see a big grin on his face, I promise you. Thank you.
Jeff, thank you very much indeed. Right, what I'm going to try and do is two things, capturing your attention. The first is to ask my panel members, please, to come up onto the dais here and get hooked up, because I think you're going to have to do that. And the second thing is just to make a couple of introductory remarks. Still holding on to your attention. I've been reliably informed that it's not just you I'm talking to, but in the entire population of Trinidad and Tobago, who are listening in as we speak on various radio stations. So it's not just hello to you, but hello to them, good afternoon to them. And they don't have the conference packs, so they don't have the CVs, and I'm going to in due course just introduce a number of the members of the panel to them and of course to you. However, seriously, we at Three Hair Court Chambers, I remind you, in the Temple, in the City of London, are absolutely delighted to be here today and to be in your fantastic country, which has wealth, strength, and if it's handled well and in the public and not necessarily merely the private interests, and if it's handled with moral self-discipline, has an amazing commercial future. We're very happy to contribute to the inaugural Trinidad and Tobago Legal Network. And we congratulate your leading lawyers on putting this network together, which, through its insistence on rigorous, open, fearless support for proper democratic and constitutional process, honours and decorates your country. Now, on the panel here, now assembled, we have an array of talent from lawyers in London and also in Trinidad. I'm just going to introduce a few of them to you, listening at home and also listening here. And we have Vijaya Hussain, the Senior Counsel, a most distinguished leading attorney and Senior Counsel of this country, topically in the limelight. I fear that the world will soon be hearing a lot about Mr. Hussain, not just in the country of TNT and in the Commonwealth. He has, of course, like a number of the senior lawyers in this country, itself not an uninteresting event, had important roles in the world of academics, political life, and corporate and economic activity. Next, I'd like to introduce Mr. Raj Kumar, Mr. Ravi Raj Kumar, hugely experienced, an excellent attorney in principally, but not only, serious criminal law cases. And anybody practicing in the Privy Council will be well familiar with his name from all the many cases that he's been involved in, which have got there. Lastly, on behalf of the TNT team, I'd like to introduce Mrs. Persad Salik, a highly experienced attorney, I think some 21 years in practice, and importantly an academic, and with long association with the Hugh Wooding School. Over to the London team wearing the red shirts, we've got James Guthrie, Queen's Counsel. Now, you've already had him introduced to you, so I'll keep it short and snappy. But make no mistake, he's one of the greatest British Privy Council lawyers there's been. He's immensely experienced across the entirety of the Caribbean and often appears there at various different jurisdictional stages. He's an administrative and public lawyer, and he has the added advantage of sitting as a deputy judge in criminal cases in the United Kingdom. And he's formerly, for many years, our head of chambers. Next we have Professor Satvinder Juss, and you've actually heard from him already. He is a distinguished law professor in King's College, London. He's a practicing barrister at the same time. And an attorney, as you might say, in judicial review administrative law. I had the privilege of leading him recently in an important Chancery Division case, determining whether the English Supreme Court could even hear a live appeal between warring religious factions about the justiciability of religious issues in English courts, and indeed the common law world. And lastly, by no means least, Tom Poole at the end there, who is a member of the A-list panel of Treasury work, doing the best and the most difficult government work. Both a judicial review lawyer and also a commercial lawyer. He and I have just finished one of the largest civil fraud cases to have happened in recent years, and I can attest to his brilliance. So, first of all, we're going to go to the questions, and I'd like to say thank you very much indeed for those of you who have given us a lot of questions. We're not going to be able to take them all, but we're certainly going to be able to take some of them, and thank you for everybody for making your contribution. So the first one I've got, and I'd like to choose Fayed for this one, please. Do the present arrangements regarding extradition proceedings, including the legislation, adequately protect an accused person? I think we can add in Trinidad and Tobago. Unless I've got it wrong.
The Americans would call it a curveball. in the Commonwealth, we call it a googly and a Chinaman ball with a piece of an in-swinger. We need to draw a line in the sand in this country between the procedure for extradition proceedings. Is that better? Pre-1986 and after 1986 and thereafter. What happened in the former legislative regime was that extradition proceedings were rooted in criminal law. So to have someone extradited, you had to provide the evidence that would ordinarily be provided if someone had to be committed to stand trial in the assizes. So therefore, there was no multiple hearsay evidence. There was no evidence from anonymous sources. There was no opinion evidence. There was some cross-examination. But the quality of evidence that had to be produced had to be first-hand evidence in some kind of declaration or witness statement or affidavit, as the case may be. And what the magistrate did is looked at that evidence and determined whether that evidence met the standard of a prima facie case that will warrant that committal ordinarily. What happened in 1986 and assumed momentum post 9/11, especially in the 2000 and thereafter, was the law, not only in this country, but a number of countries in the world, underwent very fundamental changes in respect of extradition. What it did is brought into play something called the record of case procedure. And two things happened. The world was divided, first of all, into Commonwealth countries and non-Commonwealth countries. In respect of Commonwealth countries, you had extradition on the basis of this record of case, but the evidence that had to be satisfied is evidence that was produced in a record of case, so there were no witness statements. There was no requirement for multiple hearsay, against multiple hearsay. Evidence could be obtained which was totally hearsay from anonymous sources, as the case may be opinion evidence. And that was the basis of a committal with no cross-examination and a summary of the evidence rather than the evidence itself. So that placed the accused in a very difficult position. But it's even worse in respect of a non-Commonwealth country. Because in respect of a non-Commonwealth country, the executive could agree to a treaty with the non-Commonwealth countries that made the evidential threshold even more bare. And therefore, they could qualitatively reduce even the meager provisions that existed with respect to Commonwealth countries. So I want to draw an example. Suppose, for example, there's this island in the Pacific called X. And there's this island in the Atlantic called Y. And therefore, someone in Trinidad is accused, or there's an extradition request in respect of him, in respect of something done in the island in the Pacific called X. What happened in X was that someone might have sent some money through Y to be paid to Trinidad. And Y in the Atlantic decides that it was going to pass a law that had extraterritorial effect through the entire world. In other words, it legislated extraterritorially. Notwithstanding the fact that the accused never visited country Y in the Pacific, he can be extradited, and he can be extradited on the barest of minimum of evidence. What we have now is that the rules in respect of someone is accused is much more onerous, so there is no equality of arms. Whereas the requested state can do so on a record of case which is certified by a prosecuting authority or even less. The accused person has to satisfy the requirement of reliability. He's now subjected to be extradited on the following criteria. First of all, opinion evidence. Secondly, multiple hearsay. Thirdly, no witness statements. Certification by a prosecuting authority from the requesting state. And therefore, the process of extradition is reduced to perhaps half a day and a couple of hours in the magistrate's court with no access at all to who has made those allegations, who are the anonymous witnesses, no cross-examination as the case may be. And the whole dynamic has changed. Now, that has to be looked at in the context of what prevailed before. And it also has to be looked at in the context of the fact that extradition law is extremely draconian. You're taken away from your home, You are deprived of freedom of movement. You are deprived of your family life. You are deprived of access to your loved ones. You are deprived of access to a home environment. And you are now subjected to charges which may not have an exactly equivalent charge in the country in which you live, as the case may be. The point about it is that the states of the world, especially post 9/11, have got together and constructed laws in respect of extradition that has caused a lot of hardship and made a lot of cut a lot of ground, a lot of rights away from the persons who have been extradited. There's one sign of hope, however, and that is that in this country we are fortunate to have the Court of Appeal. Justice Kangaloo, Justice Jamada, and Justice Weeks delivered a very powerful judgment about 2 years ago in a case of Ferguson against others, which I appeared in which they indicated that if it is that charges were laid here, they would apply the forum argument in respect of extradition. That is, they will apply the argument that you can be heard, or apply the principle that you ought preferably to be heard and tried in the country in which the offences were committed.
Thank you for that.
That's in a nutshell is what is the
Yeah, and quite a big nutshell. And I have a feeling we're going to be hearing that stated over the next weeks, months and years. But that is incredibly helpful, and it couldn't have been more topical to have heard that from Fayad. So thank you very much, Fayad, for that. But just before we leave that question, I'd like to ask Ravi whether or not you've got any comments on that, perhaps a different view?
Well, I don't think I have a different view. I think that the extradition procedures do, in fact, breach a lot of the fundamental rights. From the very beginning, it seems to be more of a rubber stamp than anything else. You have this record of a case that comes down here. There was the case of Peter Morgan, where all the evidence of Peter Morgan was by anonymous witness. And there was absolutely no redress at all for what was, I think, third-hand hearsay. It went to the High Court, and then because of the delays in the system, the client decided to terminate his road, or long route through the courts, and face the courts in America, just simply because it was taking too long. Again, a fundamental problem. The other difficulty you have is the almost automatic denial of bail in most extradition cases. You have a statute that says you can only deny bail for substantial causes, or where there is substantial evidence of a risk of flight or a risk of any of the three proceedings. But you come with an extradition proceedings and you're told extradition, the relationship between states is more important, therefore deny bail. And that fundamentally, I think, is a major problem.
Yeah, thank you for that. I think we've all got stories like that. I'm going to move on. I don't think anybody's brave enough from the English team to actually counter what's been said. If they are, they'll speak now. I think not. May I congratulate them on their wisdom of backing off on that. I'd like to move to another question, and I've got Mrs. Salick in mind to open the batting for this one. The citizens of Trinidad and Tobago, in the majority, are reluctant to make the CCJ the country's final appellate court. How do you view this? Thank you for that excellent question.
I'm curious to find out what kind of survey was conducted to gauge what is being said, that the citizens are reluctant. And we've been hearing a lot about the CCJ. In fact, it's been in the making for many, many years now. And the irony is that we have the seat of the court here in Trinidad and Tobago, but we've only signed on to the court in its original jurisdiction, not in the appellate jurisdiction. And to say that the citizens do not want the court, I think is I don't believe that there is any evidence to back that up. I think if you were to poll the citizens properly and the proper survey were to be done, we would find that yes, the citizens of Trinidad and Tobago, as many other citizens of the Caribbean region, are yearning for this court. We want this court. This ought to be our final appellate court. We have gone through many, many years calling for it, and it is a real mark of true independence to have the final court as the Caribbean Court of Justice. So I do not agree that the citizens are reluctant. In fact, I think they are more than willing to have it on board.
Okay, can I hear a different view across our panel? Yeah, Fayad.
Well, then I will say bring on the referendum as the case may be. Absolutely, let's prove it. But I want to make two short points. The first point is the notion in this country that somehow, if you have the Privy Council, it's a derogation from your sovereignty. And that's absolute nonsense. Because most of the countries in Europe have subscribed to international courts in Strasbourg and in Luxembourg, as the case may be. And it's not a derogation of their sovereignty. In fact, we, in this country here, initiated the International Criminal Court. Mr. Maharaj was Attorney General, and it's not a derogation of our sovereignty. That's my absolute position. And the second point I want to make is the issue of confidence. If we do not have the Privy Council and the wisdom of the Privy Council, the problem we have had in this country for the past 40, 50 years, as the case may be, and the quality of leadership and the quality of jurisprudence in respect to the Privy Council is unparalleled. And forgive me for making the third point, and it's the issue of any legal system has to be built on the basis of an international standard of all kinds of principles, whether separation of powers, whether rule of law, whether human rights, as the case may be. These are not subjective national standards. These are international standards. Yeah. And in the Privy Council, we get an opportunity to tap into a reservoir of high-quality jurisprudence that will otherwise be denied access to. And finally, I want to touch on the issue of interference with these courts, because do you know that the Chief Justice from the Court of Appeal of the other Caribbean islands was not appointed because one Prime Minister took objection to a judgment of his? And the problem that arises in all of these countries, the level of interference that is possible and the perception of interference in the judiciary. And we have to think about it very carefully. So I say bring on the referendum. Let us have a debate, let us go forward, let us inform the population, and let us take a decision as to what has to
Thank you very much. I'm going to get tougher as a... I do want to have an English view on this, so I'm going to ask James Guthrie to express, should countries like Trinidad and Tobago be, as soon as they can, trying to get total independence and join something like the CCJ, or should they do it either slowly, or should they not do it at all?
Well, I believe that it's a question which must be decided within Trinidad and Tobago. The debate should be held here. I think the Judicial Committee will always be there if it is wished by the populace, if it is still useful, if it can help, if it can contribute to democracy, then it is more than prepared to do so. On a personal level, can I make a small plea? Has this gone off? Can you hear me? Well, it's a small personal plea. I hope this debate will run and run for at least the next few years until I'm safely retired. Will not be, my practice will not have been removed from beneath my feet.
Thank you very much. Okay, we're going to move on because we've got a lot of questions. Next question. Is the presumption of constitutionality still an applicable principle in determining the validity of legislation? And I'm going to ask Fayad to open for the home team on that one.
This principle is a principle that arose out of the presumption of validity of normal commercial documents, and is transferred on to the presumption of constitutionality in respect of legislation where it does not belong. At the very least, it is occupying a neutral position. There should be no principle of constitutionality. It should be neutral. It was developed in a country in which Parliament is sovereign. Therefore, the will of the people found expression in legislation, and therefore a sovereign Parliament had to be respected. In this country, the Constitution is sovereign. And therefore, you cannot apply that principle to our legislation, notwithstanding what Lady Justice Hale said in Surat, and what was said in Grant, and all of those cases. So therefore, that principle should go. The judiciary should not be fettered with this issue of presumption of constitutionality. It should be allowed to do its work. It should not be differential to the legislature. It must have the full ability to reduce legislation, to declare it null and void without the encumbrance of the principle of constitutionality. I don't want to talk too much because I want to share the time.
That's fine. I'm going to move on to others soon, but I'd just like to end this because this is the TNT chapter of this talk particularly, before I open it all up a bit more globally. I'd like just one of the two, Mrs. Salik, do you have a view about this?
Yes, I wanted to say that with respect to the presumption of constitutionality, and we're talking about primary legislation in particular, but I think the next wave of litigation is really going to come with subsidiary legislation or delegated legislation and this whole presumption of constitutionality. Within the past, recent past, I should say, we've had two quick prorogation of parliaments, and Mr. Maharaj, you would know about that. And in that period, especially with subsidiary legislation, we have a procedure, constitutional procedure to follow. And I dare say that I'm not quite sure that that procedure was always followed. So to respect to Section 53 of the Constitution, Parliament may make laws for the peace, order, and good governance. I don't know that there has always been true adherence to that, and there may have been breach of that Section 53 with respect particularly to subsidiary legislation. So that presumption really can be rebutted.
Thank you very much indeed. Ravi, anything on this?
Perhaps I could just home in on the criminal side of it. The Bail Act, there was a recent amendment to the Bail Act in this jurisdiction to allow for the detention of persons charged with certain firearm-related offences for 120 days. Now, to me, that is both unfair and unconstitutional. The difficulty you have is you have a forensic science centre who is not able to provide a certificate of analysis to say it is a gun or firearm within 3 years. So you're almost guaranteed that a person arrested is presumed guilty. He's going to go and spend at least 120 days in prison, knowing fully well that no trial can start within that time. Manifestly unfair.
Right. Thank you. Could we pass the microphone down to the end, because I'm now going to ask a question which I think applies both in the UK and also in TNT and lots of other jurisdictions as well, which is within the context of civil litigation about what was perceived as the two enemies of justice in the civil system, namely delay and costs. Now, my own personal view is that after the introduction of the Civil Procedure Rules, the CPR, in England in 1999, that largely delay was tackled within modern civil legislation in litigation in the UK. I think the experience here might be slightly different, but I want to go to Tom Poole. Tom, what's happened recently? Are there any instances of us pushing the boundaries too much in our attempt to deal with either delay or costs?
Can everyone hear me without the microphone? Excellent. Well, I think there are two competing considerations. There's obviously the need for litigation to be conducted efficiently, and there's the need for cases to be dealt with justly and taking all circumstances into account. And it's quite common, and I'm sure all the practitioners in the room and all the students as well will have at least read or been involved in cases where a party in default has faced a significant uphill struggle, mainly due to lower courts' emphasis on the need for litigation to be conducted efficiently. And sometimes, in my experience and other practitioners I'm sure here, their experience is it's gone that way too far. And in England and Wales, there's been a number of cases following some reforms to the Civil Procedure Rules that removed the checklist for relief from sanctions under R3.9. And I understand, and I'd be interested to hear from the TNT representatives on the panel if the position is similar, because my understanding is in Trinidad and Tobago, it's a slightly more draconian approach to sort of procedural rules. So if you're in breach, then to a certain extent, that may be the end of the road for you. But certainly in England and Wales, there was a case that everyone's probably familiar with, Mitchell and News Group newspapers, that introduced a sort of three-stage test to a party in default. So take the classic example, you're late putting in witness statements. The three-stage test that would be applied under Mitchell was, first of all, was your non-compliance sort of trivial? And generally speaking, if it's trivial non-compliance, you're fine, you will get your relief from sanctions. If it is non-trivial, then the court would consider if you've shown sort of good reason for your non-compliance, stage two. If you have not shown good reason and it's a sort of non-trivial breach, you move to the third stage of the sort of three-stage test, and that is the very general catch-all. You look at all the circumstances. Now, there's nothing fundamentally wrong with Mitchell and all the cases that followed Mitchell. The problem was that the courts, and certainly lower courts, were applying Mitchell far too narrowly and in a fairly draconian fashion. And that's why you had a spate of cases where you have an example, a party putting in a witness statement or filing with the court a witness statement 3 hours late. You were not allowed to rely on that. You had to make your relief from sanctions, and relief from sanctions application was not allowed in one case. What followed is a bit of a rowback from Mitchell in a case called Denton, which again, even Trinidad and Tobago lawyers may be familiar with. It was a decision of the Court of Appeal, England and Wales, about 6 to 9 months ago. And what has happened as a result of Denton is it's a bit of a rowback from Mitchell. And now the courts have actually said in terms that parties that take sort of unmeritorious stances when it comes to short extensions of time will be penalised in costs. And so what you have, as I see it, is a situation where the courts have tried to interpret a change to the civil procedure rules which was designed to make cases more efficient and progress more efficiently. They've gone slightly too far the other way, and you're now having back from that. And the cases certainly following Denton, you have situations where relief from sanctions is granted more readily than it was under Denton. So I think that's
the English Court of Appeal has decided to clarify in Denton. When it's got it embarrassingly wrong, it clarifies it in a subsequent decision. I don't know how you deal with the language here. But I'm in the Supreme Court on one of these cases in November, if that happens. And Richard Samuel, who you've heard from this afternoon, and I are in 2 weeks' time doing another one of them in the Court of Appeal, where after 50 minutes we excluded, it was 50 minutes late, and we excluded the entirety of the evidence that the other side was going to rely upon, albeit because they were trying to introduce new documents and new arguments. So thanks, Tom, for that introduction. I would like to hear just from one TNT person about whether or not there is any experience of a like nature. So this is the expression, no good deed will go unpunished. This is the British courts doing their level best to not make, this is not new law, this is a judicial interpretation of what civil procedure rules should mean, and what is going to pass the test and what is not going to pass the test. So TNT lawyers.
We'll defer on this issue. One more interesting issues.
We've earned a fortune out of it, mate. I have to say, it's been a fantastic issue for us.
Quite a right first. In fact, 2 of the cases went to the Privy Council. I think that Peter appeared in them in respect of relief of sanctions and all of that, right? I think our law is draconian, but it's not pretty settled.
All right, okay, we'll move on. But in fact, I want to stay on the same topic, and let's stick with the TNT team. This is a difficult question, but it follows from delay, which is what mechanisms can you employ to get a judge to deliver his or her judgment when it's been outstanding for a long time? What is a long time in Trinidad and Tobago, and what can you do about it?
Ramesh and I have experience of more than 5 years in the Court of Appeal.
Oh dear.
Still not delivered. Court of Appeal. Now, you're caught in a conundrum. On the one hand, you want to write to the judge. On the other hand, you are concerned about subconscious bias, and I'm very, very frank about it. You're asked to satisfy very strict timelines in terms of witness statements, in terms of skeletal arguments. You're asked to leave your summer holidays, as in that case, and prepare for trial in September. And yet 5 or 6 years go by and you get no judgment, and it's very difficult. You're asked to deal with a situation where how do you handle that in the interest of the client and at the same time maintain as far as possible the dignity of the judiciary, as the case may be. So what do you do? It's a combination of persuasion, diplomatic savvy, and finesse. You have access to the Constitution, of course, under protection of the law. I think Luna did one many years ago from the Industrial Court. And fair trial rights are engaged as well, because you're entitled to a judgment within a fairly short space of time, which of protection of the law provisions of the Constitution and fair trial rights.
Sure. So this is all the formalities. Come on, practical answers. What do you do? Your client phones you up. No. No. Your client phones you up and says, I've had enough of this, do something about it, and do it this afternoon. What are you going to do?
You write the judge first of all. Your solicitor will instruct him, then he writes the judge.
Okay.
You get the other side to write the judge, you both write the judge, you go to see the judge, and if it write the chief justice, if it gets very rough, file an action.
File an action for what?
File an action for breach of constitutional rights in respect of fair trial rights and protection of the law rights, because I think the protection of the law rights and the fair trial rights include a right to be given a judgment within a reasonable period of time. And secondly, there is a legitimate expectation because the judiciary has imposed on itself a 6 months time frame in terms of when it ought to deliver judgments, which they extend from time to time. Yeah. But they have been good by and large, but there are instances of judges leaving the bench, for example, who have judgments to me who have never delivered it. One retired prematurely and went off somewhere else, and it happens.
We had a case where Sir Jeremiah Harman, James might know this because I'm going to ask James for a comment in a minute. Sir Jeremiah Harman, I think he was 18 months deciding, or nearly deciding, the case. Unfortunately, lost the papers in the meantime, which is slightly problematic. What can be done in England, James?
Well, I think one would probably get a more sympathetic hearing from the Chief Justice if one wrote. But I don't know that it's an uncommon thing to have a very long delayed judgment. I did have one from Trinidad where the judgment was delayed for a very long time and one of the appeal court judges died before it was delivered. And I'm afraid, just at the moment, I can't remember what happened.
Yeah, but I mean, pass it down the line. I mean, what can be done? You can't appeal something that hasn't been delivered. We don't have a constitution.
No. No, I mean,
take judicial review proceedings.
Well, I suppose yes. I mean, in the position in England and Wales, we wouldn't be able to, as you say, Simon, file a sort of constitutional sort of motion, but there is scope for a judicial review claim. I mean, it's very rare, as James said, it's very rare, and I can't see that action would be taken sort of lightly, but you could. And it feeds into legitimate expectations to a certain extent.
And also it feeds very much into Sir Fenton's speech this morning, which of course is that you've got to have a top-down vigilance has been used by Sir Fenton and also James and other people today. You have to have leadership from the top, and the public has to put pressure on its leadership to act appropriately from the top. And you have to, in bringing that pressure, that is how you percolate it properly, so that the pressure comes on the judiciary. In England, this doesn't happen generally because they're pretty scared of consequences. They're constantly being overseen about their delivery on various different things. And I can tell you the answer on lateness to fired is in the UK, it's 3 months. James Dingman's now become a High Court judge. He waits 3 months for a judgment. That's without a very good reason, already very late, black mark. Perhaps in Tom Rowe's secret book of that never gets opened apart from the minister. Okay, well, thank you very much, everybody, for that. That's very helpful. I'd like to keep with the English team to start with, and I'd like Professor Satvinder Juss to answer this one. It's a direct question. Has the law of legitimate expectation gone too far?
If you don't mind, deal with the one you just dealt with.
Yeah, please.
The Harman case is a unique case because it was so troubling that, as I recall, the parties took out insurance policy because they thought the judge was going to die. I mean, he delayed giving the judgment so long. And eventually, I think Derry Irvine, the Lord Chancellor, sacked him. It's one of the few cases we actually sacked him. And the remarkable thing was that Harman was the grandson of another High Court judge, so there's a long line of judges in any event. But the second point I'd make is just that monitoring the judiciary is actually very, very difficult because in most cases you adopt a carrot and stick approach. A carrot to induce the person to work better, a stick to apply sanctions. With the judiciary, you can't do that. It simply doesn't work. I mean, at best, if they're a full-time judge, you can say to them, well, look, you can't sit, but then they're still being paid. These days, you get appraisals, but I've even seen of cases where if the appraisal is negative, the recalcitrant judge will challenge the appraisal. So you're just creating problems, for yourself. The point that Simon makes is a very good one, that you do need leadership from the top. And I think increasingly people are beginning to realize that really those that manage the lead judges have to provide some kind of assistance and to be there to simply facilitate the writing of judgments, diction and the like and so on and so forth. But it is a very, very difficult point to deal with. On the question you just asked me, just very quickly, yes, I think legitimate expectations has possibly gone too far, because it is a juridical mechanism grounded in, the finest traditions of the common law, to be fair, to look at abuse of power. But as I say, it can be pretty erratic. and very often judges on the same facts will take different views. Would I do away with it? No, because I think the whole question of public administration, the whole question of abuse of power, which goes far beyond Wednesday unreasonableness, you've got offshoots like occasioning moral detriment, equality of treatment. There's a broad range of abuse of power areas. And I think all of these require the administration to act in accordance with the law. And where that doesn't happen, there are even cases now, which is sadly used to say that even rudeness in a court of law, there was a time when, in fact, judges appear to think that they have the right to simply be rude. Well, sadly, and the others have said, no, that's not right. The public law requires people to treat each other with decorum and respect and so on and so forth. So I think it's absolutely right that we do have this notion, but applying it in a consistent and intelligible and predictable manner is a difficult question.
Thank you. Just Fayad wants to say something on this.
2 short points. In contract, you have enforcement rights. You have enforcement rights in respect of various forms of estoppel. All of those are trust and contract rights. In respect of constitutional law, I think Pomponet got it right. It must be clear, it must be unambiguous, it must be free from ambiguity. And I think if the state makes a promise, it must be held to that promise. And there are enough safeguards within the parameters, like no election manifesto promises and all of that, that will put a curb on it, expand it beyond its present limits. Pomponet is good law, it is correct law, and it is a law by which you should stand by.
Thank you. I'd like to stick with the TNT team. We're going to move questions. Very good question, I think, probably from an English contributor. Biggest challenges facing the bar today and in the future. Keeping it to the most relevant and most serious. Ravi, what would you say from the Trinidadian perspective, looking at the profession as a whole, was the biggest problem?
I think the biggest problem we face right now is, in fact, delay in the system. When you look at the average length of time it takes for a trial to come up in the criminal courts, it's 6 to 8 years. You have a backlog of 500 plus capital matters, which means that those are persons in custody, with no accounting for the number of non-capital matters in the backlog. In addition, it seems as though trials are taking way too long. You will have a 4 or 5 witness case that takes 2 and 3 months. So there's got to be a way to control time, to forensically control the length of the time that a trial takes. And secondly, you've got to do something about the backlog and the delays. And otherwise, we're just going to go from collapse into complete rot.
Well, that's a great answer. That's more about the problems facing the justice system, but that's a very helpful answer to that. What about the bar as a practicing profession?
The problem is the legal profession in the Caribbean is very close to becoming a business rather than a profession.
Thank you.
Heavily commercialized. Profit is the incentive, not service. And there's a problem also in respect of legal training and the quality of persons who are allowed to practice at the bar.
Yes,
we have enormous responsibilities. Ours is not a business, it's a profession. I think people have forgotten that. And the second thing is that what you have is a relationship, a very difficult relationship developing between members of the profession and the business community and the political community. And the issue of profit again comes to the fore, not the issue of service and the issue of loyalty to the rule of law.
But isn't the marketplace, first of all, you have more training than less training than before. And secondly, the marketplace provides its own forces to shape the service that the community deserves and requires. So what do you say about that?
The marketplace has to be regulated. This is a profession like any profession that has to be regulated.
Okay, so it comes to the same thing, which is you've got top-down leadership. So what we need to do, the one thing I've noticed about the Caribbean states is that you've got more lawyers who have an important role to play in politics. Indeed, there's many on this stand who've done that. So, you should be obviously contributing to trying to shape the law so that there has to be regulation. What are the prospects of that?
The legal profession is a reflection of the political and legal health of the country. The problem is there has to be a more interventionist position on the part of the Law Association in respect of NGOs and most of all in respect of governmental authorities, where discipline is encouraged, as the case may be. And that is an issue which the profession has to come to terms with, and the profession has to take it by the scruff of its neck and demand more invasive powers
Well, that's very interesting.
Respect of the profession.
Well, thank you. So, lack of regulation. Can you pass it down the line? I'd like to hear from Mr. Guthrie first, and maybe Tom. We have plenty of regulation in England. So, the question was the biggest challenges facing the bar today, or maybe we'll start with Tom. What do you see it as?
I mean, personally, I think access to justice is the main concern I see for the sort of Bar of England and Wales, and really under threat by the Ministry of Justice itself and the savings that the Ministry of Justice are imposing. I'm not a criminal practitioner, but I'm married to a criminal barrister, and so I'm acutely aware, and perhaps more acutely aware than even if I was a practitioner in criminal law, from what my wife tells me, of the problems facing the criminal bar. There's been huge cuts to the criminal aid budget in England and Wales, cuts to professional fees. In civil law, you've got the increase in court sort of issue fees. Employment tribunal.
Just to stop and tell people, and now if you issue a claim for over £200,000 sterling in the UK, that's the top tariff, it's £10,000. It used to be £1,000, and before it was about £150 about 10 years ago, so it's gone up very quickly.
And when I'm wearing my employment law hat as well, in the employment tribunal in July 2013, they introduced fees for issuing a claim in the employment tribunal, and that saw a 60% decline in all employment claims that were issued. Now, that dramatic reduction in itself, I would suggest, means that the fees are probably too high to start with. But one reason that they introduced the sort of fee was to weed out what they perceived as vexatious claims in the employment tribunal. So disgruntled employees trying it on really with their employer. But there's been no discernible, the statistics show, there's been no discernible change to the outcome of cases. So it clearly shows that meritorious cases are just not being proceeded with because of the fees that have been introduced. So for me, I think it is access to justice.
Thank you. Satvinder, did you want to say something?
Yes, we used to have the highest per capita funded public litigation in the world, 1.2 billion per annum. In my undergraduate days, I learned that the law, like the writs, is open to all. I recall that now as with some, sadness, because the one thing which is clear is that it isn't open to all. And the employment case is a very good case because you walk into any employment tribunal building and the rooms are all empty. And there's been a dramatic fall in the number of cases that are going through. The £250 that's been charged by way of fee is simply beyond people. So, I mean, it's a catastrophe. And as I understand it, there's now a challenge, I think, before the European Court of Human Rights that the imposition of fee does actually militate against Article 6 of the right to a fair trial.
Fantastic. Okay, well, thanks for that. I'm going to move topics, and we've got a question here, which is what are the disadvantages of agreeing to arbitration? Obviously, that's in the civil context. And I think I'm going to start with that, and then we'll pass it around. I'm tempted to pithily say none. But I don't think that's the purpose of the question. I think the question really is a provocative one deliberately. And one could, of course, turn it the other way around. What are the advantages of agreeing to arbitration? I suspect the short answer is it's horses for courses. But there are factors which have an effect. I think it's very important, though, to be fully aware of it. I think someone like Trinidad and Tobago should be at the forefront of this form of awareness. It's an exportable product. When I went to St. Petersburg to do some lecturing in the International Legal Forum, we had basically all of the senior justice ministers around the world competing for a multi-billion pound or dollar business because the litigation services being offered, there were competing bids by Russia, France, and the UK, and others. But it's such an important business, apart from we're dealing with constitutional security, of dealing with the safety of people living lives properly in this country, which of course is an imperative. But a strength or a sign of strength of society is that you're able to contemplate other issues, other factors. As you get richer, as you get more secure in your own independence and in your role in the world, so you have to look to other achievements, not merely constantly trying to have a row or a fight about some constitutional provision, because hopefully not the whole world doesn't revolve around constitutional provisions all of the time. If you have commercial activity, you're trying to save 400 jobs in a factory, this is of a very pressing need for people in your society. Not everything has to be do or die on the beaches in some constitutional provision. You have to deal with getting by in society and progressing in society. And so arbitration offers you a fantastic location. Think of your geographical location. Think of also the meeting of your languages and your cultures with an English spoken here, an exportable, tradable product. And really make use of that as practicing lawyers. So my view is, having represented Russians, and we've seen what's been happening in Russia over the last few years, is that there is this consciousness of international security in litigation is of a very serious impact. We have instances whereby maybe 3 years ago, the view about litigating within Russia was a completely different view about litigating now. In the arbitrage courts in Russia, you might have been able to succeed. You might have been able to have a secure result. You might take a very different view to that now. So this neutrality of arbitration, don't overlook it. However, I'm asked to just kick off on the disadvantages. I think you could say that limited challenges are a potential disadvantage. In the Arbitration Act in England, you've got two routes, which are serious irregularity or a point of law. So if the arbitrator has simply got the facts horribly wrong, you might actually be stuck. And you've got to try and turn it in somehow to one of those two gateways to challenge it. Cost you have to pay for your judges, but in some cases, obviously, there's a lot at stake. As we've heard from Tom, the cost of litigation in the UK is going up anyway. Pro-publicity, well, you can take this two ways. Either what you want to do is you want the openness of open litigation to act as a lever in order to make a defendant that should be settling a bill, make them settle it, because behind the closed doors of arbitration, they might feel that they can just play games. On the other hand, it can encourage commercial activity and does have this enhancing effect, because what you can do is you know that if there's going to be a dispute, you can resolve that dispute in a confidential and secure environment. And of course, everybody might be playing with the same confidential information and value. So there's lots more that one can say, but I don't want to steal all the best lines. So do any other views over here about advantages, disadvantages of arbitration on a macro scale, and I think as the question had in mind, on a micro scale? No? Or not?
I can't let us be underrepresented on this issue. I agree with everything you have said. The difficulty that we have in arbitrating in small jurisdictions is some clients get the impression of Solomon justice. In other words, you have arbitrators where there is a perception, and it could be absolutely wrong, that somehow the arbitrators feel like giving both sides something and settling the matter on that basis, and that doesn't go for confidence. And that is the issue. On a larger note, I'm all for the fact that the taxpayer and the ordinary man in the street should not have to pay and put monies into a legal system to support large energy companies and large multinationals, as the case may be. That should be funded as amongst themselves and decided in a specialist forum that gives you quick access to justice on an agreed location with an agreed choice of law clause.
Yeah, that's a really great point. And also speed and control are very, very important. By the way, the good news is if you're very worried about onshore arbitrators and how it might be perceived, we can help you with that, because we provide a great deal of arbitration facilities. Well, of course. Anyway, but I think that speed and control are absolutely key. You can't criticise, half an hour ago, a system that has 5-year Court of Appeal judgments waiting, and at the same time be blind to the advantages of being able to control speed within arbitration. I would like to just do a pitch for Jeff, because I think he did a 1 week, $1.8 billion arbitration when I think he was sitting as one of the arbitrators a couple of months ago, and it was just right at the cutting edge of worldwide arbitrations in the capital markets, and it was a phenomenal achievement. Right, okay, I think we may have time for one question. Then I want to throw it out to the floor for 5 minutes, and then we'll wrap it up, I think. And it's back to public law. How your public law experts, this question declares, I'm pointing over there, what improvements could be made to the practice and procedure of judicial review applications? Don't be shy. A lot of listeners back in their kitchens around Trinidad and Tobago with bated breath about this question.
Well, I've just got one small experience from this part of the world, not here, but in Antigua, where an enormous amount of effort went into the leave application, when I think I would have expected leave to be granted by a judge having read the papers for 5 minutes. But we spent 2 days arguing whether the leave would be granted. And by the time we'd done that and leave was granted, we had to wait for another several months before we actually got the judicial review proper. So if that is something which is not an entirely single episode, then I think that the rolled up hearing of leave, and if leave is granted, the substantive hearing to follow more or less at once would be an improvement.
Okay. Could I have a TN2 view? Maybe Ravi or Mr. Stalick first and then back to Fayad. No? Okay.
We have in this country a dual system, the constitutional motion and the judicial review. And for those of us who practice at the public bar, we opt for constitutional motions because we don't need leave in respect of that. And judicial review could be very, very time consuming. And the second thing is that many of the reliefs which you could have formerly sought under a judicial review application, you can now get under a constitutional motion. For example, Papanet establishes the issue of legitimate expectation, which is really a judicial review ground, so to speak, as a protection of law point. So there's the conflation of them. The third thing is that many did a case called Sumaya Mohammed, in which we conflated for the first time in this country a judicial review matter in which we applied for constitutional redress, and that was permitted. And finally, we have a wonderful piece of law on judicial review. It has really opened up the system, and it's really the fifth estate, if you want to call the press the fourth estate, because there's always a wonderful opportunity to hold governments and public authorities accountable for their actions.
Thank you for that. Yeah, Tom.
Yeah, I mean, just really a practical consideration, going back to the question. I mean, to use the example of legitimate expectations, about 25, 30 years ago, you could have probably fit all you need to put about legitimate expectation cases in a footnote in the textbook. Now, today, we are overwhelmed by cases, just legitimate expectation cases. I think it was referred to earlier as an explosion of cases. And so, practical consideration, certainly over in England and Wales, is the administrative court is just overrun with cases. There are too many cases, not enough judges. And so what has happened in England and Wales is we've seen a lot more cases being sort of all filtered out at an earlier stage. You see a lot more cases now being decided by tribunals as opposed to judges sitting in the administrative court. And also, to pick up on the point we're making about access to justice, fees have been introduced as well to wheedle out what are perceived to be sort of the potentially unmeritorious cases.
Well, it's actually it's now more than 50% of all litigation in the UK is judicial review work. This, when the last day of the Second World War was being fought, there wasn't a single case. So it is an absolute explosion of a new creation. Okay, thank you very much indeed. I'd like to thank the panel members very much indeed. And I want to now... Yep, you can give a clap. Go for it. Thank you very much indeed. Now, but actually we're not done yet, because back to you, who've been listening and contributing patiently. But now is your chance to maybe ask one or two more questions directly, or alternatively state something after one of the answers that you've heard to those questions. Anybody like to volunteer, please? Thank you.
Just a comment on the issue of delay in the delivery of judgments. I'm a High Court judge. I don't think I've ever had a judgment that was outstanding for perhaps more than a few weeks. And that's really because at the end of the day, it's a matter of pure discipline. And I do think that the approach of the bar perhaps is a little too timid in addressing the judiciary on the issue of delay in the delivery of judgments. There was a Constitutional Reform Commission sometime, I think it was last year or 2 years ago. I actually presented a submission in which I suggested that there should be some kind of withholding of some part of a judge's salary. Well, of course, it didn't go down very well with my colleagues.
Funny that.
I think I was accused of bringing the judiciary into disrepute when the paper was published. But there has to be accountability. At the end of the day, all of us are lawyers. We know if you put something down for a few weeks, it's very difficult to get back to.
Absolutely.
And we're not doing magic. We're basically doing legal work.
Absolutely. And these days, with skeleton arguments and electronic passing of information, so the bulk of the facts can be actually taken quite acceptably from documents that you're given, chronologies and things like that. It should be possible to put these judgments together quickly.
I think it is possible.
But do you know what? I very much would like to hear your view. What most practicing lawyers are nervous about. I had to answer with Tom this case. We've been waiting for 1 month, and we won't name names, but while we've been in TNT, we've had a phone call from our senior partner instructing us on this colossal case, who said, should we be chasing the judge for the judgment? And actually, my view, see, English lawyer Theo Sully there looking horrified at the concept, quite rightly in my view, the nervousness of practicing lawyers is that even subliminally, that a judge might be negatively affected by the person who puts their nose above the parapet and dares to say, would you mind getting on with the judgment, please, Judge?
I think that's entirely misplaced, quite frankly. I think what has happened is because people are not held to account, because judicial officers are not held to account, they basically get away with just, I don't want to say laziness, but just get away with dilatoriness.
Yes, so if...
They just put it off.
In practical terms, are you encouraging an informal or a formal approach?
I think the time has come for a more formal approach.
So somebody to list an application before a judge in a judge's court to ask the judge for directions as to when the judgment might be expected?
There are very simple ways I think we can insist, and I think a part of our judicial code of ethics does suggest that you should actually fix a date for the delivery of judgment. And if you do, and that puts the judge under some kind of timetable to just do what he has to do. A judge's role is to decide. If you're not deciding, you are not doing your judicial work. You don't care a thing. So no matter how much time, no matter how many submissions we invite, no matter how many hours we put into the hearing of a case, we are not done until we deliver the judgment.
Thank you, Judge. That's an incredibly helpful contribution. Can we hear from Mr. Solly, who wants to express something?
In England and Wales, firm Sheridan's. And a number of points come to mind. Certainly in relation to that, one of them is that one of the advantages of arbitration, I understand, is that you can sometimes request a judgment to be provided within a specified period of time, and that's certainly an advantage to the parties then moving forward in a dispute of that kind.
Back to arbitration, you can say, I don't want to have a reasons, I just want a decision. But, or I want to have no appeals, or I want to have a limited reason decision. You can, that's the cool thing about
to the parties in that way, but I do also the Privy Council work a lot with a lot of the attorneys here and work closely with Three Head Court, and I'm often advising our clients in relation to judgments from the Privy Council that they do take time, and they often come several months, if not 2, 3, 4 months after the decision, when there's a lot at stake, and there's no prejudice, I don't believe, suffered to the parties as a result of that in any way.
But there's a very big difference, isn't there, Theo, between if you get a case to the Privy Council or the Supreme Court, it has had to be qualified, certainly as a Supreme Court case, as a case of national importance.
Yes.
And so it's not just your case that's affected and the facts of your case, but possibly affecting the shape of the law in the common law world.
A burden to parties in sort of litigating and but what's really important is obviously the energy that flows from lawyers at that junior stage, being able to feel that they can challenge those, pursue those actions in the judiciary right through to the highest court, and their ability to adjudicate on what become the very important issues there. It's obviously clear from what we've been discussing today, what's critically important is the independence and integrity of a judiciary. And I just wonder out there something that a maxim my father told me, and it comes to something we've already spoken about in the panel today in the CCJ, as to whether the grass is greener on the other side.
It was inspiring. It really was. I'm going to, in a minute, invite Peter Knox and Ramesh Maharaj to come forward. I think they should have the last word. So this is the last you'll hear from me. But I do want to say, because I think in no small part, I'm inspired by something that Ramesh Maharaj said earlier this morning about it not just being looking back over our shoulders, but it being about taking the law to where it has to go. The fact that that falls to us, and in some cases our clients, to be brave to do that. I would have thought that on the question of what is the biggest challenge for the profession, certainly from where I sit and looking out in large parts of the world, it's a challenge. Many of the challenges we heard about, the facts are important, have changed over time, but one challenge hasn't changed over time. It's the challenge of our profession to overachieve, to attract more than our fair share of the best people. You heard from the judge, we know that right people can make all the difference in the world. I'd just like to ask a question and then maybe say one thing that will perhaps inspire some of the students, younger lawyers in the room. I just want to ask on a showing of hands, how many of you were, like me, a university student in the 60s? Wasn't it great, James? We thought we were revolutionaries then. You missed all that. Sorry, nothing I can do about that. But I would argue that these are revolutionary times in the profession. Globalization, technology, again, contribute to that revolution. I can't think of a more exciting time to be coming into the profession. But it is about people, and it is about hard work. And again, I said it was a privilege and an honor for those of us who've made the trip from London to be here with you. I said it was also fun, and it has been. And now I just want to say it's been inspiring. So this is the last you're going to hear from me, but before I sit down, I'd be remiss if I didn't, and I'll ask those of you who would do it with me, thank all of our speakers for their contributions during the day. I want to do that first. And then I want to say a special thanks to the audience. If you've stayed the course, as so many of you have, you're to be congratulated. But again, it's important to us that this dialogue continues among all of us, and I'd just like to say a sincere thanks. I hope my speakers will join me in saying thanks to you, our audience. To sit down now, I'd invite Peter and then Ramesh, and I think we'd also like to hear from the network, last word, which I'll leave to Ronnie. But Peter, if you could take the podium. Thank you very much.
I now echo what Jeff Golden has just said. I think it's been a marvellous conference, but it has required some stamina, I would imagine, for the listeners. And I think what I liked about all the talks, at least those in which I was in the audience, they were easy to follow, but at the same time interesting and comprehensive. That really is the golden aim of the advocate. We went back not only through the legislative history of Trinidad and Tobago and the development of its common law going back to 1498 and the Spanish law, but back even further than the English law through the Bill of Rights in 1689, Magna Carta in 1214, and even the Norman Conquest in 1066. But I would like to go back one stage further to about 800 BC, to something written, or sung more likely, by the ancient Greek poet Homer in the Iliad, because it seems particularly apposite to what we heard today. Now, when I was a student, I was a classicist, so I had to read Homer in ancient Greek. And I always remember reading this very banal line and thinking, well, I could have written that too, but it's stuck in my mind. And basically what he said was this: there are many things that can be said on both sides of the argument. And I thought to myself, well, I could have written that, but But anyway, I think today showed the truth of what Homer said. For instance, in Papinet, we heard of the diametrically opposed views of Lord Dyson and Lord Brown on the law of legitimate expectation. Basically, Lord Brown said, I don't know what you're talking about. And again, how those two same judges locked horns on the question of the fair-minded observer in the Belize marketplace. Again, Lord Brown loses and says to Lord Dyson, I don't understand how you can possibly come to that conclusion. And he would have said it more or less just like that. And then again, in Dumas, we heard how the High Court and the Court of Appeal in Trinidad and Tobago came to diametrically opposed views on locus standi. We heard how, from Rob Strang, in the Belmarsh case, Lord Hoffman disagreed on whether there was sufficient justification for detention without charge from all the other law lords. And Lord Hoffman seems to have made a speciality of dissent because he was also the dissenting judge in the two Bahamian cases we heard about from Tom Rowe. One where he was in the minority of 3-2 when he lost then when the same case comes back but with different people, he's again in the minority trying to stick up for the original majority decision in the same case. Astonishing stuff. Again, I might say that was a case I managed to lose. We heard how in what one would have thought were fairly clear cases, the Privy Council took fundamentally different views from both courts below, both in the case involving Sir George Mitchell and in the St Kitts election. We also heard in the Law of Damages how the Privy Council shamelessly, as it seemed to me, chopped and changed on the burden of proof on the question of mitigation of loss. And indeed, more generally, the great difficulties facing the courts in Trinidad in assessing general damages in personal injury cases. And how, finally, on the problem of vindicatory damages, we heard what the problems are. I think, reading between the lines, what was being said by Hafsah and Rowan was, no one quite understands Ramesh and my case of Alain 40. It may just be the way we managed to argue it. But it's a very difficult area, the whole notion of vindicatory damages, because I've never quite understood in real life what the difference is between vindicatory damages and exemplary damages. And I seem to remember in Alain 40, Lord Wilson saying, what is the difference? And we said, we don't know. And more generally, we heard also, how should we change things? Surely, now, and I think it's especially interesting talk from John Jeremie's, surely now is the time for the courts to have a more interventionist role in investigating what happens in Parliament. Now that, of course, is a revolutionary notion, a very important notion, but one can see possibly the beginnings of some movement in that direction in the Toussaint case and indeed in the St Kitts election case. And then we heard from Sir Fenton Ramsahoye, if I may say, magisterial speech in identifying what improvements do need to be made in certain parts of the administration of justice in the Caribbean. And I, for myself, found it an absolutely gripping speech by a man who knew what he was talking about. And then finally we heard, again, I think a very interesting point from Jeff Golden, the improvements that need to be made in resolving financial disputes. And the simple point made by Jeff Golden was simply this: if you have standard form agreements which are used throughout the financing markets, if a judge makes a wrong decision or a slightly odd decision on that zooms around the markets and there's chaos. And I think Jeff's proposal, which I hope is taken up, that in England we have a specialised financial division, effectively with the Chancery Division, a bit like a patents court, then I think that would be a fine thing. It obviously makes considerable sense. And finally, but not least, we had Tom Rowe's fascinating talk on dissenting judgments. For myself, I am profoundly in favour of them. The obvious disadvantage of judgments by committee is that they're compromises, they lack all character, and the great thing about the dissenting judgments, Tom Rowe mentioned one, but there's a great dissenting judgment in Rudall, the infamous case of Rudall. You read Lord Rogers and Lord Millett's dissent, it is quite something. But the dissenting judgments, really, I think that tradition is a wonderful thing. And I think it does one really important thing, which you never get the impression of from the European judgments, which is a sense of openness. These judges, they're all debating. And that, I think, is how lawyers should be. They should be open and they should debate. All this, I think, therefore shows that a lawyer, any lawyer worth his salt, should never give up on a case where he has at least a reasonable argument. You never quite know. It looks pretty hopeless when you're at first instance and the judge is looking, I don't know what you're talking about, even in the Court of Appeal. But then you suddenly get up to the Supreme Court and they're all on your side all of a sudden. As long as you've got one sensible argument and you keep the focus on that, I think you've always got a chance. Finally, I would like to echo one thing which Fayed Hussein said in the very interesting talks at the end. In the end, this is not a business but a profession, and you're here to serve your client and to do everything you possibly can within the rules to get the right result for him. That, I think, is the one thing all students, all people in the profession must have at the heart of their job. We are in a position of the utmost trust. It is the most miserable thing for most people to have to go to law. The one thing they need to know is they must trust their lawyer, absolutely. We all make mistakes from time to time. That probably doesn't matter. Lord Donaldson once said, I think, the great thing about professional negligence is hardly ever we're normally saved by the law of causation. But that is the most important thing to remember. It doesn't matter too much about the odd mistake. Everyone will make the odd mistake. The main thing is to do the right thing for your client and to be totally straight with them. I hope you've enjoyed today's conference as much as we all have. Thank you very much.
Peter.
Sorry.
I do not dissent from anything Peter just said. I would like to thank Mr. Peter Knox and Three Hair Court for the time they have taken to come here and to visit us in Trinidad and Tobago to be part of this project. I am sure that Trinidad and Tobago has benefited, and in particular, lawyers, judges, and law students who are going to be the future lawyers of Trinidad and Tobago and in the Caribbean. I think that there are many challenges facing the legal profession, and what we are trying to do with this group is to try to give more information to lawyers and trying to make the public also understand law better. And I think if we have succeeded in doing 1 inch of that today by this project, we would have succeeded in our mission. I want to say one thing about a point which has been raised in the question series, and that has to do with delayed judgments. And I agree with Justice Govind that the bar in Trinidad and Tobago is too timid. The bar in Trinidad and Tobago, to a great extent, is subservient and sometimes sycophantic. The legal profession, the bar, has to be strong, fearless, and independent. And the time has come in Trinidad and Tobago for the bar to challenge matters which are happening, problems which are happening, even within the judiciary. The administration of justice is one of the most important aspects which have to deliver justice to individuals in Trinidad and Tobago. And one has to face facts. In the Court of Appeal, there's a matter which is pending for over 5 years. Mr. Hussain knows about it. Am I correct, Mr. Hussain? Over 5 years. And I have been studying what to do. Letters have been written, statements have been made, the judgments have been given in 6 months, and no response, and if there's a response, no action. So I have thought about something that I'm going to do. I'm going to file a motion before the Court of Appeal to go before the same judges, and I'm saying that the inherent jurisdiction of the court demands that you tell us, when are you going to give judgment? When are you going to make the order? Because it would be an abuse of process if this thing continued. And delayed judgments in Trinidad and Tobago can be a major problem for people. As Mr. Hussain has said, people have died without getting their judgments. And I think that the Law Association of Trinidad and Tobago should consider taking up some of the issues which are facing the public with respect to pro bono work for lawyers. Lawyers must give something to the community. And we should, like in some countries, give some of our time, make it mandatory to give some of our time and skill to members of the public in taking up some of these matters. So I know you have had a long day. We have all had a long day. But I would like to thank everyone who participated in making this possible. I would again like to thank the Hugh Wooding Law School, and can I call upon Mr. Bissessa to do the vote of thanks?
Thank you very much, gentlemen. On behalf of the Trinidad and Tobago Legal Network, I wish to express our gratitude, our profound gratitude, to the principal and faculty of the Hugh Wooding Law School for inviting us into their facilities and making them available to us. I'm sure you'll agree with me, it's the appropriate environment. It is a wonderfully closed, it's a lovely environment for exactly what we are planning to, what we are doing. I wish also to thank the panelists for firstly agreeing to attend and be panelists, and secondly, and more importantly, offering their contributions so frankly and unafraid. And for those reasons, I think they deserve our gratitude. Of course, our thanks go to you, the audience, whose contributions themselves are not unnoted. We, of course, have audiences outside of this room, and I wish to also thank them for their attendance and no doubt their enthusiasm for being part of these professions. I wish to thank the various contributors to the TTLN, whose financial and other support has made this particular event possible. I wish to express our gratitude to them for their loyalty and, in fact, their faith in us, because this is, in fact, our inaugural event. I also wish to thank our event planner, Ms. Laverne Henry, for her spirited and sterling work in putting this event together in a very short time frame. We are very grateful for her expertise and her professionalism, and we've all learned a lot from her. Ladies and gentlemen, in assessing how effective the TTLN has been in performing its very first function, I'm reminded, as I was waiting for my opportunity to speak with you, that our mandate is really twofold, as identified in the banner, which is very proudly displayed: promoting legal education and scholarly legal debate. I will leave up to you to assess whether or not we've achieved our mandate and whether or not you wish to be part of us in the future. So once more, thank you so much for your presence and for your enthusiastic participation in this hour debate, and I wish you well for the rest of the afternoon. Thank you very much.